Good morning, everyone. We're going to go ahead and get started. I want to thank everybody for coming out today for an important conversation. My name is Rob Vischer. I'm the dean here at St. Thomas Law School, and we are excited to convene this conversation. I'm grateful to Megan and all the student editors of the Law Journal who worked hard putting this together. And I'm also thankful to Mark and Terry Kohler and Greg and Mindy Sisk for their sponsorship of this event, which has made it possible for us to gather. I also want to thank the Law Journal's faculty advisor, Ben Carpenter, and the faculty advisor who was the moving force behind this particular symposium, Greg Sisk. It's not just important for a Catholic law school to be engaged in this conversation about prisoners' rights. I would say it's compulsory for a Catholic law school to be engaged in this conversation. Let me briefly explain. Here's what Pope Francis has to say on this topic. He says, the mission of jurists cannot be other than that of limiting and containing what he calls society's unhealthy tendencies to mistreat prisoners and those accused of crimes. He says, quote, it is a difficult task in times when many judges and employees in the criminal justice system must perform their work under the pressure of the mass media, of certain unscrupulous politicians, and of the vengeful trend which permeates society. So, he says, we must guarantee that states are not allowed to subordinate respect for the dignity of the human person to any other purpose, even should it serve some sort of social utility. Respect for human dignity must serve not only to limit arbitrariness and the excesses of the agents of the state, but act as a guiding criterion for the prosecution and punishment of those actions which represent the most serious attacks against the dignity and integrity of the human person. When he was visiting one prison in particular, Pope Francis told inmates, quote, we all make mistakes in life, and we all must ask forgiveness and make a journey of rehabilitation so we don't make them again. Some people, he said, are able to do this in their own homes and in their own professions. Others, like you, do this in a prison. And then he went on, but all of us, anyone who says they do not need to go through a process of rehabilitation is a liar. Now, wait, you're tempted to say Pope Francis, isn't he sort of the liberal Pope? Of course, he talks about prisoners' rights. Okay, then how about Pope Benedict, who can hardly be dismissed as a liberal Pope? Here's what Pope Benedict has to say about prisoners. I was in prison and you visited me. These are the words of the final judgment according to Matthew, the Lord's words in which he identifies himself with those in prison. Wherever someone is hungry, a stranger, sick, or in prison, there is Christ himself who awaits our visit and our assistance. Pope Benedict continuing, the church has always considered visiting the imprisoned as one of the corporal acts of mercy, but this, in order to be complete, means fully accepting the prisoner, making space for him in our time, in our home, in our friendships, and in our laws. Making space for the prisoner in our laws. What does this mean as lawyers presented with the stark reality of mass incarceration? Can we look past the statistics and see the person? To the students gathered here today especially, the conversation about prisoners' rights is at the heart of what it means to integrate faith and reason. It's also at the heart of what it means to be a lawyer. We are so glad you could all join us for this conversation. We're so thankful to our distinguished guests and speakers and experts to assist us in this conversation. Welcome. I hope you all enjoy and that your minds and hearts are stretched by the day. And I will turn it over to Professor Sisk. Thanks for being here.
Good morning. It's a beautiful morning, not as sunny as it was yesterday. So those of you who arrived yesterday and were thinking, see, Minneapolis really is a spring tourist destination, maybe a little disappointed by the weather today. Well, it just so happens that I was watching an old episode of Seinfeld, and he was talking about how much we humans love water. We want to be at the ocean. We want to be at the lake. We want to be on the beach. We love water so much we carry it with us everywhere we go, water bottles. We fill our lives with water. We love water. unless it's coming from the sky. And then, oh, did you feel something? I think I felt something. Oh no, now it's raining. So you're seeing why Seinfeld and I, although the same age, he went on to become a comedian and I chose a different path in life. But speaking about water, we have plenty of water for you to stay hydrated, drink and food outside. But it's important that you understand, well, maybe we can wink at water coming into the courtroom. Please do not bring other food and so on into the courtroom. And talking about the courtroom, that's a good point in which I should talk about our pandemic protocols. I know we're all tired of COVID. It's not clear that COVID is tired of us. And so as we want to be respectful of everyone that is here today. We have people from all corners of the country that have come, some traveling for the first time since the pandemic. We have vulnerable people. So please follow the protocols that we are still observing here, which are please wear a mask when you're here in the courtroom. In the audience, you can take off your mask, of course, to eat and drink, and most of that will occur out in the atrium. If you are on a panel, you may, of course, take off the mask to speak. In fact, we encourage that so you can be heard. If you're sitting up on the panel, we leave it to your option as to whether you wish to wear a mask when you're not speaking. By the way, this mask expectation applies to those of you who are currently in room 446 watching this on video as well. We are delighted that we had an over-registration and had to create an overflow room. And that room is 446. And the person in charge of that room is our wonderful incoming editor-in-chief of the Law Journal. The Law Journal made a tremendously wonderful choice in selecting Sean Smallwood, who is up in room 446. I hope he's hearing me and will stand and wave to all of you up there. You are included in our program as well. So if you do have questions, and we will have lots of question and answer opportunities, please write your questions down and give them to Sean, and he will see that they are brought on down here to us. And as long as I'm talking about the Law Journal, I want to thank all of the Law Journal students, many of whom have been picking people up at the airport and will taking people back to the airport and have played major roles behind the scenes. I can't individually recognize all of them, but in addition to Sean Smallwood, Madison Fernandez is the current editor-in-chief of the Law Journal. And I do want to give some special thanks to a small number of people, not because only a small number deserve thanks, but you don't want to continue to listen to me speak all morning. Angela Dezek is not here with us. She is on a family road trip today, but she is the one who made much of what you are seeing today possible, making the arrangements for the catering, et cetera. Xander Moser is right here with us, standing right over there. He has just been fantastic in every work I've done with him on technology. He's in charge of all the technology for today. And I also want to especially thank Megan Massey, who has, I know the participants have been in contact with regularly. She has been working directly with me throughout the past year in preparing for this. She's the Symposium editor. So continue to stay in touch with Megan. She will be graduating soon. And as you'll hear later this afternoon, she has just returned a week ago today from San Francisco, where she was arguing before the Ninth Circuit in a prisoner rights case. And so we wish you all a wonderful day. And speaking about wishes, everyone who puts together a symposium puts together a wish list of the people that they would like to invite to that symposium. And then as the people on the wish list say no, you go to your second choice and then on to your third choice. We didn't do that here. Everyone that is here today are the ones on our wish list. And we are just so delighted that all of you are here with us. I'm only going to introduce one of you right now, but you will all be introduced later on. And I point to the program. Make sure you have the program with you so you can follow what's going to happen today, including the bios of each of the presenters. Professor Sharon Dolvich is the director of the UCLA Prison Law and Policy Program, and she teaches courses on criminal law, the constitutional law of prisons. She is the person on the law of prison conditions. And you can read the rest of her bio, but I want to highlight one other thing before she comes to the podium. She has written a piece which will shortly be out in the Harvard Law Review Forum about what she calls the coherence of prison law. It's responding to another article that said prison law is incoherent, and of course there's truth in that. But the coherence that she finds, and that many of us have experienced, is a dispositional favoritism for the state and for correctional facilities. And I really encourage you to, when this article comes out, to find it and to read it. And with that, I'll turn it over to our keynote speaker, Professor Dolvich.
Thank you, Professor Sis, for that kind introduction.
Grab this.
Oh, yeah. Thanks. I want to start by thanking the organizers for inviting me to speak to you today. It's an honor to be here. And I also want to thank the Dean for his remarks. As you'll see, what he had to say and what I'm going to say are very much in tune. So the topic of this gathering is prisoner rights and prison conditions. And our purpose is to celebrate the 10th anniversary of the University of St. Thomas Appellate Clinic, which has long focused on representing people in prison under Professor Sisk's guidance. And so given the occasion, it seemed fitting to consider why advocates for the incarcerated do this work. And I'm not thinking here about personal motivation. After 2 decades of being connected with the prisoners advocates community, it's clear to me that those who do this work are driven by a profound sense of personal mission, and that they derive deep satisfaction from advocating on behalf of a group that society is so often ready to regard as undeserving of humane treatment. So this sense of meaning and purpose answers the question of why on a personal level people commit to doing this work and why so many of them stick with it for decades. But today, when I ask why do this work, I'm asking from a different angle. The question is, what exactly is being accomplished by those who devote themselves to advocating for the incarcerated? And my purpose in asking this question is to underscore just how valuable and necessary this work is, despite how unfriendly the federal courts are to claims brought from prison. Right, as we all know, even when their constitutional claims are strong on the merits, incarcerated litigants will lose most of the time. So we shouldn't be surprised if those who do this work might sometimes wonder, what good after all am I doing? So I decided to use this opportunity to make the case for the indispensability of legal advocacy on behalf of people in custody, notwithstanding the state of play in the courts. My goal is to make clear just how vital this work is for incarcerated people and their communities, for society as a whole, and even, I will argue, for enhancing the promise of constitutional democracy itself. So I'll start with just a few words about the legal landscape and about what it is about this context that makes it so hard in most cases for incarcerated plaintiffs to prevail. So as many of you know, the legal doctrine governing the rights of the incarcerated is stacked mile high against the plaintiffs. For one thing, there are innumerable procedural obstacles to bringing conditions cases, including many for which we have the PLRA to thank. The exhaustion requirement, the physical injury requirement, the 3 strikes provision for IFP petitions, the drastic limits on attorney's fees, and so on. And then there are the doctrines governing the merits, which are by design extremely defendant-friendly and which offer plaintiffs only the narrowest of pathways to success. So between Farmer's deliberate indifference standard for 8th Amendment prison conditions claims, Whitley's maliciously and sadistically standard for 8th Amendment excessive force claims, and the almost comically deferential standard of review established by Turner versus Safley, which governs almost every other constitutional claims that prisoners might bring. When you add this all up, it's a foregone conclusion that incarcerated plaintiffs will lose most of their claims most of the time. Now, that isn't to say that plaintiffs never prevail. It's just that the stars really need to align. So when you have dedicated and adept lawyers, which by the way, is one reason this work is so urgent, when you have dedicated and adept lawyers, and when the treatment being challenged is glaringly problematic, And when the state's justifications are thin or nonsensical, then incarcerated plaintiffs have a chance of success. But even in cases like this, prisoners might still lose for a simple reason, which is that no matter how brutal or inhumane the conditions plaintiffs face, they will never win in court unless a court is open to taking their arguments seriously and engaging fairly and even-handedly on the merits. And unfortunately, in the current judicial environment, this condition of courts being open to even-handed treatment of plaintiffs' evidence and arguments can't be taken for granted in the prison context. Right? We all know by now that by the end of the Trump presidency, fully 25% of sitting federal judges are Trump appointees, which doesn't mean that Trump judges will never find for incarcerated plaintiffs, but we would be fooling ourselves if we said it didn't matter. And of course, it isn't as if before Trump, all federal judges were highly sympathetic to the claims of incarcerated plaintiffs. And then there's the Supreme Court, which has the ultimate authority to set the terms, both for prisoners' access to the courts and the potential for their success on the merits. And despite what I personally consider to be the wonderful addition of Justice Ketanji Brown Jackson, Justice Jackson will still be very much in the minority, right? You don't need me to tell you that right now on the Supreme Court, there is a very young, very conservative majority, which means that if there are going to be developments in the law governing the rights of incarcerated people coming out of the court in the coming decades, these developments are likely only to narrow still further the ability of people in custody to challenge their treatment by the state. In other words, as hard as it is currently for incarcerated plaintiffs to get into federal court and to prevail on the merits once they get there, it may be about to get even harder. So in light of all this, a person might well ask, what's the point, right? What good do lawyers do, incarcerated people? And in the time that remains, I want to try to answer this question. What good do lawyers for the incarcerated do? My claim is they do a lot of good. In fact, my thesis is that in the current legal and political environment, the work done by legal advocates is vital. It's vital for the clients, who without legal advocates would be even more isolated and alone, and so even more vulnerable to abuse and neglect than they currently are. It's vital for society, for which lawyers provide a crucial channel of information about what is going on in prison, thereby keeping the polity informed about what are, after all, public institutions. And finally, the work lawyers do on behalf of the incarcerated is crucial to what we might call, in somewhat grandiose terms, the prospect of forming a more perfect union. In other words, at this moment in the development of the carceral state, lawyering for the incarcerated may be the primary mechanism we have to move our carceral system closer to consistency with the basic normative commitments of a constitutional democracy. So I was actually thinking of calling this talk, the indispensable work prisoners' rights lawyers do in curtailing abuse, bearing witness, and ultimately preserving democracy. Thought that might be a little much, so I dialed it back. But that is really my point. So to make this case, I first need to say a little about the foundational moral values of any constitutional democracy, and about the way that despite these normative foundations, the distribution of political authority necessary if society is to function will inevitably put vulnerable people at risk of abuse by state officials. And my overall claim can be broken down into 4 steps. First, in a well-functioning polity, the moral hazards incarceration creates would be anticipated and effective institutional safeguards would exist to curtail the abuse of state power. In other words, in a well-functioning polity, we would create institutional mechanisms for keeping official abuses in check. Second, that in the American system, when it comes to prison, any such institutional safeguards that might exist in theory have largely failed in practice. Third, that as a consequence of this failure, there exists a dangerous regulatory vacuum. And fourth, and finally, that legal advocates working on behalf of those in prison help to fill this regulatory vacuum, and through their work, provide a crucial measure of the recognition, respect, and protection that a morally defensible system would ensure those living behind bars. Now, it is crucial to underscore, and I do this emphatically, it's crucial to underscore that lawyers do not do this work alone. Every successful effort made on behalf of people living behind bars is always a collaborative effort among several crucial players, starting with the clients and other incarcerated people, and also including the families and loved ones of people inside, along with activists, grassroots advocacy organizations, and other allies. So I say again, lawyers and other legal advocates, the litigation specialists, the investigators, the monitors do not do this alone. And they couldn't do it alone even if they tried, because if the work is to be meaningful, any action is going to require an understanding of the impact on those most directly affected. as well as a range of necessary skills, only some of which are contributed by lawyers. However, in keeping with the theme of this gathering, and in honor of the appellate clinic we are here to celebrate, I have chosen to focus here on the particular and considerable contributions made by legal advocates. All stakeholders do vital work in this fight, but it is also true that in the United States, virtually all power and thus the promise of change runs through courts and legislatures, in other words, through the law, which means that when it comes to advocating on behalf of society's most disadvantaged members, including the incarcerated, lawyers and legal advocates play an indispensable role, and it is that role that I want to focus on here. Okay, so let me step back and lay out what I hope is a simple conceptual framework for understanding the normative foundations of American political institutions, the way state power operates, and the threat that is inevitably posed to the moral character of state action by the exercise of this power. And let me start with the normative foundations. So here, all I can really do is stipulate the moral commitments embodied in our founding documents and rhetorically invoked at key moments in national life. I'm talking here about what I've elsewhere called the baseline liberal democratic values: limited government, the primacy and sovereignty of the individual, and individual liberty, dignity, and bodily integrity. And to this list, we could add basic constitutional commitments like equal protection, due process, and the prohibition on cruel and unusual punishment. But it's worth noting that to name these constitutional provisions alongside the baseline liberal democratic values may actually be redundant, since these provisions are really just constitutional manifestations of the underlying values that I just listed. In other words, any society committed to the baseline liberal democratic values would necessarily commit to some version of these basic constitutional provisions. And I should say, by the way, that I include the United States here. We count as such a society, even though our commitment to these basic values is more rhetorical than real. Okay, so back to our conceptual framework. We've got the baseline values. Now we need to ask, how does a society that is committed to these values put them into practice? Every society needs state institutions in order to function. But right away, we've got a problem because the state is not a natural person, which means the state can't act on its own. It can only act through the individuals we authorize to act on the state's behalf. And the problem is that anytime we delegate political authority, what we are doing is delegating to inevitably flawed human beings power that can be readily abused. We are, in other words, opening the door to what the great political theorist Judith Sklar called public cruelty, or what we might also call official cruelty. And this is the cruelty Sklar teaches that is made possible by differences in public power. In other words, the same political arrangements that make political society possible also create the conditions for profound abuses by public officials against vulnerable individuals. Now, obviously, there is substantial value in preventing official cruelty. Speaking for myself, and I'm guessing I'm speaking for many of you, the constitutional prohibition on cruel and unusual punishment is the moral North Star that guides my work. And of course, Sklar also condemns acts of cruelty. But for her, the prevention of public cruelty is not only important for its own sake. It's also vital because for her, individual liberty is crucial to the liberal project. And as she sees it, the single biggest obstacle to personal freedom is not the exercise of public cruelty itself, but the fear of such cruelty. So as she puts it, systematic fear is the condition that makes freedom impossible, and it is aroused by the expectation of institutionalized cruelty as by nothing else. So inevitably, as she says, a minimal level of fear is implied in any system of law. But there is a particular sort of fear, which for Sklar is most destructive of the moral foundations of a liberal democracy. And that is, as she calls it, the fear created by arbitrary and unlicensed acts of force and by habitual and pervasive acts of cruelty and torture performed by military, paramilitary, and police agents. In other words, this is the fear that arises from knowing that one is at the mercy of public officials who feel themselves free to harass, to intimidate, to use violence, and even to kill with legal impunity because no one with any power is going to stop them. So for Sklar, it is this fear that, like nothing else, corrodes the moral foundations of liberal democracy. Now, for her, as I've said, the paramount value is ensuring that people can live their lives according to their own lights. But as she recognizes, and I have to say these are my words, not her words, as she recognizes, when it comes to the baseline values of constitutional democracy, it's not like pick and mix at a candy store where you can just grab your favorites. What I've called the baseline liberal democratic values cannot be sold separately. If you want limited government and individual freedom, you also need the conditions for individual dignity, self-respect, and what Sklar calls moral courage, self-reliance, and the stubbornness to assert oneself effectively. Partly because these qualities are what we need if we are to manifest our own preferences and our own personal vision of the good life, and partly because unless citizens have these qualities, they will be unable, as Sklar says, to act individually and in associations to protest and block any signs of governmental illegality and abuse. In other words, we need these qualities to give us the fortitude to stand up to the acts of official cruelty that make it impossible for us to function as moral agents. Okay, so to sum up, Sklar's work highlights two profound threats to the possibility of a free and democratic society: the cruelty inherent in what she calls extra-legal, secret, and unauthorized acts by public agents or their deputies, and the way the fear instilled by these arrangements corrodes the dignity, self-respect, and sense of personal security that are the requisites of full moral personhood. And she teaches that the preservation of liberal democracy, always a work in progress, requires that we strive to minimize as much as possible the conditions that promote these damaging dynamics. So I hope it's obvious why these ideas are relevant for those of us here today. A well-designed government would recognize the urgency of constraining official cruelty against people in custody. It would create effective regulatory and oversight mechanisms to discipline abuses of carceral power so that people in prison might live without fear and instead inhabit spaces that promote dignity and self-respect. Unfortunately, as you are all well aware, our political system has failed utterly to establish effective mechanisms for disciplining carceral power. So that brings us to an obvious question. What do we do about this? And this, at long last, is where the lawyers come in. Now, we need to be careful not to overstate the extent to which lawyers and their allies can right this ship. However, I want to suggest that despite the obstacles and despite the limits on the relief they can secure for their clients in court, lawyers for the incarcerated do vital work in helping to rebalance the moral orientation of the system and to promote the basic values that are in theory supposed to guide our political institutions. They do so in innumerable ways, but perhaps most centrally by puncturing the secrecy that fosters official cruelty, and also by restoring to people in custody some measure of the dignity, self-respect, and moral courage that together defeat the fear of official abuse, which, as Sklar teaches, is so deeply debilitating of personal agency and freedom. So in the time that I have left, I'd like to catalog just a few of the ways lawyers strengthen the public values that ought to guide the carceral system even when they do not win in court. Now, I emphasize that I don't mean this list to be comprehensive, but only illustrative. And I'm certain that many of you will have examples to add, and I look forward to expanding the conversation to include them. So let me start with what may be the most obvious point. By getting access to prisons, legal advocates serve a vital transparency function, bringing light to the dark corners where, absent external scrutiny, correctional officers can carry out unchecked the acts of public cruelty of the sort Sklar so strongly condemns. If prisons are sites of official cruelty, it is because there is so little external scrutiny of what goes on inside. As we'll be hearing more from Andrea Armstrong later today, what happens in prisons and jails remains obscure thanks to the culture of secrecy that corrections administrators have been allowed to cultivate. It can be easy to forget that carceral facilities are public institutions. And lawyers constitute perhaps the only exception to what is otherwise a virtually absolute power of secrecy and exclusion that prison officials enjoy. Even members of the media, through whose work, as Justice Powell recognized, citizens receive the free flow of information and ideas essential to intelligent self-government. Even members of the media have no right of access to prisons and often have to struggle to get inside. But when lawyers file complaints that state a cause of action, the right of discovery allows them, among other things, to get access to internal records and documents and to conduct interviews with prison residents. And when cases succeed on the merits, which many still do in spite of judicial hostility because of good lawyering, when cases succeed, lawyers have the right to monitor compliance with any court orders, which gives them access to the facilities themselves. Yes, there are always limits to what legal advocates can see inside, no matter how diligently they perform their monitoring function. And yes, implementing court-ordered remedies is always a process and even a fight. But even if they can't fix everything, lawyers are getting inside and seeing all kinds of things that would never otherwise be exposed. In this way, even apart from the improvements that they achieve, and they do achieve improvements, legal advocates serve at least three important functions. They provide a channel of accountability that wouldn't otherwise exist. They serve a disciplining function for correctional staff who know that they are being observed, and they assure people incarcerated in the facility that they have not been forgotten and that there are people who are paying attention and advocating on their behalf. Lawyers also provide a conduit for information to the public at large about what happens behind the walls. Despite judicial hostility to prisoner suits, it is at least beyond question that people in prison retain their status as legal subjects with basic rights. And this recognition gives lawyers privileged access to people inside and thus to firsthand accounts of what is actually happening on the ground. And this access allows lawyers to convey to society as a whole the reality of what people are experiencing in prison. And actually, just yesterday, we were reminded of this really important power that lawyers have to expose the failures and abuses, that lead to cruelty and abuse inside carceral facilities. And I'm talking about the DOJ having just issued its remarkable findings letter detailing horrific conditions inside Parchment Farm Prison in Mississippi, right? So that is a remarkable example of what I'm talking about here. But more prosaically, lawyers provide this vital information channel even just by filing legal complaints describing the facts on the ground. Now, it's true that legally speaking, facts and complaints are only allegations, but once those facts appear in legal documents, they have sufficient heft and veracity to be taken seriously by journalists, among others. Now, it's certainly the case that people in prison should be able to convey their own firsthand accounts of what goes on inside without having to have those experiences filtered through their lawyers. And happily, there are actually now many efforts underway to allow people in prison to tell their stories directly, as for example, with the Marshall Project's Fabulous Life Inside series. But it is still true that these channels are limited. And in a polity that so often regulates through litigation, it is just true that legal advocates will occupy a culturally privileged position that makes them especially effective conduits for information about what is happening inside prisons and jails. Sometimes it's as simple as lawyers serving as a trusted information source for people with the power to make a difference, a role that lawyers are able to play especially well when they cultivate ongoing relationships with their clients. As for example, what happened in New York City in January 2019 during the ice-cold polar vortex, when the boiler broke in a federal jail in Brooklyn, leaving people inside freezing and in darkness. So when this happened, the New York Times, got a tip about what was happening, but they were getting the runaround from the BOP, who said the housing units are not being affected. So they reached out to Betsy Ginsburg, a longtime prisoners' rights lawyer in New York, who now runs the Civil Rights and Prisoners' Rights Clinic at Cardozo Law School. And Betsy, who was on top of what was going on, was immediately able to give lawyers and reporters information about what was happening on the ground. And she was also able to connect them to Deirdre Von Dornum, the chief federal defender of the Eastern District, who at the time, of course, had hundreds of clients in the jail. And Von Dornum, in turn, was able to connect the Times to some of the people who were freezing inside. So the point I mean to emphasize here is the way lawyers for the incarcerated occupy a privileged position which allows them to shine a spotlight on a hidden world. And they're only able to perform this role by remaining connected and trusted by their clients. And even if the practical payoff is limited, the efforts of lawyers to call attention to the experience of their clients has a dignitary effect. It tells people inside locked facilities that they have not been abandoned and that there are people prepared to speak up for them, to fight for them, and to call prison officials to account. Here's another dimension of what prisoners' rights lawyers do. They play a watchdog role. By their presence, they remind corrections officials that there are people paying attention who are ready to scrutinize their conditions and challenge abuses. Now, as we've seen, constitutional litigation doesn't always succeed, but it is hard to imagine that the threat of lawsuits does not check abuses that might occur if custody staff believed no one was watching. And importantly, this watchdog role extends beyond constitutional violations. A key function that lawyers perform, which helps to rebalance the moral orientation of the system, is preventing the economic exploitation of people in custody. Right? As we all know, the lure of private profit brings all kinds of players into the carceral market, and many stakeholders, I should say, including very much Paul Wright and his Prison Legal News and HRDC team, many stakeholders work hard to prevent the commodification of people in custody. So the fight against price gouging, first by phone companies and now by email and video call providers, is just one example, and the FCC regulations capping phone rates was a victory shared by many stakeholders and advocates. But in some cases, lawyers have to take the lead. For example, for years, the Florida Department of Corrections operated a program allowing people in Florida prison to buy digital music they could listen to on MP3 players, with the Florida DOC taking a cut for each song sold. So the program was extremely popular. Through it, people in Florida bought and paid for almost 4 million songs. Then out of the blue, the Florida Department of Corrections canceled the original contract and entered into a new contract with a new provider, whereupon all the music, 4 million songs, that people had already purchased disappeared, and they were told if they wanted those songs, they'd have to buy them again. In response, lawyers at the Florida Justice Institute, led by Dante Trevisani and Ray Tassef, filed a lawsuit titled Demler versus Inch. The plaintiff class in Demler comprised all those who had purchased more than 75 songs, which by my rough count of the settlement agreement amounted to over 11,000 people, almost 12% of the state's prison population. So there were millions of dollars at stake here. And so unsurprisingly, the DOC fought hard, but ultimately the plaintiffs prevailed, and the court ordered the state to provide close to 4 million song credits for the plaintiff class, plus 25 song credits each for everyone who had originally bought music through the program, whether or not they qualified as a class member. I think I'm dehydrated from the plane. So I hope it's clear that this case was not just about the music. It was about whether corrections officials can treat people in prison as profit sources with zero regard for their humanity or their right to be treated fairly. In other words, turns out, you'd be surprised to hear, that it's just a short step from Beyonce to Judith Sklar. Sklar, you will remember, underscores the urgent need in a constitutional democracy to constrain both public cruelty and the fear it instills in those vulnerable to official abuse. Achieving this aim demands efforts to ensure that people in custody retain some measure of dignity and self-respect, along with the moral courage to insist that their humanity be recognized. By bringing this litigation, the Demler advocates affirmed to the plaintiffs that they are legal subjects with rights and moral beings who deserve to be treated fairly and with respect. And in their turn, the plaintiffs joined the fight to help vindicate their rights. It is no exaggeration to construe the Demler litigation as powerfully democracy enhancing. And it bears emphasizing that the moral recognition lawsuits can provide does not depend on winning. To the contrary, just bringing cases can affirm the dignity and self-respect of people living behind bars, regardless of the outcome. So following Jules Lobel, we might think of this as a species of winning by losing. Example, Alan Mills, legendary prisoners' rights lawyer in Illinois, recently shared a story. He told me he once had a use of force case that he was sure was a slam dunk. Went to trial, Alan put on what he thought was a bulletproof case. And it took the jury all of 30 minutes to find against his client. So Alan is outraged, but to his surprise, his client is delighted. And Alan can't understand it, right? How can his client be happy? They just lost a case they should have won. As he tells it, and here I'm obviously paraphrasing the paraphrase, but as he tells it, the client basically said, look, you don't get it. I've been in the system for decades and I know the drill. I know there is no justice or fairness in prison. But in court, he said, I got to see you cross-examine the officers, question them, poke holes in their stories in a way I could never do inside. And I got to tell my own story in my own way in front of a judge and a jury in this beautiful courtroom. And the judge was listening to me and the jury was listening to me. And the other side had to listen to me whether they liked it or not. So Alan's point was that for the client, this alone was a big win. Now, as he says, it isn't as if this one experience completely evens the playing field. The power imbalance is still enormous. But in court, that balance is so much more equalized than it is in prison, which means that just being a party to litigation can make people feel seen and heard and affirmed in a way that never happens in prison. And I heard something similar from Mercedes Montagnes, who represents lawyers or people incarcerated on Louisiana's death row. So Mercedes shared with me something she'd heard from several of her clients and their families, which was that their involvement with the litigation challenging conditions on Louisiana's death row was the thing they were most proud of in their lives. Now, during this litigation, as it happens in prisons all over the country, many of Mercedes' clients experienced retaliation from staff for participating in the lawsuits. Yet in acts of great courage, they were not deterred, and in fact, their resolve only strengthened. And these accounts only reinforce my point, which is that just by bringing cases, legal advocates afford their clients a measure of moral recognition, which, as Sklar teaches, is a powerful antidote to the fear of official abuse that inhibits a person's sense of agency and self-respect. Now, obviously, the personal agency of people in prison is by definition drastically curtailed by virtue of their incarceration. But it is also true that people make meaning in custody. Within the constraints of their incarceration, they can, to a greater or lesser degree, be agents of their own situation. And the more one feels the sense of dignity and self-respect that lends moral courage, the more empowered and less fearful one will be, and the broader the scope for personal agency one will experience, even though they are locked up. Now, there are many other things lawyers do that promote these effects, which I haven't had time to mention here. A few quick examples. Legal advocates create self-help legal manuals so people inside can advocate for themselves, like Professor Sisk. They supervise students in clinical settings, which has the wonderful cumulative effect of expanding the number of people inside receiving legal representation, training the next generation of advocates for the incarcerated, and exposing young people to the realities of the carceral system and the humanity of the people trapped inside. At the micro level, legal advocates hold prison officials to account as when they do direct advocacy who cannot get the institution to listen to their valid concerns. And at the macro level, they can force the polity to reckon with the continued existence of those in prison, as when the lawyers at Leaf Cabraser, along with the Equal Justice Society, sued the IRS and the Treasury Department for unlawfully withholding CARES Act stimulus payments to 1.5 million people in prison. Now, again, this list is only partial. I know there will be many other examples to add. Now, there is, I should say, no denying that for all the good lawyers do and that all stakeholders do who work so tirelessly on behalf of people in prison, it is not even close to enough to bring contemporary carceral practice in line with the baseline values reflected in our founding documents. But each of us can only do what we can do. And my message is that by advocating on behalf of people in custody, by filing the cases, by giving voice to those inside, and also just by being present, demanding access, bearing witness, and broadcasting what they see, legal advocates are increasing the ability of people in custody to live free from fear, and thereby expanding the space in which the core values of a constitutional democracy are able, if not to fully flourish, then at least to take root, which in a carceral environment is no small thing. And for this, legal advocates for the incarcerated should be celebrated and rightfully proud. Thank you.
So as is usual for these programs, we started a little bit late, but we have built in some time in the schedule to accommodate for that. So I do want to invite some questions. We'll take at least 10 minutes, 10 to 15 minutes for that. And the next panel will start just a little bit late. If you have questions here in this room, Megan will pass the microphone around. If you have questions up in room 446, write them down and Sean will bring them down. I understand when you ask a question, you sometimes want to state the premise for what the question is, and that's entirely appropriate. Please, though, at some point, make it in the form of a question. All right, so. Have a question, go ahead and raise your hand.
Thank you so much. I mean, that was just really, from a both normative level as well as a practical level, really helpful. One thing that I'd love for your thoughts about is thinking about the practice of lawyering and the ways in which certain practices don't necessarily require, but encourage or incentivize secrecy, right? So attorney-client confidentiality, when we're engaging in settlement negotiations, right? It's also not the time that we are going to the media to talk about some of the abuses. And so I'd love your reflections on the ways in which the legal profession maybe embodies some secretive incentives and the ways in which we can address those in performing some of the very good functions and public functions that you talked about in promoting constitutional democracy as well as the rights of people incarcerated.
Yeah, it's brilliant. It's a brilliant point and a brilliant question. And I think your intuition is exactly right, that there will be plenty of times when lawyers' first obligation is to the client. This is a phenomenon in public interest lawyering across the board. It's certainly a phenomenon here. There are going to be times when the interests of the client would be strengthened by maintaining secrecy. And I don't know that I have a good answer for that. Except, a few thoughts. One is, to the extent that departments of corrections are offering secrecy in exchange for settlements, then I think a lawyer might communicate to their client the imperative for helping. The imperative for helping everybody, let's say in their facility, not giving into that request. And, my sense is, and, just, speaking to my colleagues who've done this work, I don't represent clients myself, but, my sense is that people who are clients in these cases are motivated by a desire, not just for personal gain, but really to change the system, to call the system to account. And so to some extent, it might be as simple as encouraging the clients to be on board with the enterprise. And, the other thing is, lawyers create classes of clients. And this might be a theme, just thinking kind of as you're describing the practicalities of lawyering, this set of kind of realizations about the normative implications of publicity might be a theme that could be informing the construction of a client class. And lawyers could be communicating with their clients these values right from the beginning, so that at the very end, when they say you can have X dollars and, and as long as you keep it secret and, half X, if you make it public, then at that moment, the client class or the clients may be willing to kind of help reinforce the values. The other thing is, I think we can do a lot more with complaints. I suggested that the client complaints are there for the media to see. And as you all know, reading the complaints is a compendium of all the awfulness that happens behind the walls. And these are public documents. So like I said, the DOCs can always say, well, they're just allegations, but, let's face it, first of all, they're presented in court, lawyers have to swear to their veracity, and they've got all kinds of testimonial evidence supporting what they're saying. So I actually think we could do a lot more just in terms of publicizing the fact foundations for the cases that people bring. I'd be interested to hear if other people have examples of other things lawyers do.
I don't have that, but I do have a question, which is that, in my field, we've seen a real change because people on the other side have taken over prosecutors' offices through elections, and we've got progressive prosecutors, and that, it's been awkward and controversial, as change always is, but still a lot of good has been done. Is there any movement towards that here, of having people with different values take over corrections departments?
Yeah, that's a great question. And I actually think so there are parallels, and I think they're deeper even than the top level that we're talking about. So, Michelle Deitch talks about this, that she's at UT and she's one of the country's leading people on prison oversight. And she points out that a lot of corrections commissioners, people in the top job around the country, are starting to sound a lot more like the progressive prosecutors in their context, ready to make changes and recognize that, that things need to be done differently. So, we could identify some of whom, by the way, came to their views because of efforts by PLO and others to show corrections commissioners around the country that think that there's another way. I'm thinking of the trips to Norway that have been undertaken over the last few years and have really made a difference in some places. A couple things to say about that. One is, just like with progressive prosecutors, it's very tenuous because they cycle in and out of positions, and prosecutors can lose elections, corrections commissioners can be replaced. They can also decide they want to leave. So, the most progressive corrections commissioner in the country, Leanne Birch, who went to Norway with PLO and was transformed in her way of thinking about prisons, really brought a lot of the ideas that she garnered from that effort, that trip to the North Dakota Department of Corrections. And then she left, and now she's working for CoreCivic, MCC, right? MTC. So, private company. She went to work for a private prison company. So that tells me a couple of things. One is you can have people in those positions who are going to be committed to making a difference, and we can't just hang our hat entirely on leadership. The other thing is, the other way that the parallel is actually very profound is that, as we all know, leadership is important, but there's only so much you can do when you're a leader if your line staff are not with you. So, the difficulties Larry Krasner's had in Philadelphia with all the line DAs being against him, and we see it in, Tampa too. One of the biggest obstacles to change is prison line staff who have a commitment to a certain kind of culture. And you can have a leader at the top who is a progressive corrections commissioner, we'll call them. And it's only going to make so much difference if you can't change the culture. And I actually think culture change, which I know is really hard. I know PLO has done a lot of work on that front and other organizations too. Culture change at the line staff level in every institution is going to be the obstacle.
I'm going to go back to the beginning of your presentation about the fundamental values and also again to highlight your piece on coherence of prison law, which I really highly advise people to download when it's available and read.
Any day now.
Any day now, good. So sometimes there's an exception that proves the rule. And the exception that proves the rule here may be free exercise of religion in prison. One of my other sidelights is that I do empirical studies of religious liberty decisions. Prisoners win at a higher rate than other free exercise claims. It's really amazing. And this is not just recently, it's been a long-term thing. And I'm interested in your thoughts about that, but there's a couple of possibilities that occur to me. One is, in contrast with Turner factors and the PLRA, you have federal religious liberty statutes that shift the burden against the government to prove that there is a justifiable basis for the restriction on religion. And the other is that judges who may be more conservative and less in favor of prisoners are very pro-religion in their views. And so you see this not just at the Supreme Court, which is remarkable there too. Most recently, the ministering to a prisoner at execution, but you see it in the lower federal courts too. That the free exercise right seems to work a little bit better. Anyway, your thoughts?
Yeah,
on that?
I mean, there's so much to say about that. So thing number one, I have a fabulous student, Kate Mitchell, who's writing a thesis about the way that having statutory frameworks protecting rights of people in custody actually strengthens the hand of courts, and not just in a kind of formalistic way, but it seems to lead courts to be more willing to more robustly enforce rights for people who are in custody. And so I think one thing to say is having RLUIPA and RFRA, I think, gives that kind of heft. On the other hand, it is perfectly, courts are perfectly able to under-enforce even rights that are statutory, so, as you saw in the piece that I wrote, there's this case Holt versus Hobbs out of Arkansas, where the prison refused to allow the plaintiff to grow a half-inch beard. He wanted to grow a half-inch beard for religious reasons. He really wanted to grow a full beard for religious reasons, but he said he'd compromise at half an inch. And the prison's justification was that you can't grow a beard because you could hide contraband in your beard. And, he got a preliminary injunction. He was in the court arguing his own case at the merits hearing, and the magistrate judge looked at him and said, looking at you, I think it's almost preposterous to think that you could hide contraband in your beard. And then the magistrate judge applied RLUIPA, which has a strict scrutiny standard, and he held for the prison. And he said, we owe deference to the prison, so I'm going to defer to the prison. So then he gives that recommendation to the district judge, which enters agrees. And then it goes to the Eighth Circuit, and a unanimous panel of the Eighth Circuit, under RLUIPA, strict scrutiny standard, half-inch beard contraband, the Eighth Circuit unanimously found for the state. Now, the Supreme Court reversed, but my point in that piece is it took 9 justices. You had to go to the Supreme Court on that case. And so what that tells you is, there's actually no bottom to the extent to which courts who are ready to defer will find for the state in prisoner cases. So it is true that religious freedom is different, I think, for some of the reasons that you suggested. And it's interesting to me what you say about prisoners doing better even than other claimants. And I think that's probably because the court, first of all, the facts are so ridiculous in the prison context. And as soon as you're willing to put the state to its proof, those cases can fall apart pretty quickly. And also in a lot of those cases, there is no good reason. Whereas, there'll be maybe some economic tension in like employment issues with religion, et cetera. There's none of that there. It's also true in other aspects of the rights of incarcerated people that there's no good reason, but that doesn't stop the court. So I think you're right that there's definitely something different about religion.
I'm curious about your thoughts on the prison abolition movement and the messaging surrounding it.
What I say is, I'm always personally leery of labels, because as soon as you say I'm an X, somebody else is going to fill in what they think that means, and they're going to interact with you as if they know what you think when you haven't even said anything about what you think. So when people ask me sort of what do I think, I would say that I am deeply committed to radical decarceration and to a transformation of the way the society responds to people who do wrong against other members of society. And also to expanding the perspective so we get a sense of kind of the reasons why, the structural, institutional, and economic reasons why some people commit crime. And I actually think if that were the political program that we pushed, it would make, it would dramatically change the landscape. As for, so as far as like the messaging part, like the kind of abolition equivalent of defund the police, I don't really know what to say, except that I think what I said a minute ago about the danger of opting to take on labels invites, political manipulation. And that of course comes from people who are not acting, in my view, acting in good faith. They're looking for a reason to delegitimize. So I think the thing that if people are committed to abolition, I think the message we should be pushing, I say this all the time, the top 3 things that we can do to transform the American prison system are humanize, humanize, and humanize. And so I think if we just keep pushing that message and insisting that we have so many people who are locked up we have no business keeping behind bars, I think that will push the vision quite far.
I think we need to end the questions here. Let's thank Professor Dolovich again.
All right, folks, we're going to get started with our first panel. And I'm going to get the official title correct, which is why I got this program. So it's just simple. Okay, good. Healthcare in prison. I thought it might be something more fancy. So I'm going to encourage all of you to read the full bios of our presenters in the program. What we're going to do is I've asked each of our presenters to speak for 10 to 12 minutes, which is tragic because every one of them is such a wealth of knowledge. So they just have to speak quickly. And I will invite them to speak in the order that they gave me, which was Andy, Corinne, Rachel, and Rebecca. And I'm going to, at the beginning of each one of their remarks, just give you a couple of lines about each of them, and then I'm going to turn it over to them. So we're going to start with Andrew Knoll, who is a partner in the Minneapolis office of Robbins Kaplan, where he helps run the firm's civil rights practice and represents, among many other clients, families who lose loved ones to suicide while incarcerated. And he's going to be talking to us about the constitutional right to medical and mental health care in corrections facilities. Andy. Thanks.
I appreciate the opportunity to be, of course, as I was listening to Professor Dolovich, a lot of thoughts were going through my mind about things that she was talking about and a lot of important issues. So my focus is kind of a smaller slice of correctional institution litigation. I've been doing this type of work for about 20 years. Most of our work involves the county jail system in Minnesota, North Dakota, a little bit in South Dakota, and a little bit in Wisconsin. That's kind of where our focus has been. So, it's a smaller slice, and the things that Professor Dolovich talked about with the exhaustion of remedies, the PLRA, that's really the front lines of where this fight is happening. And the advocates who are doing that are doing great work, and it's important for everybody. My world is more of a single plaintiff lawsuit against either correctional officers or correctional medical providers. And federal court is where all these cases live and sometimes too often die as well. My first exposure to this world came as a law clerk about 20 years ago when I went along on a case that was tried in Milwaukee. It was a jail suicide. A mother of the decedent was the plaintiff, and the primary defendant was the prison psychologist. The case was dismissed on a 12B6, so we got thrown out of court right away. And by we, I mean the lawyers, since I wasn't a lawyer yet. So I didn't have anything to do with that loss or the victory at the Seventh Circuit that brought it back. But this was a 30-year-old male who was in prison for assaulting his mom, and mom was the plaintiff. And I found then that what these cases really boil down to, in my view, is the mindset of either the correctional officer or the correctional healthcare provider. The psychologist in that case, just basic line of questioning, said this in response to a question about, does he look okay? or did he look okay? And this was an individual who had lost 40 pounds in about 3 months in prison, looked like a prisoner of war, and he had been in segregation for a while. And the psychologist's simple answer to that question was, he looked like a segregation inmate. So that was the defining moment of that trial. And the case was won, thankfully. And the lawyers who I helped on that case told me, don't expect this to happen every time. And they were right about that. They're very hard cases. But what I'm really looking for and trying to get to the core of these cases when I'm either taking depositions or looking into taking a case is this mindset, the attitudinal issues that exist in corrections. Because when you make the decision to get into a case, you can expect, as all the panelists and probably many in the audience can understand, it's going to be hard fought. These aren't cases where the defendants and their either county boards or state funds are just going to roll over and say, yeah, you know, we did wrong here. We're going to try to make it right. That doesn't happen enough in my view. So we look at, you know, can we win the case is obviously the most important thing going forward. And one of the tenets that we always embrace is the notion that inmates are essentially the only class of people in the United States that have a constitutional right to health care. So, you know, when we talk about universal health care, a lot of people don't really think about it that way, but that's where it exists. And so that's what we have to try to get either the juries or the judges, expert witnesses, correctional medical providers to understand. The cases, like we said, are challenging. We deal with qualified immunity. We'll talk about that a little bit here today. But there are some benefits to federal civil rights litigation in the jail and prison setting that don't exist in other types of cases. One of those benefits is that there are no damage caps. State law, states all over the country have damage caps set up that don't apply to these claims. Attorney's fees are also recoverable, so you have that hammer when you're dealing with the defendants and their decision makers about whether or not to deal with a claim early. And what's been happening more and more, and I'm sure some of you have read about it or in the paper, in the news, is this privatization of healthcare in jails and prisons, particularly in the county jails. There was just an article a couple days ago, or a story on Care 11 dealing with Mend, which is a company that we've been suing a lot, and it seems like they're going away. So, but they're a private for-profit medical provider in a lot of county jails in Minnesota, and there's no qualified immunity for those folks. So the Eighth Circuit just came out with a decision on that in 2021. So those private actors benefit to us, no qualified immunity, and they also have the same things in terms of punitive damages that are available and no damage caps that other more traditional public defendants have to deal with. The private correctional world is kind of in flux. There's the Mend, which is kind of the leading correctional care company in Minnesota, has recently had its medical director get his license indefinitely suspended. His name was Dr. Todd Leonard. He was rung up pretty good by an administrative law judge with regard to care of a prisoner in the Beltrami County Jail. But he's, you know, at this point in time, when that case was going on, the incident that led up to it at least, he was the only medical doctor for thousands of inmates in the state of Minnesota. So why does that happen? Well, it happens because Mend is a for-profit company. So by definition, and this is of course my opinion, which we're here to talk about, I don't think the provision of healthcare in jails and prisons should be a for-profit business. It should be a priority for counties and the state. Because I'll give you just one example. A Wright County jail case that's still going on. Wright County's in Buffalo, Minnesota. And Tony Valiant, who's our client, went to the Wright County jail with his medications. One of the medications was Xanax. Xanax is a benzodiazepine, which means anyone with medical training would understand you can't abruptly stop that medication. Otherwise, you risk serious consequences. What MEND had in place was a correctional officer would go through the medications when Valiant came in, flagged the Xanax because it's a controlled medication. It's obviously a medication that would be in demand on the street. And then they call a registered nurse who works for MEND, and the registered nurse made the decision on her own to discontinue his prescribed Xanax. So without consulting a medical doctor, a physician's assistant, someone who has the ability to prescribe or unprescribed medication, and obviously without seeing Mr. Valiant, they discontinued his medication. 3 days later, he had a seizure and suffered a serious head injury. And when the nurse was telling me this in her deposition, that this is how they were trained to do it, that basically made our case. That's practicing above her license. And Dr. Leonard in his deposition said she must have been confused about what was supposed to be going on in the jail. So I think Dr. Leonard is one example of this mindset that really gets to the core of how things go bad in correctional institutions. And, you know, qualified immunity is something we have to deal with in every case. Fortunately, that case, they have not moved for summary judgment yet, which they seem to do in just about every jail or prison case that I've ever been associated with. And what qualified immunity is in my context, and I'm dealing with cases primarily when we talk about deliberate indifference to a person's serious medical needs. Medical needs includes mental health needs. So we deal with delays in treatment, obviously yanking prescriptions inappropriately, and essentially the non-treatment of mental health conditions that can lead to suicide in correctional facilities. So you have to prove, number one, on this first prong of deliberate indifference, was there a violation, a constitutional violation? The first prong is, was there knowledge of a serious medical need? Can't say that you should have known, you had to know. The second prong is, what did they do, and was the response reasonable in light of that knowledge? And that's really where most of these deliberate indifference cases fall. The second prong of qualified immunity is was there a violation of clearly established law? Would the state actor have known that the law was clearly established such that their conduct was unlawful? And that's one that we hear about a lot in the context of the Fourth Amendment, police use of force. I think it fits not as well in the deliberate indifference setting. And actually, we found in 2021 that we have an unlikely ally on that theory. And we're actually pursuing it at the Eighth Circuit right now on an appeal at a case that we prevailed at the district court. The Fourth Amendment, police officers, we deal with split-second decisions. We don't want to use 20/20 hindsight. In the Eighth Amendment, when we're talking about deliberate indifference, it just sounds different. There's time to deliberate. And Justice Thomas, in a case called Hogard versus Rhodes in 2021, an ally in Justice Clarence Thomas on this issue, he asked this question, and I'm going to read it so I get it exactly right. He said, "Why should jail officials who have time to make calculated choices about an inmate's care receive the same protection as a police officer who makes a split-second decision to use force in a dangerous situation?" So this is something that moving forward with our cases, we're going to try to exploit and further and really hammer down the fact that when it comes to prong two of qualified immunity, it has no place if you satisfy prong one on a deliberate indifference case. You know, there's many case studies that I could give you. I'll give you just one before I end my preliminary remarks here. We had a North Dakota case where we had a jail medical provider and his wife was the nurse who worked at the jail. And 15 minutes into this doctor's deposition, we knew that we were going to win the case. Some of the questions that we tend to ask at the beginning of these is, do you agree with me that this person is your patient? And the doctor's response to that question was, he's a prisoner, not a patient. This gentleman came into the jail with a gaping wound in his neck from a suicide attempt with instructions to be on suicide watch and to be treated with antibiotics. They gave him the antibiotics. They didn't do that well on suicide watch or the mental health. And this jail doctor, the medical record talked about it as a complex laceration. I asked the jail doctor, Dr. Boyd Addy, why you didn't see or treat this individual. And Dr. Addy's response was that I don't see little cuts. And so, you know, this case, even with this type of testimony, they fought the case through summary judgment all the way to the eve of trial before they would deal with the real problem that this doctor presented. So, and in my view, he defines the mindset that we need to keep out of correctional healthcare, which is basically an infected, jaded mindset that these people are prisoners and not your patients. And I'll look forward to hearing everybody else on other issues, and thanks for your time today.
Thank you so much. We're going to turn to Corinne Kendrick, who is Deputy Director of the ACLU National Prison Project. Before moving to NPP, she spent a decade as a staff attorney at the Prison Law Office. Among many other areas of her expertise, she has extensive experience litigating complex Eighth Amendment medical care cases in California, Arizona, and elsewhere.
Hi, everybody, and thank you for inviting me. So my talk is about what happens when you win a case. The ACLU National Prison Project and Prison Law Office and other organizations, we bring complex class action injunctive cases. So a little bit different from what Andy was talking about. These oftentimes are soup to nut cases. You know, every component of a correctional healthcare system, every component of an ADA disability accommodation. And unfortunately, you know, there's this mindset of like, well, we settled the case, we won the case, it's over. And really what I'm going to talk about is the example of once you win, that just means you're starting the next chapter of what's going on. So basically I'm going to talk very quickly in 10 minutes about what we do at NPP. Translating legal rights into reality. So making the promise of the Eighth Amendment and the Estelle versus Gamble case and others that say incarcerated people do have a right to basic health care because they are captives and prisoners of the state and can't just go out to the emergency room to get medical care. And then talking about the example of our attempts to try to monitor the Arizona Department of Corrections. And then finally, very briefly, just going to touch a little bit on COVID-19 and how correctional systems were broken before the pandemic. And really, like so much of our society, the pandemic just really revealed the fissures. But Rachel's going to talk more about COVID also. So National Prison Project, what do? We are one of the projects of the National ACLU. We were established in 1972 in the wake of the Attica prison uprising. And our mission is to end the policies that give the United States the highest rate of incarceration in the world. And we do this through blended advocacy of litigation, advocacy, pushing legislation at the state and federal levels, and public education. My next two slides, I think they're kind of part of my standard deck. Probably with this crowd, I don't need to tell you, we are the leaders in mass incarceration. We are the leaders in mass inequality and mass incarceration. So that's the system that we're dealing with. You know, there's some good language out there that I like to sometimes look at just to make me feel a little bit better when I'm losing my cases. And these are some of them. You know, the first one, Turner, that's a good reminder that the Constitution does not stop at prison walls, despite what a lot of times the courts think. So we like to pull that one out. And in Brown versus Plata, which was decided actually the first day I started working at the prison law office in 2011, Justice Kennedy had very striking and stirring language about the basic dignity of humanity and incarcerated people. And I just like to read that sometimes. But going more to the point of what I'm talking about is who is monitoring prisons and jails. And Justice Kennedy, again, in his concurrence in a case called Davis versus Ayala, said that basically it's a game of everybody pointing the finger to everybody else. Professor Dolovich mentioned Michelle Deitch at University of Texas, who has really been the leader in talking about the lack of transparency and accountability for carceral settings. And actually Sharon herself recently wrote a paper in the Annual Review of Criminology about the fact that basically the failures in prison and jail oversight extends to every single branch of government. And really, it's kind of left to us, the prisoner litigators, to the extent any monitoring is happening. And the paradigmatic example of this is a case that the Prison Law Office and the ACLU brought. We filed it in March 2012 against the Arizona Department of Corrections. And it was called Parsons versus Ryan. Mr. Parsons is deceased now, and Mr. Ryan has retired, so it now has a different name, and we've gone through 3 judges. So we've gone through 3 judges, a named plaintiff and a named defendant, but the one group that's still there are the prison litigators. And it was a class action on behalf of all people in 10 state Arizona prisons. Arizona has the 4th or 5th largest prison system in the United States and the 2nd highest rate of incarceration in the United States. We settled the case in October 2014, and the court approved the settlement agreement in March 2015. Yay, we won. No, we didn't win. That's when the real kind of rubber hitting the road started in the monitoring. This was kind of a weird settlement agreement in hindsight. It's very quantitative. So it's all about the numbers. It's not about it was not a qualitative settlement. So it was things like, if a provider says that a prisoner needs to go see a specialist in the community and it's urgent, is that appointment approved and completed within 30 days? And the way this was monitored was there were random samples taken each month at each prison on each prison yard to see of the, like, we'll take a sample of 10 people of the 50 that were referred off-site. Did this happen? And then there were numbers and there was monthly reporting. And this was also important because it was actually the Department of Corrections did all of this legwork, not us. And it was because, speaking of privatization, they had a private vendor, a company called Wexford. Wexford was in charge when we settled the case. Very soon thereafter, Wexford walked away from a 3-year, $350 million contract, saying that the state of Arizona had lied during the RFP process. And actually, they made a PowerPoint that we helpfully got in discovery that said, everything in the ACLU complaint is true. So that was a very happy day when we were doing document review. So, for all of, especially the law students who are about to go become first-year associates at law firms and do the drudgery of document review, it's stuff like that you just live for, because when that came up, I was just like, OMFG, pretty excited. So Wexford left, then another company called Corizon came in. Corizon was there for a long time, and now they're on their 3rd company, a company called Centurion. So how did we monitor? We did it in a lot of different ways. Plaintiffs' counsel, as part of the settlement, we had the right to go physically to the prisons at least 20 days a year. There was no limit on the number of attorneys or attorney staff we could bring, but there was a limit on the number of days. And so in the Prison Law Office's other cases and ACLU's other cases, there aren't limits on the number of days of visits. So maybe one attorney will go like once a month. But since we could only do 20 days, we would just hammer them and bring 9 people on a tour and just fan out in the prison. And we would know beforehand some of the people we'd want to talk to, some of the incarcerated people, because they were writing our offices, or we were getting these monthly reports with the data, and it would list prisoners' names of like, they were found non-compliant because this guy had cancer and he was not sent out for 90 days. And so we would talk to those people, but a lot of what we did was literally going on the yard, going into building after building and just saying, hi, we're here from the ACLU and the prison law office, for the Parsons case, anybody want to talk to us? And it would just be lines of people. So then the Department of Corrections said we couldn't bring business cards or self-addressed stamped envelopes. And so we had to get a court order allowing us to have that kind of contact with our clients. And we would just basically go on the yard sometimes. And when we'd run out of time, it was like we were just making it rain envelopes and business cards and literally would take like a box of 200 or 400 cards and go through all of them. So as part of it, we would, talking about the publicity thing. So we would do these monitoring reports. You guys can't really read it, but this is one that we did when we went to the women's prison, and it was just a horrific crimes against humanity that we saw. And we did a notice letter. And then there were a couple of really good reporters in Arizona, including one from the NPR affiliate. And so we would file these redacted on the docket with the court. And the court would kind of say, like, I'm not going to consider these. But then they were public documents. And multiple reporters realized that if they just got on Pacer, they could find out what was going on. So as a result, we found out that we've learned this from women who had given birth. They were coming back and they were getting, after delivering a baby, there's a lot of blood. They would be given 12 thin mini pads, and that was it. And so it was just so outrageous and such a lack of dignity that we really kind of raised hell about this. And as you can see, it got picked up by, of all people, John Oliver. And really kind of just shamed the department. And that was one of the ways we did things. I should have warned you guys. So literally we would go into the infirmaries and start talking to people. And these are things we saw. This was a man who had his broken leg. They refused to take him out and treat it. He got strictures. That's what the medical term is for when your foot does that. This other man was working at a corrections industry facility. It was owned by a member of the Maricopa County Board of Supervisors. It's an egg ranch. His arm got severed in a machine. It took them a very long time to send him out to get his arm reattached, and he had not received physical therapy. We also went to the prison. It came out in the media, thanks to some whistleblowers, that the locking system in one of the prisons was broken. So they were using padlocks to lock people into the prisons. Not really related to healthcare, but we were there. We had cameras. We had them take pictures of it. And then part of the case also was conditions in solitary confinement. The picture above was just graffiti that I found in a cell. The picture to the right was a photo taken last year when I had an announced visit with our mental health expert, Pablo Stewart, and this was in the mental health unit. And they knew we were coming, and they were like, yeah, we haven't had a chance to get around to clean up the blood that's inside this cell. So I'm going as fast as I can. So there were a lot of reasons why there was a complete failure of compliance. First of all, complete denial that there were problems. There was absolutely no independent oversight or accountability. We were the only people going in there. Privatization was a big problem too, because of the profit motive for the healthcare vendors. And there was a very strong culture of retaliating against whistleblowers and incarcerated people who came forward. So we just kept pounding on them. And this is kind of a summary of some of the contempt. They were found in contempt of court twice in less than 3 years, which is extraordinary in any civil rights litigation, but especially in the prison complex. And then in July of 2021, on a Friday, much like this, Um, Out of the blue, our district judge issued an order saying that she was sick and tired of the department not complying. She was vacating our settlement agreement and she set us for trial. And we had a 15-day trial just recently in November and December, where we have asked the federal court to appoint a receiver to take over the delivery of healthcare. We got all sorts of evidence about the overuse of solitary confinement, people with mental illness, children. Children convicted as adults in Arizona are sent to adult prison, not to a juvenile facility. And we've asked the judge to do this. And so as we are here today, we are waiting to see what the judge might do. And I am at the end of my time, but I just want to briefly point out that COVID-19 in jails, prisons, and detentions, it's been just a really kind of horrifying experience as a prisoner rights attorney and as somebody who, talks to, visits, meets with incarcerated clients. Some very dear to me clients died during the pandemic. They were medically vulnerable. They were not protected. These are the numbers I got actually from Sharon's program. I checked it a month ago. These numbers are a profound undercount. And later on, we can talk a little bit more about all the different ways that prison systems have lied about the numbers. And this really shows you why social distancing is not possible in prisons. These are two of the living options in Arizona prison systems. On the left is an old style tiered facility where it's 5 stories and it just looks like that all the way up. Another facility uses World War II Quonset huts that used to incarcerate Japanese Americans during World War II. And people live in those facilities. So unfortunately, that's not livable. And then finally, this is an image. We have been suing at the ACLU a lot of ICE detention facilities operated by for-profit contractors. At La Palma, which also is in Arizona, operated by Core Civic, the asylum seekers and immigrants staged a hunger strike because they were not being provided masks or soap. This was very early on in the pandemic. And this was the response that they got. And we got these photos as part of the discovery. It was from a fixed video that just showed the SWAT team coming out, and the men had been sitting at the tables and just, were saying they were not going to go to chow. And so this was the response. And finally, a few more thoughts for you. Again, striking words from Justice Brennan in dissent, but I think Pell really sums it up in just one sentence. A visit to most prisons will make you a zealot for prison reform. Thank you.
So next up, we have Rachel Kincaid, who is an assistant professor of law at Baylor University, where she teaches criminal law and criminal procedure. Before starting at Baylor, she practiced at Mountain State Justice in West Virginia, where, among other things, she litigated civil rights claims on behalf of currently and formerly incarcerated people. And she's going to talk to us about reasonableness and deliberate indifference in the time of misinformation, carceral responses to COVID-19. Rachel.
Thank you, Sharon, and to Corrine and Andrew, and to Sharon as well for your words already today. I feel really lucky to be here with such incredible voices on prison litigation. So I'm currently working on an article called Reasonableness and Deliberate Indifference in the Time of Misinformation, Carceral Responses to COVID-19. The article focuses on the effects of the misinformation campaign surrounding COVID-19 on carceral responses to the disease. Today, I'd like to talk about just several issues related to that project. First, I'll briefly set the stage by discussing the misinformation campaign itself and the reasons that carceral facilities are a tinderbox for the spread of COVID-19. Then I'll discuss the myriad legitimate reasons that incarcerated people might be suspicious of the medical treatment they receive while incarcerated, compounding the problems created by this misinformation campaign. Then I'll discuss the way the legal remedies for federal constitutional violations, further compound the problems that result from a misinformation campaign like this one. And then I'll end with a few suggested solutions. So first, let's just briefly talk about the misinformation campaign surrounding COVID-19, which the World Health Organization calls an infodemic. The infodemic in the United States, of course, has included misinformation coming straight from the top of the executive branch of our government. For example, Donald Trump downplayed the severity of the disease and what to expect out of the pandemic during the early weeks of 2020, including claims by the president that it would disappear when the weather warmed up, and repeatedly saying COVID-19 is like the flu. He also de-emphasized the importance of masks and insisted on holding campaign mega rallies in spite of the clear danger. And he advocated for unproven and even hazardous cures and treatments like hydroxychloroquine. But of course, the misinformation campaign wasn't coming only from the President of the United States. Other sources like conservative media pushed ivermectin as an unproven cure. And a doctor who had advised President Trump claimed that social distancing and quarantining did not work publicly. Of course, when people are misled by unsubstantiated claims about the nature and treatment of a disease, they are much less likely to observe official health advice, thereby contributing to the spread of the pandemic and posing a danger to themselves and others. But not only has COVID-19 been the subject of this infodemic, various aspects of the disease make carceral facilities a tinderbox for its spread. Carceral settings are a tinderbox for COVID-19 for many reasons. Some of the biggest ones, though, are the overcrowding in many carceral facilities, the pervasive unhygienic conditions, the comorbidities of jail populations, and the deficient provision of medical care, which is the focus of this panel overall. But the infodemic has been especially dangerous to carceral populations, not only because of the conduciveness of the carceral environment to COVID-19, but also because of the susceptibility of carceral populations to the infodemic itself. We know, of course, that the carceral environment is an anxiety-inducing one. Even in the best of times, incarcerated people are isolated from the outside world, and their access to information is severely curtailed. But contact with the outside world has only been further curtailed during the pandemic, while the use of deliberate isolation in carceral facilities has increased. Carceral facilities are also full of people who have been traumatized by the government and others with high rates of mental illness, being held in conditions that only exacerbate these problems. Incarcerated people also generally have legitimate reasons to distrust the medical care they receive while they're incarcerated. Specifically, there's a history of experimentation on incarcerated populations. Through the 1970s, this was widely accepted, but the practice of using carceral populations as test subjects for various medical treatments continues to this day, often with only dubious consent. And the same generally deficient medical care that contributes to worse outcomes on COVID-19 for incarcerated people also, of course, legitimately feeds their distrust of any medical care they might get while incarcerated. Finally, rooted in racism and eugenics, US carceral populations have been subjected to coerced sterilizations. California has been in the news of late for attempting to provide reparations to thousands of people who were sterilized in California institutions without adequate consent. These sterilizations continued into the 21st century, but California is, of course, not the only state to have carried out these atrocities. Like everything about incarceration, the racial disparities in incarceration in the United States are also relevant to this discussion. As most of you, I'm sure, know, Black and Latinx people are grossly overrepresented in our carceral facilities. Less talked about, but equally troubling, is the overrepresentation of members of Native American tribes in our carceral facilities. As this graph indicates, all three groups are confined in disproportionate rates in our local jails and prisons. And Black, Latinx, and Native populations are similarly overrepresented in federal carceral facilities. The medical mistreatment these three groups have suffered even outside of carceral settings feeds into the legitimate distrust of medical treatment that we see in carceral populations. Black, Latinx, and members of the US Native tribes have all suffered medical mistreatment in many of the same ways that carceral populations as a whole have suffered. The medical mistreatment of Black people, of course, dates back to the time of slavery when slaves were abused as experimentation subjects. But that practice was not abandoned with the end of slavery. Perhaps the most famous example is the Tuskegee study, where effective treatments for syphilis were deliberately and systemically withheld from a group of Black men in Alabama. The medical mistreatment of US Indigenous people has been similarly systematic, ranging from forced sterilizations in boarding schools and elsewhere to medical experimentation, including evidence that such experimentation was carried out on kids who had been forcibly removed from their tribal homes to boarding school institutions. And the Latinx community has not escaped this mistreatment. President Obama publicly apologized for the use of incarcerated Guatemalans as test subjects for a study on STDs in the 1940s. And the issue of forced sterilizations reared its ugly head less than 2 years ago when allegations of forced sterilizations at a for-profit ICE detention center became public. And of course, overall, disparities in medical outcomes for Black people, Latinx people, and Native Americans in the United States are an ongoing and pervasive problem, separate from the problems in carceral institutions. And perhaps the ultimate validation of this patchwork of mistreatment leading to legitimate fears of medical establishment by incarcerated people. Last fall, incarcerated people in a jail in Arkansas were given ivermectin, to treat COVID-19 without their knowledge. Another lawsuit in Oregon alleges what was almost certainly not a unique occurrence, that correctional staff spread misinformation about the pandemic to incarcerated people, calling it a hoax, an election scare, a plandemic, or otherwise indicating allegiance with unhinged conspiracy theories and lies. So just as this author and incarcerated person, Christopher Blackwell, noted in an op-ed in the Business Insider, there are many reasons for incarcerated people to be distrustful of the medical care they receive while they're incarcerated. And the groups that are disproportionately incarcerated in the United States have even more reasons generally to be distrustful of the medical establishment. I posit that this means that the infodemic had the effects of the infodemic on carceral populations are therefore likely to have been magnified when compared with the general population. That means that even reasonable jail and prison administrators trying to do the right thing as public servants and do everything within their power to protect the incarcerated people under their care have difficulty getting buy-in from carceral populations because of this distrust compounded by the infodemic. And for incarcerated people not lucky enough to be held in a facility where the administrators truly want to protect their health and safety, there is one last piece to the puzzle explaining why I suggest that the infodemic was especially harmful in carceral settings. And that is the limitations of the legal remedies that incarcerated people can use to validate their constitutional right to medical care and to be protected from disease while incarcerated. The Prison Litigation Reform Act, which you'll hear more about later, requires that incarcerated people exhaust their administrative remedies before they are allowed to bring their federal constitutional claims to court. But when incarcerated people aren't even sure what they should be asking for or what actions they should be challenging because of a misinformation campaign like this one, it becomes that much harder for incarcerated people to jump over the exhaustion hurdle. The deliberate indifference standard itself also compounds the problem. It, of course, means that proving that jail and prison staff have just been unreasonable is not enough. Incarcerated people have to prove that the people they are suing were deliberately indifferent. What we've ended up seeing in prison litigation about COVID-19 is a tendency for courts to say, well, if the prison had some policies in place, then they weren't deliberately indifferent. That, no doubt, in part reflects the reluctance of many courts to get involved in prison and jail management decisions. But I also posit that it reflects the general lack of guidance coming from the federal government about what is and is not required to protect the health and safety of incarcerated people. Against the backdrop of official misinformation, it becomes even more difficult for courts to say that carceral administrators have been deliberately indifferent as long as they've tried to do something, even if that something was to just put a policy in place and then make no real efforts at enforcement. So I don't want to end with exclusively doom and gloom. So I do propose a few solutions to prevent this kind of thing from happening as we continue with the pandemic and in future situations. Of course, first of all, don't do the misinformation campaign to begin with. But where we can't control that, we also need to include enforcement mechanisms in official CDC guidance. Not just, you should do this, for example, make hand soap available, provide masks, wear masks, clean high-touch surfaces, but also use these techniques to get compliance from staff on these rules. This will help undermine litigation outcomes where the court holds that administrators made a policy regardless of enforcement strategies, so there was no deliberate indifference. Of course, we also need courts to actually listen to and take seriously litigants' evidence about whether policies are being enforced. And finally, perhaps most importantly, we need to include education programs for incarcerated people, including peer education and official guidance about diseases. We've seen a lot of discussion about education with respect to the vaccine rollout in carceral facilities. And there's evidence that facilities that have engaged in intentional education campaigns about the vaccine have had higher rates of vaccination rates than ones that haven't. Lots of settlement agreements reached for lawsuits about COVID-19 responses in carceral facilities have included incarcerated person education in their provisions. And the most recent CDC guidance to the pandemic, to its credit, issued in February 2022, calls for education about the vaccine. But we need education about the disease and preventative measures across the board, not just about vaccines. It will directly help fight the infodemic, and it will help to increase buy-in by incarcerated people in policies that can help protect their health and safety. These kinds of educational provisions should be incorporated in any CDC guidance about future diseases, and that guidance should come with resources from the federal government to help carry out those education goals. Thank you all.
Thank you so much. Now I'm going to turn to our last speaker, Rebecca Schlaffer. How much is it?
Well, it's a long name, Schlaffer.
Schlaffer.
We're so close.
Rebecca Schlaffer, who is associate professor in the Department of Pediatrics here at the University of Minnesota. She has particular interest in children with parents in prison and the impact of incarceration on families. And I'm going to turn it over to her to talk about pregnancy and parenting in the time of COVID.
Thank you so much. And thank you for the introduction and the opportunity to be here. I am going to move quickly too, because we have an amazing panel of pieces that have tied together across presentations, which I'm eager to talk about. Also very nice to see faces in person and not Zoom boxes today. So again, thanks for that opportunity to leave my house and put on real pants. So I want to begin with my major take-home message, and that is that pregnancy in prison is characterized by a lack of supportive policies and practices. Put simply, prisons were not built for pregnant or postpartum people. And although a lot of my work has focused on improving the conditions of confinement and making new policies and practices to improve the conditions for this population, I believe very strongly that these environments will truly never be safe for pregnant and postpartum people. So before we dive in to thinking about the way that COVID has impacted pregnant and parenting people in prison, I want to back up just a bit and talk briefly about women in prison more generally. So we know over the course of about 3 decades that we saw a nearly 700% increase in the number of women incarcerated in the United States. We also know, and as some of the panelists have talked about today, that systemic inequalities have resulted in marked disparities in who is incarcerated in this country. Incarcerated women are disproportionately women of color, and they experience very high rates of chronic health conditions and mental health problems. Most of the women behind bars are mothers with minor children, and a majority of them are of childbearing age, between 18 and 44 years old. So when we think about pregnancy in particular, we actually know very little about pregnancy in prison, in part, right, because of these issues that we've heard about already regarding a lack of transparency, a lack of data collection, a lack of oversight. And most states do not systematically collect any information about pregnant people in prison or their outcomes. And so we actually know, as I said, very, very little about this population and their health conditions. My colleague, Carolyn Suffren, completed a landmark study in 2016 with 22 state prisons, all of the federal prisons, and 6 large jail systems. And this really was the first time ever that we got any information about the number of women who were in prison and pregnant. And from that study, she said that approximately 4% of females entering US prisons were pregnant, resulting in an estimated 3,000 admissions of pregnant people to state prisons each year. Similar data in terms of what we see in jails, an estimated 3 to 4% of women entering jails are pregnant, resulting in about 55,000 annual admissions to jails. And unlike jails, where there is considerably high turnover, as you all know, most women who enter prison pregnant will give birth during their period of incarceration. But what happened to pregnant people during COVID? It's hard to say, again, right? Because prisons aren't systematically collecting information about pregnancy status. And in our attempts to ask, prisons were very difficult in terms of getting a handle of what they did with this population or how policies or practices changed during the pandemic. We do know, though, that the pandemic resulted in dramatic reductions, at least temporarily, in the prison population, and that presumably these reductions were similar to the number of pregnant women coming into prison. I can say that anecdotally, this appeared to be the case in Minnesota. We had significant reductions in the number of pregnant women at the women's prison in Shakopee. And when we did see pregnant women, they seemed to be in for longer sentences, suggesting that what we were seeing pre-pandemic, right, that the population that was coming in now were for longer sentences. And these were the cases that had made their way through the system. We also saw that in many states, pregnancy was considered a health condition that was prioritized for medical release. And some in our state were released during that time. So taken together, we saw fewer pregnant women coming into the system, and many of those that were incarcerated were released at the peak of the pandemic. I want to turn now to thinking about the care and treatment of this population from pregnancy to postpartum. And along the way, we'll briefly discuss how COVID impacted this population in unique ways. First, let's think about prenatal care. Most jails do not screen for pregnancy, which means that in some instances, individuals who will be admitted to prison only then learn that they are pregnant, perhaps having been in county jail for weeks or months beforehand without receiving any pregnancy-related care. Additionally, while we know that they have a constitutional right to health care, we know that there are no mandatory standards for pregnancy-related care in prisons and jails. And pregnancy-related care has been consistently described as poor. And I think that poor is the politically correct term here, and we all know that it is much, much worse than that. A study from the Bureau of Justice Statistics found that only 54% of pregnant women in prison reported receiving some type of pregnancy-related care while incarcerated. So almost half say that during their time incarcerated, they received no pregnancy-related care. There are many states, at last count, around 18, that have no laws that prohibit the use of restraints on pregnant people. We know, of course, the risks associated with the use of restraints during pregnancy, labor, and childbirth are well documented. And even in states like Minnesota, where there are laws in place, compliance with these laws is an ongoing concern, including recent high-profile cases where restraints were used on a woman in active labor. Additionally, most states do not ensure adequate prenatal diets for this population, which Crean just shared a slide, and I picked up on the part there about the peanut butter jelly sandwich, the peanut butter sandwich, and the additional carton of milk, which we know is nowhere near the nutritional guidelines for pregnant people. Detoxing this population with OUD, the pregnant population with OUD is common, despite clear clinical guidelines around best practices for treatment of opioid use disorder. So this is the context of prenatal care in our country, right? And during COVID, it only, of course, got worse. There were disruptions to nearly every aspect of prison operations. Standard prenatal care was disrupted in some cases, and when pregnant patients were taken off grounds for medical appointments, they were required to quarantine, regardless of vaccination status, upon return to prison. So I encourage you to think about what this looks like in the last trimester of pregnancy, where you are seen regularly off-site for prenatal care and then returning to prison for long periods of time, essentially the entire last trimester of pregnancy in quarantine, also by another name of medical isolation. And we can have a discussion about what that means in terms of how that differs from segregation, other types of correctional control. Additionally, in most prisons across the country, programs and classes, often which are led by volunteers in the community, were suspended in order to reduce the risk of exposure from individuals coming from outside the prison. This, of course, meant that many states where there are programs for this population, pregnancy support, parenting education, and the like, these programs were suspended, some of which have resumed today. Labor and birth support is another area where we see challenges in the care of this population, generally, even before COVID. In most states, pregnant patients will be transported from the prison to a local hospital for labor and birth. In nearly every state, policies prohibit contact with family members. And with the exception of 2 officers in the room and the nursing and medical professionals, women will labor and birth alone. In a few states, Minnesota included, pregnant people have the option of being supported by a birth coach or doula. During the pandemic, though, this has looked, of course, much different. For the laboring person, there was understandably heightened anxiety and stress due to the increased risk for severe infection for pregnant people. And in those states where doulas were usually permitted, there were long periods of time where these services were paused due to hospital policies aimed at reducing exposure to spreading the virus, meaning that even in those states where programs existed, women were back to laboring and giving birth alone. Before COVID, there were some common aspects of care related to the postpartum patient. Patients were generally discharged from the hospital and transported back to prison within 48 to 72 hours. Nearly all biological mothers are therefore separated from their infants at that point in time, with the exception of mothers in a handful of states where prison nursery programs are available to women who qualify. I want to come back to this point about separation from infants because I think Rachel raised a really important point here about the intersecting aspects of marginalization for people in prison, especially women who are in prison. Pregnant women in Minnesota prisons, 25% of them are American Indian Indigenous, right? We think then about the forced separation at the hands of the state of families and the historical trauma that is happening, again, at the hands of the state. Really critical pieces here when we think about systemic inequality and family disruption. The transports back to the prison for postpartum patients are often physically and emotionally traumatic. Unclothed body and cavity searches are common, and women return to prison environments that have given little attention to their postpartum needs. For example, few facilities have written policies about lactation, and postpartum screening is often non-existent. And what about during COVID? Again, the birth and hospital stay mean that when the mother would return from the hospital, she would quarantine upon return. I think this should give us all pause about what this means for the well-being of a postpartum person who has just been separated from their baby and is now more or less isolated from other supports within the prison. We know other aspects of care were disrupted. Programs that support postpartum moms were suspended, and with visiting suspended across the country, this meant that new moms would have no opportunity to visit their newborns, even if there were caregivers who would overcome all of the typical barriers to visitation, like travel, cost, reliable transportation, and the treatment of visitors in these facilities. I want to end where I started. Rachel gave you a really helpful solution slide. I'm just going to end on the cynical side. Maybe I'll come up with solutions during the panel. Pregnancy in prison is characterized by a lack of supportive policies and practices. And like nearly everything else, the pandemic made this infinitely worse for pregnant and postpartum people. Thank you.
Thank you all so much. That was really incredible panel. I learned so much. So I gather we just have a few minutes. Okay, fabulous. We have 15 minutes for questions. And actually, if we do have 15 minutes, I want to start by inviting the panelists to see if you had any comments on anything you've heard from anyone else on the panel. Andy, yeah.
Yeah, one thing occurred to me with regard to the COVID issues, and I'm wondering if, oh, I'm sorry, thank you. You know, I'm wondering with an infectious disease like that, if you at times have allies in like the correctional officers, other people that work at the facilities. I mean, I can recall in Minnesota, we had a big TB outbreak at a county jail, and basically the correctional officers were just as angry about what happened with the inmate who spread it and how the inmate wasn't treated than the other inmates who got it. So I'm wondering about maybe an unlikely ally among jail staff and COVID, if you guys have seen any of that.
Yeah, Rebecca.
I'm curious. I mean, I would be interested in hearing from others. In my experience, they were not necessarily allies. And I think it speaks to what Rachel shared about misinformation. We saw pretty drastic differences in correctional officer vaccine rates by facility, which I think signals regional differences and sort of vaccine uptake and understanding of COVID-19 and the importance of vaccine. And I think really important, one of the things that we consistently heard, I have a project that's ongoing about vaccine confidence and uptake among incarcerated people and staff. And I think one of the things we consistently heard from incarcerated people was, why would I get a vaccine if the corrections officer in my unit isn't getting vaccinated either? I don't trust that thing. And I think, again, we saw a high correlation between correctional officers' vaccination rates and incarcerated people's vaccination rates. And I think it goes back to that question about information and the access to information. And Rachel talked about the infodemic, and I think it's important to remember just the information inequality that exists in prisons, right? No access to the internet, if access to phones to contact loved ones is limited and your time on those phones is limited, the ability to have conversations about what's going on in community, what does vaccination look like, et cetera. I think not always are corrections officers going to be the ones you're going to look to for reliable, accurate information. So.
And I can definitely see how that would be with COVID versus the tuberculosis
Yeah.
example. Universally, I think back when this happened, it was 10 or 12 years ago, everyone knew that tuberculosis was
Right.
bad, right? And you didn't want to get it. So I can see how that could play out.
Rachel, Kareem, thoughts?
I would say yes and no. So there's kind of two examples. In early 2020, at the beginning of the pandemic, my favorite place, Arizona, the correctional officers, I mean, they also had the problem where at some of the prisons, only 50% of the officer positions were even staffed. So everybody was kind of overworked. The officers threatened a wildcat strike if they weren't allowed to wear face coverings. Because originally the director said that incarcerated people couldn't wear masks or face coverings because they could, if they can't hide the contraband in that half-inch beard, they can stick it in their mask. But then also they said, well, the officers can't wear it because it'll scare the incarcerated people if they're not allowed to wear masks, but then the officers are walking around wearing masks. So the officers threatened a wildcat strike if they weren't provided masks and access to testing. That was very early on. And then the other extreme is in California, where there was a pre-pandemic prison case. The federal judge issued an order requiring all staff to be vaccinated. And under intense pressure from the prison guard union, which coincidentally, I'm sure it was just a coincidence, donated $1.8 million to Gavin Newsom's campaign to resist the recall. The state of California and the Department of Corrections appealed that order to the Ninth Circuit, and the oral arguments were last month. So kind of two examples.
Any other thoughts from anybody about anything else you've heard on the panel before we turn over to the audience? Yeah, Rachel.
Well, I'm interested in y'all's thoughts on, thank you. And y'all's thoughts on, I mean, yeah, we need courts to listen to this evidence about whether policies are being enforced. Have you guys seen litigation strategies to try to make that happen? Is it totally just judge dependent? I mean, very early in the pandemic, in the class action that I was involved in against all of the West Virginia jails over healthcare and medical care, we filed a COVID-19 motion, as many people did. We had all of these incarcerated people lined up to talk about the fact that, yeah, they have this policy, but they're not doing anything. And the judge didn't even hear the evidence. The judge looked at the policy and said, it's early enough. They wrote a policy. I don't need to hear the evidence. If you think the enforcement problems endure, come back, basically. And so I was just wondering if, you guys have particular strategies that you think are effective, or if it's just, is the judge actually going to listen to the evidence? Is there anything to help make that happen?
So the ACLU filed about 80 of these cases across the country regarding COVID and against prisons, jails, ICE detention centers. And it really came down, I mean, I hate to say this, but it came down to who the judge was. Because, I mean, you can't file 80 cases, like each one uniquely. I mean, the complaints look strikingly similar. All the legal arguments were exactly the same, just changed, for the circuit. With every case, whether we were moving for a TRO or a PI or whatever, we would have dozens of declarations from incarcerated people. And in one court, we got the PI, and then in another court, we didn't get the PI. So the legal strategy was identical. So I think that's a good example. I mean, one thing that a little bit after the fact happened, because we were already in discovery in one of our cases, but so the jail was like, we're not going to let them in. They're going to bring in COVID, and, they're just going to be tromping around and, talking to people about their med mal cases, like this doom and gloom. And so this was actually, I think, a very smart thing that we did was we said, okay, well, we'll make it really easy for you. Why don't you just give us 12 hours of random still video footage of what's going on? And that was way better than having a tour because, except for the blood on the walls that they couldn't bother to clean up. For the most part, when they know the ACLU is coming to do a tour for a lawsuit, all you can smell is the bleach and the paint and, everything's the Potomkin village. But, the line officers had no idea that we were asking for the footage from between 3 and 4 p.m. on the, day room floor of the M-Mod in the jail. And oh my God. I mean, it was just like, this is better than a tour. And I think that was good evidence to show the judge to say, look, they weren't trying to paint things up for us and our expert to come watch. This is what things look like. This is what our clients are telling you in their declarations. Here is the video proof.
I was just going to say, so the piece that Greg mentioned, I read about some of these cases, the COVID cases, and I'm just so struck by the disconnect, even between this deliberate indifference standard that was in place before the pandemic and how it's being implemented in the COVID cases. And the thing that strikes me the most is this line that you see in case after case, I think taken from Valentine and then just recycled, is prison officials doing their best. And so that's, here's the policy, they've done something, therefore they're not deliberately indifferent. And I would just say, Justice Sotomayor in her dissent from the denial for the vacation of the stay in Valentine makes this point that, it's not enough just to show that you have a policy. It's not enough just to show that you've taken some step in response to COVID. And the reason is deliberate indifference is actually realizing the risk of harm. And if you take a step, but that step will be inadequate and then the harm will persist, you are deliberately indifferent whether or not you took the step. And that's just, and we know that that's obvious, but I actually feel like, obviously Karina's right, like the judge is everything, but I actually think that helping the judge see precisely why doing your best is irrelevant is actually could make a difference. And I use the example of Plata and Coleman. I used to say to my class the other day, in Plata and Coleman, they were trying, but overcrowding just meant it was impossible for them to actually provide adequate medical and mental health care. And so nobody at any point in the litigation, like the defendants never tried to argue, we are no longer deliberately indifferent, even though the medical and mental health care is still grossly inadequate because we're trying. If they had, everybody would have laughed them out of court, and the reason is that it's actually illogical on the doctrine. So some of it might just be, I think judges are looking for a justification for getting rid of the case. So all you can do is make it as hard as possible by walking them through what the standard actually requires.
Yeah, I hate to beat on the judge thing, but it is 100% true. If a federal judge is looking for a way to dismiss one of these cases, they will find a way. If they're looking to make it survive, they will find a way to make it survive. That just seems to be the way it is.
Great. So I'm going to turn it over to the audience to see if people have questions.
Corinne, thank you so much for reminding us that winning the case is not the end of the case. So I wanted to get your thoughts about something. And in law school, of course, we talk about remedies and the value of an injunctive remedy because it's enforceable by contempt. So you obtain an injunction, you obtain a contempt citation, and yet it still doesn't seem to work. So my question is kind of twofold. One, was there ever any recognition by anyone in the Department of Corrections that being held in contempt was kind of a big deal. That's not something that happens very often, that public officials are held in contempt. And second, do you have any thoughts about how to bring about better enforcement of these kinds of agreements, or whether we should even enter into those agreements if it's going to be met with contempt?
Well, so on the contempt thing, so they were found in contempt, fined $1.4 million. What happened is because they're privatized, in the contract for the privatization, they were indemnified by Corizon. And so in the contract, it said all legal expenses associated with this case will be paid by Corizon. And so I don't know if it's an appropriate expression to use anymore, but the state had no skin in the game. Because at the end of the day, it wasn't coming from them. That's also why, like, I think it was such a litigious thing, is because the state attorney general was not representing the department. It was a private law firm who many of the people who do this work will know the name of it quite well, but their day job is representing Core Civic. But they had no incentive to work collaboratively. They litigated every single thing. I mean, we went to the Ninth Circuit 4 or 5 times on 14 different appeals. The Ninth Circuit just kept consolidating them. So there was no incentive, and their legal fees were not being paid by Arizona, indirectly being paid by Arizona taxpayers. So the third time we moved for contempt was when the judge just said, I'm blowing up the settlement agreement. And she walked through the legal standard and said, I could fine them $24 million, but the 2 previous things have made no impact on you. And so I'm going to set the case for trial. What we had asked her to do the third time, which she did not do, but I kind of wish she had, was we said, invalidate, and there's doctrine that allows this, is that nullify the indemnification clause and make the state pay and not pass it on to their contractor, which I'm sure the attorneys from Centurion were privately like, thank you. But she decided not to do that and said, look, we've found you contempt twice in less than 3 years. Apparently nobody from the state realizes how extraordinary that is. Unfortunately, this all happened right at the same time. One of the same judges had found Joe Arpaio in contempt, who ran the jail in Maricopa County. And while all this was going on, the background noise was he received a full pardon. And after he received his pardon, the contumacious behavior of the state just went through the roof. So I think that may have been part of the reason why the judge just said, I'm not doing that a third time. There's no point, because who knows? Charles Ryan might get a pardon from the president.
Hi, I just wanted to add a little piece to what Dr. Schlafer was saying about the COVID-19 response here in Minnesota. The Ombuds Office received thousands and thousands of emails from incarcerated people during the pandemic. It was an email that we opened up so they could have direct access to our office. And so we monitored those emails, but we did not respond to them, but we monitored all of them. And one of the things that really struck out to me, both from emails from incarcerated people and staff, was it really did come down in a lot of places to culture. And so the places where we had higher staff vaccination rates, came both to the kind of the culture at those facilities and the communications around what was happening and how much kind of open communication was happening. And so I think that that's a really interesting point too, when we keep going back to that thing of like, you can have leadership and a lot of great policy, but if the culture is not changing, and those are very slow changes, that it has very real effects on incarcerated people in day to day. One of the things that I've been really struck by in this conversation today is over and over again, people are saying there's not the independent oversight and there's not the access. And so that's one thing that Ombuds does have, and it's not a replacement for legal remedies. And in fact, we often refer people to follow their rights in court. But we do hear from federal facilities and loved ones of people who are incarcerated in federal facilities, and we have no jurisdiction there. And Dr. Kincaid, I think you had said that there's been a lack of guidance from the federal government. Is that part of the conversation at all in the solutions? There is not a Bureau of Prisons ombudsperson. There is for staff, but there's not for incarcerated people. Do you know if that's been part of the conversation at all, or anybody else know?
Do you all know? When I was just nominating.
Yeah, well, I mean, I would just say that, I mean, if the question is kind of what's available, yet again, we're going to invoke Michelle Deitch, who has developed a kind of comprehensive database for all of the ombuds people, oversight people that are pretty much exist around the country. And, I think what she would say,
Here's her.
but who oversees, right, this is from the American Criminal Law Review just recently, who oversees the overseers, the status of prison and jail oversight in the United States. And I think what she would say is it's obviously a patchwork. There are a few places that do very good work and many places that strive mightily, where there are oversight agencies, ombuds people, they strive mightily to do what they can. And I'm sure as you guys do. And the problem is, first of all, authority is, one of the big things that she talks about is, they have the power of shaming, but not any kind of legal authority. So as good as you can be at calling attention to what's going on, if you don't have any, you can't hold hearings and subpoena witnesses, you can't direct anybody to change anything. So it really, I know from what's going on in LA County is the Inspector General in the jail, they do really great work. Most of their work is only done, they only have success when they can get deputies and command staff on their side. So there's a lot of kind of interpersonal navigation, and the successful function of oversight should not depend on whether you can play nice with the people that you're overseeing. So I really, for anybody who's interested in this set of issues, Michelle Deitch's work is indispensable. I think we probably are out of time. Oh, one more question. Yeah, there's one more here.
So my question was for Dr. Schaefer. So what reasonable policy changes do you think that we could make to better support postpartum care, dealing with birth parents that are separated from their children, bonding with children?
I don't want to put Commissioner Schnell on the spot, but since he just walked in, maybe we'll talk about the Healthy Start Act. Just last year, the governor signed the Healthy Start Act into law. For folks who are not familiar with this, this gives the Commissioner of Corrections authority to release pregnant and postpartum people into community for up to 8 months, 1 year is where we landed. I think that's an option, right? And I think that it's a better alternative than prison nurseries where we're thinking about bringing babies inside. I think we have a lot of work to do to think about what are the other ways that we can move upstream, right? So kind of on the pre-adjudication side, where are there places to prevent any separation from moms and babies, but also thinking about intervening early if these are issues that are bringing moms into the criminal legal system related to mental health, chemical dependency. Those are things that can compromise parent-child relationships, right? And so how do we support moving upstream, intervening early, supporting whole family systems so that the separation doesn't occur when moms come into the criminal legal system? So I'll leave it at that.
Thank you all. Thanks, everybody.
My name is Rachel Paulos, and I'm a visiting professor here at the University of St. Thomas. It's my privilege to moderate this next panel on personal safety for prisoners. We're going to be hearing from 4 presenters in 3 different presentations, including Chinyere Ezie, Alexander Klein, Claire Kiefner, and Keith Udoybach. We're going to begin with Ms. Ezie. And as she's walking up, I'm just going to introduce her. Ms. Ezie is a senior staff attorney at the Center for Constitutional Rights. She advocates for racial and gender justice for lesbian, gay, bisexual, transgender, queer, and intersex rights. And she challenges governmental abuses of power. Before joining the center, she was a staff attorney at the Southern Poverty Law Center, one of the nation's foremost civil rights organizations, where she brought cases defending the rights of LGBTQI Southerners, including trans prisoners' rights, activist Ashley Diamond. Previously, she'd also served as a trial attorney at the United States Equal Employment Opportunity Commission, the EEOC, where she litigated employment discrimination cases. So we're looking forward to hearing from you this morning, ma'am.
Thank you so much for the generous introduction, and good to be with all of you. For the first time, at least in my case, during the pandemic, a non-remote appearance. I'm here today to, in essence, explain why LGBTQ rights, why prisoners' rights and prison conditions cases are LGBTQ rights issues, and sort of how I came to that understanding, and what I hope you will come away with as far as understanding the discrimination to incarceration pipeline, how it works, and how we can work together to disrupt it. So in the United States, transgender and gender nonconforming people who, for purposes of today, I'll refer to as TGNC people, experience a lot of discrimination in areas ranging from education, employment, and in many instances, healthcare, and even in the family. And so as a result, we have seen systemically through social science research that you see very disproportionate rates of unemployment in the TGNC community, extreme rates of poverty among TGNC individuals, and at times that can go up to rates as high as 21% of TGNC individuals, particularly people of color, living below the poverty line, or the rate of extreme poverty, which is less than $10,000 of income a year. These issues matter not only because they're systemic, but because we've seen time and again that they end up being drivers of incarceration for the TGNC community. Pictured here is Miss Major Griffin Gracie, a very prominent trans rights activist, a Stonewall rebellion, one of the agitators there, who not only has experienced systemic employment discrimination over the course of her life, but also many stints of incarceration after she resorted to forms of survival that are criminalized because of the ways that she was treated when seeking legitimate employment, including having employers call her vile, disgusting, annoying, an abomination, and in essence, report that they didn't want people like her working at their companies. I point out Ms. Major's story because it's really representative of what many of the folks I've represented, both as an employment discrimination lawyer and as a prison rights lawyer, have faced, which is systemic push out from means of survival that are, again, not criminalized by society. So what is the result of that? You see that TGNC people in the United States experience really disproportionate rates of homelessness because of the discrimination and barriers they face, which includes rates of homelessness up to 59% for TGNC women of color, as well as youth homelessness rates of 45%. As you see, I'm starting to synthesize again the operation of what I call the discrimination to incarceration pipeline. So what you see is, in addition to lots of exclusion in employment settings, a lot of challenges that people face, even securing housing, which again starts to fuel their participation in criminalized economies. Originally, with a thought that I'd have a little bit more time, I wanted to take you through some of the experiences that TGNC people have when they're experiencing homelessness. Suffice it to say, it's a lot of abuse and a lot of things that heighten their vulnerability and actually increase, again, their participation in criminalized economies. My organization, the Center for Constitutional Rights, has been active in this space of trying to do harm reduction in the homeless shelter context and make shelters more welcoming to TGNC people. But typically, the problems you hear about are things like sexual and gender-based violence, harassment, abuse, discrimination. You have transgender women being told, if they're even allowed into shelters that accord with their gender identity, that they have to sort of perform sexual favors or other types of favors to staff to kind of remain there without being evicted. It's really a tremendous problem that, again, fuels people's participation in criminalized economies for survival. I have been representing a client who, because of discrimination she faced in the homeless shelter system when she was most vulnerable, actually resorted to survival sex work and living on the streets because that was, albeit a criminalized means of survival, a more dignified way of living than the homeless shelters that were available. And so that leads us to the topic for today, which is the ways that discrimination fuels participation in the system of mass incarceration for the TGNC community. A very disturbing statistic is that a shocking 47% of Black transgender people and more than 1 out of 5 transgender women of all ethnicities will be incarcerated or report experiences of incarceration within their lifetimes. Oftentimes, we see that the bases for these folks' incarceration is their involvement in poverty-related and survival-related offenses, such as theft and survival sex work. In addition, trans people are profiled oftentimes and arrested in ways that are familiar to many of us for other minority communities. But oftentimes, in this case, it's on the suspicion that they are sex workers. And so you'll see people who are entering the system of mass incarceration, or at least prisons and jails, based on the enforcement of archaic loitering laws, like the Walking While Trans bill that was only repealed in New York after really sustained community effort. Now, once incarcerated, and this is going to be a theme, I assume, of this panel, TGNC people face really unconscionable prison conditions. That includes violence and neglect, medical neglect, because oftentimes their gender-related healthcare needs are severely underserved and neglected or treated even as cosmetic, although they are known, the failure to treat things like gender dysphoria are known and established push factors for suicide ideation, suicide attempts, and other medical conditions that, like all other health conditions under the 8th Amendment, require medical treatment. You also see really outlandish rates of sexual abuse and sexual assault from TGNC people, particularly transgender women behind bars. This is an instance where the abuse is not exclusively at the hands of prison officials, but certainly with their permission, with their neglect, and because of their deliberate indifference. So the work I do is aimed at disrupting and dismantling the discrimination incarceration pipeline. My career has sort of taken me on that trajectory. It has involved everything from trying to strengthen laws, respecting sex discrimination in employment, which we ultimately as a movement achieved with the Bostock decision, such that this nexus of having to basically figure out what type of Black economy or criminalized economy you're going to enter to survive is not such a specter for TGNC people as it has been in the past, where, in essence, people really felt a lack of options. Because, and I got to see this firsthand as an employment discrimination lawyer, the belief that transgender people were not protected by the law led to really, very open and opaque, transparent rather, instances of discrimination against them, including people, again, just being told, for instance, I have had clients be told at the point where they're, after being offered a job, but at the point where their identity documents are being scanned and perhaps as a discrepant gender marker, oh, well, you perpetrated a fraud on our company, we don't hire people like you, basically this is your last day. Some of that work, in addition to employment, has been in the homeless shelter context. Again, I'm not going to spend as much time here because I really do want to get into the meaty issues of the challenges people face in prisons and jails, but this is a case that my organization successfully settled this past year that creates new shelter units that serve and affirm transgender people in the 4 New York City boroughs, because we were seeing this really consistent nexus between unsafe shelter conditions and, again, people opting out of the homeless shelter system and into more dangerous means and modes of survival. With respect to prison conditions themselves, I want to take you through the case of Ashley Diamond, who is both a current and former client, and someone who has been very outspoken, albeit at tremendous cost, about the ways that transgender people are persecuted and subjected to state violence in incarcerated settings. This is Ashley. She's a Black trans woman who grew up in a rural town in Georgia, who, like many of the clients I've served and like many of the community members I've been describing, after coming out as transgender, experienced periods of homelessness, was consistently denied jobs because she was trans, including instances, again, of being hired and fired within a matter of days just because it was, revealed that she was transgender. Ashley Diamond, as a result, is in prison right now because of quite literally writing about $500 of bad checks and pawning a saw that was believed to be stolen. The pawning the saw charge was charged as burglary, even though there was no evidence that she was involved in removing it from the rightful owner. And the bad checks charge was charged as theft. It resulted in, despite her being a first-time offender, a 12-year sentence in Georgia. Since her incarceration began in the early 2010s, Ashley Diamond has been sexually assaulted at this point, I would say more than 24 times by incarcerated people. She has been told by prison officials in Georgia that, what does she expect? She's trans, she should, stop being effeminate if she doesn't want to be abused. In her first litigation against Georgia, there were prison officials that actually told her to guard her booty and prepare to fight, because that was the extent to which they planned to protect her from sexual violence. And in addition to that, Ashley Diamond was severed from all of the healthcare that she requires for her survival as a trans woman, including hormone therapy, which is a very inexpensive, highly effective means of treating gender dysphoria, albeit not in isolation, not without things like being able to express your gender, which is one of the subjects of our current case. Now, the problems that Ashley is facing are unfortunately very typical in prisons. We have heard from so many people in Georgia and elsewhere since our litigation on behalf of Ashley began. And the types of legal challenges that can be made about conditions like these are well settled to some extent, but again, the challenges that litigators face in a hostile judiciary are vast. This slide indicates some of the challenges that are available. Obviously, Eighth Amendment is really a tool in every prison litigator's toolkit, but there has been an attempt, at least in the case of transgender people, to also look at claims that might be available under the Americans with Disabilities Act, the Affordable Care Act. And as this clinic can say with confidence, there's also been attempts, however successful, to bring sexual abuse claims under the Federal Tort Claims Act as well. Again, that's not without challenges. Farmer v. Brennan, which, as you may know, was actually litigated and brought by a Black trans woman who, like my client Ashley Diamond, experienced sexual abuse in prison, is an increasingly challenging standard to litigate under, with qualified immunity and the Prison Litigation Reform Act being additional barriers. All that said, we have had some success in Ashley Diamond's cases, including in 2015, when her first lawsuit against Georgia commenced, a reversal of Georgia's policy at the time, which amounted to a blanket ban on initiating gender dysphoria treatment to people who were incarcerated, including hormone therapy. The Department of Justice under the Obama administration, and sorry, my slides are a little delayed, became an ally in that fight and did issue a statement of interest, which is their version of an amicus brief that explained that just like cancer treatment, hypertension medication, et cetera, that gender dysphoric treatment was medically necessary care for a serious medical need. Unfortunately, our litigation against Georgia has continued because what we've seen is that, I'm sorry, it's catching up. In essence, they took the admonition to, at a minimum, commence hormone therapy for transgender inmates to be a ceiling, not a floor for care. And so now we're dealing with a regime where you have, incarcerated people across the state being able to access hormone therapy, but they're still being housed, not in accordance with their gender identity under any circumstances that we're aware of. They're not being able to access any sort of gender affirming care in the form of gender expression, clothing allowances, et cetera. And so you have people like my client, Ashley, who also, by the way, has been denied access to even, facial hair removal. She had to fight to get permission to even shave more than, twice a month. She basically describes herself feeling like she's a bearded lady because she's a curvaceous, woman, very feminine in a men's prison where she's constantly being abused, growing facial hair that she doesn't want because, being called a man in a man's facility day in and day out, because again, somehow this perverse reality for Georgia represents satisfaction of a constitutional standard. What I will say, and I'm convinced I'm running out of time, is that bringing prison litigation cases, prisoners' rights cases, is becoming harder, not easier. The Trump reorganization of the federal judiciary has made its mark. We are before the same judge in our current case, which is challenging the fact that despite at this point, again, about more than a dozen sexual assaults and abuse incidents and our client's ardent request to be placed in a female facility, that there's been no serious consideration of that request. And again, no attempt to offer her healthcare besides hormones therapy. We're before a judge who 7 years ago, wrote a 92-page decision about how qualified immunity didn't apply in the context we allege here, where Farmer and Estelle v. Gamble are implicated and the rights of a transgender inmate to healthcare and safety are concerned. This judge 7 years later is sending everything to a jury trial, doesn't want, has made it very clear he's afraid of being reversed by the 11th Circuit, which is now a very hostile place to be bringing plaintiff side litigation. What does all that mean? Apart from the fact that I'm out of time, it means that, prison rights litigation is more important than ever for all of our communities, particularly and including at the intersection of race, class, poverty, and as you now know, gender. I applaud you all for being in the fight or being interested in it. We need these cases to go forward, and we need to be unafraid, deliberate and afraid of nothing, including losing, because we will probably lose along the way. But again, representation matters. Thank you.
We're going to hear next from Alexander Klein and Claire Kiefner, both of whom we're proud to say are graduates of this law school. They're going to be speaking on taking the Prison Rape Elimination Act seriously and setting clear standards for identifying and protecting vulnerable prisoners from sexual violence. Mr. Klein is an attorney with the law firm of Cuisinot, Van Bergen, McNee, and Malone in Minnetonka, Minnesota. As part of the University of St. Thomas's appellate clinic, he briefed and argued a case in the U.S. Court of Appeals on behalf of a transgender prisoner who had suffered a violent sexual assault due to neglect by prison officials. He was also a student attorney with the First District Public Defender's Office in Minnesota. During law school, he served on Representative Dean Phillips' successful re-election campaign as his communications intern. Ms. Kiefner is an attorney with the Minneapolis law firm of Lewis Brisbois. As part of the appellate clinic, she briefed and argued a case also in the U.S. Court of Appeals on behalf of a transgender prisoner who had suffered a violent sexual attack due to neglect by prison officials. So we thank you both for coming back to your law school, to your alma mater, and look forward to your presentation.
Thank you so much, and thank you all for having us. It's really such an honor and a privilege to be here. As was just mentioned, we're really going to be talking about the case that we worked on with Professor Sisk during our time in his appellate clinic. And this mostly fell under a law called the Prison Rape Elimination Act. So I'm going to start by giving kind of an overview of what that law is and what that statutory structure looks like.
Alex is going to talk to you about how we applied that in our case and how that applied to our client. And then we're going to talk through some of the problems that we encountered and some of the solutions that we think might exist. So in terms of the background, like I said, we're talking about the Prison Rape Elimination Act, otherwise known as the PREA. And this is a statute that was unanimously adopted in 2003. And it said that it had the goal to detect, prevent, and punish prison rape. But the statute as written, that sounds great, but the statute as written did not do a lot of what it promised. It called itself a zero tolerance policy for prison rape, but clearly we're here in 2022. This was adopted in 2003, and the prison rape statistics are just as bad, if not worse. So as written, the statute did not necessarily serve as some sort of method to punish or prevent, but rather it was mostly a data collection mechanism. It had prisons, federal prisons, collect data as it related to prison rape and sexual assault, and then report that data in order to receive some of their federal funding, which is of course helpful because it's good to know what are the problems and where are the problems. But the statute came into being in the first place because we knew that there was a problem, and the statute alone was doing very little to address that. So then in 2012, we get closer to a solution when implementing regulations for the PREA are put into place, which theoretically give a lot more teeth to the PREA. They're quite lengthy and they provide a lot of guidance about how we can prevent, detect, and punish prison rape. They're broken into different sections for adult prisons, for lockups, for juvenile facilities, which in theory should all be great, but we still found a lot of problems with those regulations that make it difficult to both prevent and punish prison rape. One of the first is that they lack adequate substance and context. One example that we run into in our case where we're defending or when we're working on behalf of a transgender inmate who was sexually assaulted, theoretically, she ought to fall under the category of what constitutes a vulnerable inmate. As you just heard from our first presenter, transgender inmates in prisons are most vulnerable to sexual assault. However, within these regulations that should be seeking to protect vulnerable folks, the only part of these regulations that has any sort of meaningful guidance as to how to help vulnerable inmates shows up in the lockup section, but not in the adult prison regulation section, juvenile section. So we're leaving a lot of gaps for some of the people who are the most vulnerable. Second is that this is treated as a highly deferential standard. And this is what we've been talking about almost all day at this point, is that we can have these regulations and we can have these policies, but at the end of the day, when they end up before the court almost always says the prison officials had the discretion as to how to implement these regulations. They said they did the best they could. They thought one guard was enough, and that's the end of the story. And last, another problem that we see is even beyond just this prevention, even once we get to the point where there is some sort of cause of action, there is no independent cause of action under the PREA or the implementing regulations. So there's almost no recourse for any prisoners who have suffered any sort of harm. And again, this is going back to what we've been discussing all morning, is that it's very difficult to get a court to listen to a prisoner and to be able to accept their claim. And we really only see success under the most egregious circumstances, usually under the 8th Amendment, and not necessarily under this statutory or regulatory scheme. So with that, I'll turn it over to Alex, who will tell you a little bit more about our case and our client.
Well, first off, thank you to everybody who's spoken already. It's a hard act to follow, and it's important work that everybody's doing. But actually last year, as part of Professor Sisk's appellate clinic, Claire and I had the opportunity to represent a transgender woman that was at the time housed at the time of her attack at United States Penitentiary in Tucson, Arizona, which you all have heard a lot about Arizona prison systems today. USP Tucson is actually the most notorious federal prison for sexual assault in the entire country. It happens at a rate, I believe, somewhere around 2 times as much as the second most notorious federal prison. And in 2016, Ms. Gladney, who was our client, suffered a brutal sexual assault while in confinement. She was forced into a housing unit in her section held at knife point, threatened with death, and brutally raped. As part of her claim, she filed a Federal Tort Claims Act case against the United States government. Somewhat surprisingly, she was able to litigate that herself all the way into federal court, surpassing the PLRA threshold, and it was dismissed on summary judgment, which is where we came in when we took her appeal. As part of that, we raised a couple different arguments. First, that the national standards that Claire mentioned were binding on the Bureau of Prisons, and that a violation of a mandatory regulation constituted or forfeited discretionary immunity under the FTCA. And second, that failing to provide adequate protection to her while in prison was a violation of the Eighth Amendment and constituted deliberate indifference. Unfortunately, we were unable to succeed on either of those arguments for a lot of the reasons that have been brought up today about the hostility of the federal judiciary to claims raised by inmates and particularly raised by transgender people. So first off, kind of along the same lines Claire mentioned, the national standards were held to be discretionary entirely, which despite using language such as shall provide constant supervision and other language, similarly, they were held as discretionary. Two, that those only applied in lockup facilities, which seems kind of backwards because those are facilities that house inmates for usually 24 to 48 hours, whereas the people that actually need the most protection are in adult prison facilities, and those don't even include the same mandatory guidelines. And second, the Ninth Circuit acknowledged that the district court erred by not addressing the Eighth Amendment argument raised by our client in the district court, however, held that it was harmless because she did not fall within a particularized group of vulnerable person, which to me makes no sense considering the Farmer versus Brennan standard acknowledges that transgender people are vulnerable. The Department of Justice acknowledges that in all of their prison policies, and the fact that she pointed out individualized risk factors to herself beyond just that of being transgender, still held in about a one-paragraph opinion that was a harmless error. So clearly there are a lot of issues with prison litigation. And with that, we'll kind of move on to, through our article, we have come up with a couple solutions that we think might provide some kind of help in that area. First off, adding a private cause of action under the PREA. Even doing that right now, every federal court nearly unanimously has refused to accept any argument raised under the PREA at all in a one sentence saying that there's no independent cause of action and therefore provides no considerable standard under any cause of action that you might raise, including the FTCA. However, as we've mentioned, I think Professor Sisk mentioned, even adding an independent cause of action may be inadequate, as courts will still consider it, be considered hostile to inmate litigation. And the second thing that I think I've found the most striking when doing this research is how the federal courts will, in the same opinion, say that the PREA does not provide an independent cause of action to forego any argument made by a prisoner. However, in the same opinion, will use it to justify the government's behavior. So one case I found especially striking was a religious liberty case where an inmate wanted to have prayer oil, and that was withheld from them. And the government's justification for that was that it could be used as a lubricant for a sexual assault of another inmate. And the court accepted that as a justification for infringing on somebody's religious rights because it may violate the PREA. And the court was perfectly happy to accept that justification while also saying that the PREA means nothing for an inmate who suffers a sexual assault.
And then the second thing, on top of just adding an independent cause of action, of course, it's important to try to formulate some sort of strategy to be able to give aggrieved prisoners some sort of right to recover. But I think probably even more important is to figure out how to detect and prevent this from happening in the first place in order to actually protect these folks who are in confinement from sexual assault and from sexual violence so that we never really have to get there. And so I think one of the most important things to do is to be reconsidering the content of these enacting regulations, seeing what do they actually say, what is really happening in each of these facilities, in the lockups, in the adult prisons, in the juvenile facilities, who is being harmed, and what can we do to prevent that? And Alex kind of teed this up. We see these regulations for vulnerable inmates showing up only in the lockup sections of these regulations, which tend to be smaller, with more direct oversight, fewer people, and for shorter terms of confinement. Whereas then you go to an adult prison, which is a larger facility, longer term, with less direct oversight and vision throughout the facility, and we remove all the protections that are in place in the lockups for inmates who are, by definition, vulnerable underneath the terms of the regulations. So I think it's really important for us to be looking at these regulations with a critical eye, seeing where are these problems taking place, who are these problems happening to, and what can we do to actually provide meaningful, heightened protections to vulnerable inmates. So, and this is of course very delicate. There's no sort of one size fits all solution. The solution that's in the lockup provision right now says that there needs to be direct and continuous sight and sound monitoring of vulnerable inmates. Of course, that poses even additional problems of people are going to be losing their access to their right to privacy when we give them this right to be protected. So there's not necessarily one perfect one size fits all solution, but when we're looking at what we can be doing, we need to be thinking about what is the content of these regulations, who are they protecting, and are they actually binding on any sort of actor such that we are protecting folks and then giving them a right to recover in the event that we're not. Thank you.
Thank you, Ms. Kiefner and Mr. Klein. Finally, we're going to hear from Kenneth Udoybach, who heads a law firm in downtown Minneapolis. He represents victims of police brutality as well as people charged with in the criminal justice system. Among his most prominent cases currently, he's representing 2 Minnesota women who sued the federal government on claims that a federal probation officer solicited sexual favors while he supervised them. Sir.
Thank you. Good luck. That's a legal theory. And it's what you need if you want to represent prisoners or you want to have a case against the federal government. In this case, I needed luck. I got lucky when the 2 jurors involved in my case as Chief Judge Thunheim and Judge Richard Pratt in Iowa. But I'll just live through this. The outline is not in any particular form, but it'll facilitate this discussion. I'm going to talk about 2 cases. And the purpose of that case is those cases would confirm the notion that you don't need facts, you don't need law to win these cases. You need good luck. So it started with back in 2014, where I actually started the case in 2013 against the federal government relating to Donna Buck v. Curtis Majeski at the Women Correction Facility in Waseca. She had no choice but to engage in oral sex with a guard. At one point, she got frustrated and preserved some DNA. And turning that DNA, an investigation ensued. Of course, I was called and I thought, of course, this is respondeat superior, not knowing that it's not applicable in the federal system. Well, then come this other case. 3 women two Black women, Aisha McKinney, Tracina Ross, Black, not that it's relevant, and Tammy Bloomer. Both had been previously convicted, and they were into their second crimes. Aisha was involved in bank fraud. Tracina Ross was a drug conviction, and Tammy Bloomer was also a drug conviction. I lifted the complaint, fearing that I don't know what the audience is going to be like. I didn't want to leave here and get sued. So everything on this slide is taken from the court records. So we moved, in this case, this Aisha McKinney case, we moved on Federal Tort Claims Act and Bivens action. Well, now these are the facts. We talked about bank fraud, and she pled in the criminal case before Judge Thunheim. And Dennis Bresnahan was her probation officer. Of course, you know, Federal Probation Services report to the court. Now, we allege that Bresnahan demanded sex from McKinney. Anyone can allege anything, right? But we had recordings. He asked her for pictures of her having sex with her girlfriends. She faked and sent him something from the internet. And he insisted on her sending him pictures of her breasts feeding her newborn. But it got more serious. Remember, Ms. McKinney is on post-conviction release. He demanded more. And this time she recorded their conversation, and he demanded that. Well, there's a history with McKinney. She had suffered a gunshot wound when she was about 14, still dealing with sexual assault. That's part of the court record. And so this incident with Bresnahan was significant in her life. Now we have Tracina Ross, same thing, same probation officer. And he wanted to vacation with her in exchange for some favorable conditions. There was touching, caressing, and then he had this fascination with a threesome. During his deposition, I asked him whether he had any idea who the third person was going to be. And he enjoyed it. That's part of the deposition transcripts. Of course, those conditions exacerbated her mental illness. Now, Tammy Bloomer was, compared to McKinney and Ross, was a little older. Bresnahan supervised her between 2010 and 2016. Also, this is how he phonetically pronounced his name. When he called her to introduce himself as her supervisor, he defined or pronounced his name as Dennis Breast in Hand. Well, you see, all of these things, he forced her to engage in oral sex, and also wanted threesome too. So she wasn't enough for him. Now, what was my cause of action? Well, you could go forth eighth, and eighth is the federal. Why did I go with eighth? as well as 14th, was because McKinney was post-conviction. And I don't have enough time, but McKinney had to go into custody because of Bresnahan. She was pregnant, and Bresnahan caused her to violate her conditions for release. So she voluntarily went into custody to be away from Mr. Bresnahan and had a baby the day she was released, I believe. She had a baby. So that's why the interplay between 14th, 4th, and 8th. Well, so the state cause of action was assault, battery, and abuse of legal process. So this is where my client's depression was caused by the law. You know, we couldn't sue the federal government back in 46. I wanted this definition for us to know that you can sue the federal government by way of state claims. However, sexual assault can happily be recognized as essential scope of employment. So you're left with this, the liability that comes from Federal Tort Claims Act. Now, I brought this up as an issue. This is taken from Judge Pratt's order. You don't know who you are fucking with. The court agrees that the statement is threatening. But then Judge Pratt made the statement that he wasn't sure that that statement was apprehensive enough to justify assault. Well, when a probation officer says that you don't know you were fucking with, you've already been in custody for 6 months. And he says that after he solicited sex from you, I think a reasonable person would view that statement as serious enough to warrant compliance. So the alternative, I made the novel idea of finding a way to go to indirect battery. And the judge said, take a hike. No way, that cannot happen in America. So then I was left with, maybe I can get through this by abuse of process. It is pretty clear that these women, condition of release by the federal court, were converted into Mr. Bresnahan's personal interests. I thought that was clear. Probation or pretrial services or conditional release, those are all processes. Well, the court defined it otherwise, that cited a Minnesota case that it is not, that pretrial release cannot be a process. So, I know that's a little wordy. What is interesting in this is the court agrees that Bresnahan had converted pretrial release process to his personal gain, but there was no chance. So I decided now, maybe I can go after Mr. Bresnahan by way of Bivens individually. Now I've lost the United States. So maybe our luck would change. I went through the process and the court says, no, it's not going to work. So my luck is running out at this juncture. And I thought when I started, I had physical evidence, I had recorded conversations that should not have been an issue of contest. I'm going to skip through some of this. When I realized there was no way, now the law is giving my client depression. I'm also depressed. So what do I do now? So the court says, I want to make sure I have 5 minutes left. All right, I'm going to just race through this. I'll speak with a quicker Nigerian accent. So he says the Tort Claims Act is the alternative to Bivens. All right, I agree. Really, I thought it wasn't available. So now they're kicking the dead horse. The court goes through the process of Bivens. And then when Judge Pratt cites a court in Texas, I thought, okay, this is not going to work. That's for your interest if you want to see that case that says Bivens is not going to work. But I take consolation. This is the case that I read and plotted my strategy, but didn't work. So the only claim left for us to go to trial on assault and battery on Ms. Ross's claim. Now we're at the bottom of the ninth. I thought, okay, at least I'm going to have a trial. And this is one of the experts that the federal government produced, the chief judge of Minnesota, who, this is the federal government's disclosure, to offer testimony on this important fact that is not a well-known risk in the profession that probation officers would sexually assault their probationers. So I was exhausted. And we settled with enough money to have dinner at McDonald's. So will I do this again? Of course. Thank you.
Thank you, sir. Thanks to all our presenters. I want to just start the discussion because I'm pretty depressed too now at this point, by maybe offering a meta comment here. It strikes me that all four of you, in speaking about your clients, have represented people of color and transgender people. What role, if any, do you think systemic discrimination, which we've had a lot of discussions about in this country and in this state and city in the last 2 years, what role has that played in how your clients or potential people going into the system, how they've suffered? And if it has played a role, what can be done to address that?
I'll take a gander. I think if you can hear me, I mean, my presentation really centered, put front and center societal discrimination as push factors to mass incarceration. I think there's another component of it, though, which is the callousness with which we view people who are incarcerated. I think also comes from the availability of narratives about criminality, which are so deeply linked with race and class, where we sort of think of people who are incarcerated as deserving the punishments that ensue, and it's unmistakable in my mind that really comes from sort of, systemic racism, as in case of my clients, the way that intersects with transphobia, But I think there's a belief that the people who are behind bars don't have value, to begin with, right? And there's something already less substantial about their claims of constitutional violation and what have you. Prison rape jokes, don't drop the soap, like that's still part of our common vernacular, right? And it also shows up in the litigation itself. Right now, if it wasn't clear from my presentation, I've litigated against Georgia twice. The first time we had a settlement, my client went home. State supervision, as you see, is really a minefield. She's back in prison for quite literally going out of state to access specialized healthcare without letting her parole or her, parole supervisor know that that was what they charged her with. And that was enough to basically be back in prison with her entire remaining sentence reinstated. And, what the lawyers are doing for the state of Georgia the second time around is they're litigating her worthwhileness as a person. They're saying, well, look, she got a disciplinary report last month, and we saw her talking to some inmates in the hallway. Are we sure that she really cares about her safety? If she's not following prison rules, we don't, therefore we're not liable. And I'm like, so you're telling me that Farmer v. Brennan is a conditional right extended only to well-behaved prisoners? Like, is that really the position you're taking? And, of course that's legally erroneous, right? But the point is it works at a narrative level to sort of tap into the latent disgust that we have for people who, we are sort of willing to throw away under the label, the weight, the burden of the label of criminal, So thank you.
I have something to add as well. I think systemic racism obviously plays a big role in who is actually incarcerated in the first place. I know from Shinieri's presentation, it starts at, kindergarten detention or being kicked out of kindergarten, elementary school at a disproportionate rate. It starts with employment discrimination, where you can't work and you become homeless, and then you resort to survival crimes like theft and survival sex work, which ends you in prison, where then you are also at a disproportionate rate assaulted while in prison, treated with less respect and human dignity than other people in general. So I think you need to address situations that arise long before you even end up in the incarceration pipeline. And I know there's a lot of really good advocates that are doing that work. So I think starting early, even if you look at the presentation on prenatal care in prison, it starts with taking a baby from their family. That's another way that the incarceration pipeline is furthered before you even have a shot at life. So I think those are all issues that need to be addressed as well.
And one thing I'll add is that, and unfortunately, this is more of a question than an answer, but we've talked a lot about today bad actors in these prisons and in the system. Maybe it's an assaulting probation officer, maybe it's a bad doctor, maybe it's a negligent guard. You have all these people who likely inherently do believe some sort of racist, sexist mindset that's going to perpetuate harm against these folks who are already within the system that's already against them. And something I'm always struggling with, and I don't know the answer, is how do we get good actors into the system to help protect these folks and advocate for some sort of change and get the bad actors out? I don't know, but it seems like if we could, it might help.
I don't know what the question is.
Systemic racism.
I intended to avoid, it's a long story. It's the entire, I'm a foreign born, and so I look at this country differently, but the so many things so apparent that yet nothing is wrong. Of course, there's racism in everything. Of course. From when you were arrested to the prosecution and the nature of your representation, and ultimately you go to prison and you're viewed from that prison. The outcomes are predictable. So
Thank you for helping us understand the dehumanization of people in the system, which starts at a really early age. We'll take questions from the audience, 7 minutes. Yes, over here.
Thanks. I was just curious from Mr. Udoybach to know whether the probation officer was represented by the federal government the whole time, or if he was on his own, or if he had a private lawyer, and how those sorts of things played out.
So that's a very good question, because starting out, the FBI was involved. So I was dealing with the FBI. One thing that was good that the U.S. Attorney's Office in Minnesota did was once the event was public, the FBI got involved, and then some local U.S. attorneys got involved, and they turned it over to Washington lawyers. And Judge Thunheim, conflicted the case out to Iowa. So he ultimately, when it came time for discovery, he obtained a private counsel. And I wasn't sure whether the government helped in paying his bills. That got a little convoluted during the discovery process. So.
Other questions from the audience? Do the panelists have questions or follow-up comments based on what you've heard today?
I had another observation, which is, the Prison Rape Elimination Act, I call it PREA because I talk about it a lot in my legal work. It's a nationwide standard that is supposed to be keeping people safe. It talks a lot about the way people are supposed to be screened for the potential risk as a victim of sexual assault. It talks about how in the case of transgender people, there should be consideration given to where they'll be most safely housed, and that consideration should include their own opinion about whether they should be placed in a male or female facility. The fact that courts have so uniformly found it to be toothless is well known within the prison system, and if anything, the way I've seen PREA implemented is on one hand to sort of criminalize consensual relationships between prisoners, that will get you, thrown into the segregation in no time at all, and with all the penalties that befall you. And then the second thing I've seen is it's almost become a game to sort of see how quickly you can unsubstantiate PREAs, because as my co-panelist pointed out, there are what is clear is that there are these kind of annual reporting requirements that prisons are now held to, where they basically have to report out how many allegations of sexual assault there are and what the result is, and, my client, Ashley, we've filed PREA reports on her behalf, reporting in detail instances of sexual abuse, describing how we believe there's cameras that exist that would have, captured it, so forth and so on. In discovery, we're now seeing that, she never got responses about where those investigations stood. We now learn that almost every single one of them was marked unsubstantiated or unfounded. Unfounded is a phrase that's supposed to be reserved for, we can prove that it didn't happen. The cases where they can prove that it didn't happen include one instance where, for some reason, they closed the investigation. Our client experienced and reported that she experienced 4 sexual assaults over the course of one weekend in her completely understaffed dormitory, where, one officer is manning, three buildings at best. They marked her PREA complaint unfounded, as in we can prove it didn't happen. One day later, they never reviewed video. They never spoke to our client. They never spoke to us. We actually made the PREA report on her behalf as a third party. They never contacted us for information. There was no investigation that happened, and they marked it unfounded. There was one assault where the assailant actually confessed that he, entered our client's cell and groped her. And they marked that initially unsubstantiated, unfounded. There was, she was assaulted by a nurse, a member of staff who decided, well, unfortunately, two members of staff, one who locked her in a closet for several hours. There's another security guard who witnessed her who saw her in the closet with this other officer, saw that a makeshift bed was out. That was somehow also unsubstantiated, unfounded. And then there was a report that she made that a nurse basically, I'm sorry to be crude, like jiggled her breasts and said, "Are they real?" Also on camera, also in front of a crowd. Another corrections officer wrote a statement saying, "Yeah, I did see the officer touch her chest, but she didn't complain about it in the moment." That too was marked unsubstantiated. And so another litigation tactic that we're seeing in this case is they're literally like, well, she claims that she's been assaulted, but we don't know under Farmer because we've marked all of her claims unsubstantiated. And it's like, but how? So again, I think that these numbers almost become like, I don't know, bingo or Jenga. It's like, look, we got, 400 reports of assault, but we didn't actually believe any of them happened. You can't make us say that they did happen. So our prison's safe. And like, we're seeing that all across the state.
Yes.
I just really want to just make comment on what you just said, which is really moving and insightful and helpful. Just two quick things. One is, I mentioned the findings letter from the Mississippi, the DOJ findings letter from the Mississippi Parchment Farm investigation. And I've only had a chance to get through the first half, but they talk a lot about what you're saying, not in the PREA context, but just in terms of the use of force packets that are supposed to be, investigations are supposed to be done, and they're just repeatedly not doing them, partly because of understaffing. And the other thing is, I know you know this, it all depends on whether a court is willing to hear the case, but, Farmer says this is not a standard to protect willful ignorance. You have just illustrated to us, how strong your case would be for, even if they are claiming that they didn't know. It's not even willful ignorance because they're not ignorant, but they're drumming up fake evidence to suggest that they didn't actually realize the risk. If you had courts that actually took these claims seriously, you should win on every one of those cases. The problem, of course, is, you add up staff who are non-responsive or even obstructionist with courts that, as you say, don't take your clients seriously as human beings who deserve a fair hearing. And then you end up with defendants winning, not because of the law, but because the system is not working. So I really appreciate
I would just add, because to not beat up on my judge too much, I think he, 7 years ago, he cared about these issues. Like, he does not want to be reversed by the 11th Circuit. And like, he's made that so clear, so our motion for preliminary injunction has now been converted into an expedited jury trial in Georgia on whether a trans woman should have had safekeeping in a female facility. So we know where that's going, and it doesn't matter if as a legal matter, we should prevail, So it is, I had more time, I would have really sort of tried to dig into the challenges of this, this changing judiciary, because I do think the composition of the Supreme Court, the appellate courts, is having a chilling effect on district judges too,
Thank you so much to our panel, and thanks to all of you for coming this afternoon. Let's show our appreciation to our panelists.
All right, welcome back, everybody. My name is Mark Osler. I teach here. I'm fortunate to be a colleague of Greg's. And one announcement, if you are up in the overflow room, we have some room here in the courtroom, so feel free to come down and be an eyewitness to everything that's going on. This next panel is officially titled Other Issues in Prisoner Rights, which is, it's the big box of miscellaneous that we all have in the basement, although that's where the most interesting things usually are. And we're going to be hearing from people from very different backgrounds and significantly different topics that are, of course, related by the theme of the conference as a whole. Our first speaker today is going to be Andrea Armstrong on carceral secrecy. And Professor Armstrong is the Law Visiting Committee Distinguished Professor of Law at Loyola in New Orleans. She's a graduate of Yale Law School, and she founded incarcerationtransparency.org, which provides facility-level deaths behind bars data and analysis for Louisiana and memorializes those lives lost behind bars. She's also the lead investigator for the Deaths Behind Bars in Louisiana project. And obviously, this gives her a deep background in the subject of her talk, carceral secrecy.
Good afternoon, everybody. Thank you. At least some of y'all come from the South. So good afternoon, everybody. There we go. So I am delighted to be here with you today, right? So I started writing about prison conditions and how the Constitution operates within prisons, I think in 2010 or so, right? And I wrote a piece really early that talked about the value of transparency, and these are public institutions, and right? And now 10 years later, I find myself kind of full circle, because what's become clear to me is that it's not just about transparency. That is an important way of talking about what happens behind bars, but it's also about secrecy, and that the secrecy is not accidental. And so I was delighted to receive this invitation because it gave me an excuse to explore a new idea. It takes me away from some of the empirical work that I've been doing, and lets me really think and step back about these ideas. And so I want to do a couple things with you today. First is just talk about incarceration in general, because a lot of times we don't have a lot of nuance in what we talk about and how we talk about it. I want to start previewing this idea around carceral secrecy, and I would love your feedback and ideas, because this is very much early stages of a draft paper. Thinking about some law-created secrecy, right, towards kind of the public, and thinking about it within three frames, and then last, some takeaways. So, I usually start with this idea that prisons and jails are supposed to be very different spaces, right? So for those of you who know, right, so when we talk about prisons, it's usually about the Eighth Amendment. When we talk about jails, folks who are pretrial, there are ostensibly different legal standards. And yet the picture on the top is from extended lockdown in Angola, which is Louisiana State Penitentiary, one of our largest maximum security facilities. And the picture on the bottom is a local jail, the New Orleans jail. And I've had this experience myself. I walked into a maximum security Colorado prison once, and I was like, oh my God, this feels exactly like the brand new jail that we just built in New Orleans. Same design, same like cookie cutter design. And so there is a difference between the two. But at the same time, we have to understand the commonalities between these two types of institutions. And I say this in part because when we talk about carceral secrecy, I am talking about all of the institutions that have bars in them. Okay, so that could include youth prisons, that includes civil detention centers, our private prisons, our local jails, our police lockups. We have a lot of different types, and yet they look very similar. The second part that I want to talk about in terms of this carceral overview comes from some research I did a couple of years ago, particularly thinking around justice reinvestment initiatives and the ways in which we talk about criminal justice reform. And so everybody's like, yes, criminal justice reform. And I'm like, okay, so, but that only hits 2 out of the 3. So arrest, trial, stuff happening pre-trial, we do pretty well. A lot of money, a lot of effort. And in fact, some new laws have gone into addressing what happens pre-trial, right? Whether someone is convicted or not. And then a lot of effort has gone into reentry, or what happens on the back end. And yet, in a survey that I did around the 33 implementing states under the Justice Reinvestment Initiative, not a single one addressed the conditions of incarceration. And so my thinking along these lines is, listen, we could design the gold standard of reentry programs. We really could, right? And we heard some ideas for that just now during our keynote luncheon. At the same time, even a gold standard package will not be able to address 5, 10, 15 years of torture, right? And so we have to think about conditions of incarceration within this broader criminal justice reform. And that gets to our ideas, or at least my initial ideas around carceral secrecy. So I spend a lot of time in prisons and jails. This is the house of detention. It's in the New Orleans jail. I was born and raised in New Orleans, moved away for a while, moved back. This building has been or was in place since 1965, and I did not know that this existed on the second floor. So the house of detention on the second floor. It's on the door. So I didn't know that these existed, and yet I knew people after the fact who had been held in there. So one friend told me that he spent a month in that isolation cell, which is smaller than a regular cell, right? And which is hidden, tucked away on the second floor. So the majority of the cells are all in the 10-story building, right? And that traditional tier design that, you know, was a big part of our building boom in the 60s and 70s. These were just tucked away. There's no space on this hallway here for any sort of observation, for any interaction, for access to natural light. And so how are we keeping these things secret? Because they are in fact secret. Take this example. This is an outdoor rec yard at Angola. And this is where a friend of mine, Glenn Ford, who was on death row for 29 years and was eventually released and then passed away 15 months after that. But that is a whole nother story. He refused to go outside for the last 7 years of his sentence because he said he refused to be treated like a dog, right? There's no shade, there's no water, there's no privacy. And so this is out there in the open. And yet the fact that we cage people like this by virtue of what they are convicted of, right? So he was simply sentenced to death row. There was no other kind of solitary restriction or housing assignment put on him. The fact that this is what he was allowed to do, it's interesting that this is secret and yet it is open and outside. Moreover, why is this stuff secret, right? So when we think about people, enormous amounts of people are impacted by prisons, jails, youth prisons, and detention centers, right? So we know 2 million people are behind bars at any given point in this country. 1 in 7 children in Louisiana has an incarcerated parent. Over 10 million people nationally have someone that they love behind bars. We know from the Bureau of Labor Statistics that almost 500,000 people work in correctional, as a correctional officer, right? So that doesn't even include all of the medical staff that is in there, right? The social workers, the people who do facilities and sanitation, right? So we have millions and millions and millions of people in this country who go in and out or who are impacted by these places, and yet we know very little about them. Spaces, there are almost 5,000 carceral spaces here in the US, right? We have more prisons, or at least more carceral spaces than we do colleges. And in Louisiana, we have more prison beds than we do hospital beds, right? And so how is all of this stuff both known and unknown, right? Given the number of people who are exposed to or impacted by carceral conditions, I have to think that secrecy is a feature of American incarceration and not a bug. So what purpose does it serve? So first, I have to note that our keynote speaker, Sharon Dolovich, has theorized what American incarceration looks like. And this comes in part from her paving that path, where she argued there can be no carceral project, no physical banishment from society without the simultaneous, unremitting control of the excluded by the state. And when she talks about that exclusion, she talks not just about their physical exclusion, but also their moral exclusion, exclusion from the category of moral subjects to whom we owe decency and humanity. And so in thinking about these things, I've thought about initially 3 different purposes, right? And then we can think of them as different tools. One is simply to maintain the gulf, the wall between public versus incarcerated, right? And that really gets to this aspect of American incarceration, which Professor Dolovich has explained. But then second, that secrecy also enhances the ability to claim and use power within the facility itself, right? Simply the ability to invoke secrecy is an assertion of power. Third, I think about how secrecy is in fact vital to maintaining the existence of prisons and their viability in the future, right? So by hiding the costs, and the costs are enormous. We can talk about the financial costs, we can talk about the social costs, we can talk about a lot of these things. But the only way they continue to exist is when those costs are hidden. And so when we're talking in this moment of thinking more creatively around what role do prisons serve within public safety, the secrecy serves to affirm their future viability. So this is also in the House of Detention. It is a restraint cell. It's a permanent restraint bed in a cell on a psychiatric tier. And I want you to look at this to understand the video, but also to think about what role does law play in keeping this secret. This is HOD, CLU, first cell. Okay, so I want you to think about in that prison, in that cell, there was no water, there was no toilet, there was simply the restraint cell. And there may be lots of reasons why the interior of prisons and jails are secret. I don't mean to imply that it's just the creation of law, right? It could be as a culture in our society, we denigrate and exclude. It could be for lots of different reasons, but I'm interested in what role the law plays in this secrecy. And so here, I think about it through 3 different angles. And these angles don't necessarily operate independently. And in fact, I think that they reinforce one another as they work. So we can think about the judiciary. And there I've been focusing on elements of deference, right? So the fact that we defer to the decisions of carceral administrators, particularly under Turner versus Safley, but also the diminution of individual rights, right? It's what first attracted me to doing scholarship in this area is the gross disconnect between the extended governmental authority, right? Government has power in these spaces that we would never allow in other settings except perhaps the military, right? And at the same time, that is juxtaposed with the fewest amount of rights because the Constitution operates far differently behind bars than it does for you and I. And so because of that diminution of individual rights, we can think about the denial of rights to organize, to protest, to speak, to associate, the denial of media rights to come into these facilities, the denial of visitation or parental rights or contact rights for both people incarcerated as well as people in the community. When we think about statutes, there I have focused on elements of exclusion. the ways in which we, through procedural or substantive rules, exclude prisons and jails from the otherwise generally applicable rule. So there we might think about the Prison Litigation Reform Act, which we are going to hear a lot more about. We would also talk about public records laws, which have broad exclusions in a 50-state survey that I've just finished kind of reviewing and updating. In Louisiana, for example, if you are incarcerated, you are not considered an eligible person to file a public records request. But the exclusions are often broad around security. And last, I want us to think about regulatory omission, right? And so the fact that our generally applicable regulatory laws often simply don't apply because a prison or a jail often is invisible or not mentioned. So what does that mean for our restraint bed, and how does secrecy facilitate that? Thank you. So first, when we think about judges and judicial deference, here they defer to the warden on what is necessary and when it is necessary in terms of treatment. Our state laws will exclude public records around the purchase or use under broad exceptions that prioritize security over individual rights. We also see it through the exclusion of incarcerated people from Medicaid coverage, because it turns out the Centers for Medicare and Medicaid Services has rules around freedom from restraint for patients. And yet, because incarcerated people are not included in that coverage, the rules that are developed by CMS don't apply. We also see regulatory omission, particularly when we think about the building codes and the enforcement of building codes. And so you noticed in this cell, there was in fact plumbing in this cell, and yet it was removed and a restraint bed was placed within it. Which building inspector then said, oh yeah, I'll sign off on this, right? So once built, these buildings often have modifications that are put into place, often harsher conditions, and those are not necessarily inspected or subject to new regulatory enforcement. It is also the spaces in which we have tons of invisible degradations. And so on the top, you'll see holes, and that's right above the cell wall, where because people lacked a clean place to put a toothbrush, they started carving holes in the wall to keep their toothbrush up there, right? The bottom is the masking tape, right? So they would put the masking tape on the person and then start writing on the person, right, about where they were. And you'll notice that there isn't even a name there, just which floor they belong to and what time they get returned. So what does it mean to challenge carceral secrecy? Because there are rooms in this jail that are full of uniforms just waiting for a chance to be used. The bottom is an underside bunk where the creativity is really amazing when you go into these buildings. That is a calendar that was created in toothpaste so that he could keep track of time and how long he had been there. And so what these two pictures remind me of is that we have to challenge our own assumptions and our own boundaries. That when we think about carceral secrecy, that when we challenge that secrecy, we are challenging elements of the system itself, elements which not only allow the system to exist, but also to reproduce itself. Thank you very much.
Thank you so much, Professor Armstrong. Our next presenter is going to be presenting remotely. Catherine Struve is going to present on the PLRA's limits on preliminary injunctions. Professor Struve is the David E. Kaufman and Leopold Glass Professor of Law at the University of Pennsylvania Law School. She's a graduate of Harvard Law School and a national expert in federal procedure. And she must make federal procedure pretty interesting since she's won her school's teaching award 3 times in recent years. So thank you, Professor Struve.
Thank you so much, Professor Osler. And I wanted to thank my old friend, Dean Vischer, and Professor Sisk and Megan for their work in putting this symposium together. I'm really honored to be a part of it. And Professor Armstrong for such a powerful presentation, which gives us a really overarching lens through which to view the carceral state. And I'm going to take a very different tack and really home in on a very, very particular part of one statute that Professor Armstrong mentioned, the PLRA. So I'm going to share my screen because, with apologies, I'm going to delve into some statutory details. And to those who are familiar with the particulars of what I'm going to discuss, it'll seem like it's overly stylized, and then for everybody else, it'll probably seem like it's overly detailed. So I apologize in advance, but I'm going to take a crack at examining something that surfaced in an opinion I read this summer. So in July, the 11th Circuit had decided a case, Georgia Advocacy Office versus Jackson, and I had just finished reading that opinion when Professor Sisk generously invited me to participate. And so I decided to take this occasion as an opportunity to learn more about what that court was up to. So you're familiar with the PLRA, enacted by the Get Tough on Crime Congress in 1996, bolstered by allegations about a flood of assertedly frivolous inmate litigation and assertions about unwarranted intrusions by the federal courts into prison conditions. And on the latter point, the PLRA set limits specifically on injunctive relief with respect to prison conditions. And oftentimes folks are familiar with the limit set by 18 U.S. Code 3626A1, which sets what courts sometimes call a need, narrowness, and intrusiveness limit on prospective relief. That is to say, it requires that the court, in order to grant such injunctive relief, requires that the court finds that such relief is narrowly drawn, extends no further than necessary to correct the violation, and is the least intrusive means necessary. Equally dramatic is the effect on permanent injunctions once they are entered. So Section 3626B1 provides this mechanism by which the defendant can come in and ask the court for termination of a permanent injunction, making it less than permanent in this context potentially. So starting 2 years after entry of a permanent injunction that would be entered at the end of litigation, the defendant can come in and ask the court to terminate it. And if the court says no, then they can come in every year thereafter and renew that request. The court can deny termination if it finds that there's still a current ongoing violation and redoes the need, narrowness, intrusiveness analysis. What I would like to focus on is 3626A2, which addresses preliminary injunctions. And this provision concerns preliminary injunctions, which, as you know, would be entered by the court while the litigation is going on in order to prevent irreparable injury to the plaintiff during the pendency of the litigation while the court determines whether it is appropriate to enter a permanent injunction at the end of the lawsuit. To enter that preliminary injunction, there must be a similar test applied, that is to say, the need, narrowness, intrusiveness test. But in addition, 3626A2 sets a 90-day limit on the duration of the preliminary injunction unless the court makes the findings required under subsection A1, that's those need, narrowness, intrusiveness findings, and, quote, makes the order final before the 90-day period expires. And the meaning of makes the order final was the focus of the 11th Circuit in this case that I'll discuss. So in that case, the plaintiffs had sued to challenge the practice of solitary confinement for women with mental disabilities. And after a hearing, the district court found that the plaintiffs were likely to prevail on the merits of their claims, deliberate indifference to the women's medical needs and disability discrimination. And in July 2019, shortly after the hearing, it issued a preliminary injunction stating that it would provide more detail in a forthcoming opinion, which it then entered a couple of months later in September, a very detailed, very long addendum order containing findings and conclusions to support that the injunction met the standard in A2. Now, the parties disagreed about the implications of this development. So the plaintiffs took the view that the second September order met all the requirements under A2 for lifting that 90-day limit on the duration of the preliminary injunction. Essentially, in the plaintiff's view, that second detailed order made the order final for purposes of A2, and thus there was no 90-day limit anymore on the duration of that preliminary relief. By contrast, the defendants asserted that makes the order final means enters a permanent injunction, which is the type of injunction that would be entered after a full trial on the merits, and that the district court had not done that, and that in that case, if the preliminary injunctive relief were to continue past 90 days, it could only be because a district court would issue a second or successive 90-day limited preliminary injunction. So the defendant's view was the 90-day limit was still in place, and that meant if this relief was to continue, the district court had to issue a new preliminary injunction. Those were the contending views of the parties. On review in the 11th Circuit on the interlocutory appeal, the 11th Circuit held that, yes, the 90-day limit was still in effect. They agreed with the defendants on that point. And they held that for that reason, because the PI was no longer in effect, the appeal itself was moot, and they dismissed on mootness grounds. So we can see that the panel majority rejected the plaintiff's reading of A2 and held that the 90-day limit still applied. But they did not actually in any explicit way adopt the entirety of the defendant's reading. Rather, they issued a rationale that was what caught my eye when I read that opinion. And I will confess this was my first acquaintance with this feature of the PLRA, because it was so striking the way in which the 11th Circuit panel presented the function of this provision. It started by conceding that the ordinary function of a preliminary injunction is to protect a plaintiff when necessary from irreparable injury that would otherwise occur during the pendency of the lawsuit. But then it said, however, under the PLRA, the PI will automatically expire 90 days after entry unless certain conditions are met, one of which is entry of a permanent injunction after a trial on the merits. And so in the description given by the majority, it decided that A2 sets a novel mechanism for something called a test period, during which a 90-day limited PI would give an opportunity for the court to see what happened. One possibility, the court said, was that the defendant would reform, and then there would be no further need for the lawsuit, and the court could dismiss. The other possibility, the court said, was the defendant doesn't reform, in which case the district court should proceed to a trial on the merits and enter a permanent injunction. In conclusion, the description of its vision was that once the preliminary injunction issues, the plaintiff's entitlement to a permanent injunction would be, quote, typically ascertained within 90 days, so that this provision, in the view of the majority, furthers the PLRA's goals by expediting prison litigation. Now, I read this opinion and I thought, who on earth thinks that prison conditions litigation can be fully litigated through a trial on the merits and to its conclusion within 90 days? That just struck me as insane. And so the opinion had caught my eye, and I sort of wondered what was going on. Now, it turns out that this is not how other courts around the country have read this provision. And the clue is provided by how the parties themselves had been litigating this in the court below. That is to say, the text of the statute does put in place the 90-day limit, but nothing in that text says the court is unable to enter a new preliminary injunction after the initial one expires. So even if one buys the 11th Circuit's reading about what's required to quote unquote make the order final, there is nothing in the statute that would foreclose sequential 90-day injunctions, despite the sort of vision that the 11th Circuit majority seems to put forward in this particular case. And in fact, the 9th Circuit long ago held that the issuance of sequential preliminary injunctions in no way violates this limitation set by the 3626A2. And in fact, in their view, the system that this puts in place creates a parallel between how the PLRA treats preliminary injunctions and how it treats permanent injunctions. Because in both instances, there's a need, narrowness, and intrusiveness limit on the injunctive relief. And in each instance, the statute builds in a mechanism by which the court has to come back as a practical matter and reconsider the appropriateness of the injunction periodically. In the case of preliminary relief every 90 days, and in the case of a permanent injunction in that longer 2-year and then 1-year time frame provided for under 3626B. So even if one interprets the 90-day limit the way that the 11th Circuit did, its description of its actual valence and significance is really off base because it doesn't take into account this possibility of sequential PIs when they're needed. And indeed, I mean, in looking at this question, I've seen that district courts around the country have indeed recognized the availability of these sequential PIs. And that's also true with a non-precedential opinion from the 10th Circuit, as well as indeed just last week, the 11th Circuit, which in a non-precedential opinion upheld a second preliminary injunction in a particular case governed by the PLRA. So it's non-precedential, but it clearly recognizes the availability of sequential PIs. So this then raises the question, what is the valence in practice of the 90-day limit? And I'm really eager to get the thoughts of people who are a lot more expert on this than I, and I've had the opportunity to get some wisdom on this from a number of really experienced people, including at least one person who I know is there today because he's on the next panel, and that's Paul Wright. So Paul, thank you for your input on this. But I would be excited to learn more about what folks' experience is with this. I mean, one overarching point is, the reason why folks don't often think about the 90-day limit is that it's very rare in relative terms for a preliminary injunction to in fact be issued. And I guess, one has to recognize that the number of examples of PIs that have been entered in prison conditions suits is limited, and that's a true fact. But the flip side of that might also help to explain why the 90-day limit isn't the whole ballgame, because in a case where the district court is sufficiently convinced of the merits, of the potential merit of the plaintiff's claim that it enters a preliminary injunction, that's a strong signal to the defendant that it should think about settling. And so that's another reason why, at least in that kind of case, it may be that just getting that first preliminary injunction may get you very far towards your goal if it can convince the defendant to engage in serious settlement negotiations. Another question that I think is interesting is that in a number of the cases I've seen, people did not initially recognize the applicability of the 90-day limit. And so one interesting question for the plaintiff's lawyer is, if the court seems to be unaware that there's a 90-day limit in A2, and if the defendant doesn't seem to be raising it, should you? And it's an interesting question because, of course, if you don't, it can come up at any point thereafter and become relevant. On the defense side, it seems as though there are a number of different ways that defendants respond in a situation where the 90-day limit is recognized and the question of successive preliminary injunctions arises. So sometimes defendants might somewhat throw in the towel on the question of preliminary relief and not really put energy into opposing the grant of successive preliminary injunctions. On other occasions, they might be strategic and just alter their conduct just enough in response to an initial preliminary injunction that they essentially create an opportunity for them to argue that the record has changed, and if the plaintiff wants to get an additional preliminary injunction, they need to relitigate and build a new record for the purpose of securing the second preliminary injunction. So the 90-day limit, it's not like great news for plaintiffs that you can get sequential PIs, because the defendants can make it costly to litigate that question repeatedly and continue getting them. But in any event, these strategies vary a lot. The other thing you see in a bunch of recent cases is this question of mootness on appeal. So 90-day limit means that a defendant who's taking an appeal from a PI is going to have a potential problem with actually getting appellate review, because the appeal might go moot once the PI has expired by operation of the 90-day limit. Now, in a case called Barnes v. Ullman out of the Ninth Circuit, there's actually a twist on that because the defendants managed to get a stay of the PI, and they now argue that that stopped the clock on the 90 days such that they can avoid a mootness question on appeal, and they are taking that argument to the US Supreme Court, actually, in a pending cert petition. So there's a lot of detail under there in terms of the litigation strategy elements. But I'll close where I started, I think, which is that bottom line, even if the 11th Circuit reading is adopted, which is to say that you can't lift the 90-day limit on the length of a preliminary injunction under A2 until you have a permanent injunction. That's not the only possible way to read that language, but it's one that the 11th Circuit adopted, and I could imagine some other courts adopting it too. Even if you do that, the PLRA should not be read to bar the entry of successive preliminary injunctions. That's clearly a second best compared with just getting one that's justified and having it persist. But that second best at least should be left, because even when it was upholding other provisions that we're familiar with in the PLRA's limits on injunctive relief in Miller v. French, the Supreme Court did recognize that if Congress is going to displace the traditional equitable authority of the courts, it needs to speak clearly. And I would argue that that equitable authority has to include the ability to grant effective interim relief in cases where harm to the plaintiffs can only be prevented during the pendency of the lawsuit in that way. So I'll close with that, and I'm really eager to get any comments that people have on this particular doctrinal thicket of problems.
Well, thank you for Professor Struve. So next up, we have two recent graduates of this school, Alexander Gannon and Nicole Stengel. And Ms. Gannon is a lawyer at Erickson and Westman in Bloomington. And Ms. Stengel is a lawyer at Reuter Ware in Wausau, Wisconsin. And their subject is abusing taxation of court costs by government lawyers.
Good afternoon. As Professor Osler said, I'm Alexandra Gannon, and this is Nikki Stengel. I practice probate law in Bloomington, and Nikki practices employment law in Wisconsin. You might be wondering why a probate attorney and an employment law attorney are presenting at a symposium on prisoner rights. Nikki and I were both students and research assistants of Professor Sisk during law school when he invited us to collaborate with him on this article. Admittedly, we didn't know much about this topic when we commenced the project with Professor Sisk back in 2019, but through our research, collaboration, and Professor Sisk's evident passion for this story to be told, it has become something quite special to us. Our article is about court costs in federal courts. The amount of money involved may seem trivial. Court costs, which are generally awarded to the winner in a civil case, are limited to such things as filing fees, witness fees, deposition costs, etc., but not to general expenses or attorney fees. We're talking about hundreds or maybe a few $1,000s at most. Precisely because it is something so apparently simple and basic, it is easy to overlook and be ignored in scholarly writing or judicial attention. But it is of surprisingly powerful importance to the disadvantaged in our civil justice system. While the money involved may be small to us, it can loom large in the thinking of a poor person or a person without employment, such as a prisoner. This is the problem. Attorneys in state attorney general offices regularly employ the threat of court imposition of costs on pro se plaintiffs to convince them to dismiss or settle federal civil rights claims against public officials or entities. Persons of limited means may fear being held liable for hundreds or thousands of dollars in court costs if they don't win their civil rights lawsuits. Pro se litigants especially may be intimidated by attorneys who exert their authority as public officials to pressure abandonment of even meritorious civil rights claims.
And to the contrary of these threats that are often used against pro se litigants, all of the federal courts have a presumption that the awarded party will be, the prevailing party will be awarded court costs.
However, every federal circuit court has addressed this in cases of indigent plaintiffs and pro se plaintiffs, and every single one has says it's actually a matter of judicial discretion. So all of the courts addressed it a little bit different, although they do find that it's not necessarily, the presumption of shifting costs is not an automatic thing. So the 7th, 8th, and 6th Circuit focus on the indigent plaintiffs as a factor in the analysis. The 8th Circuit says it's an appropriate factor to consider. The 6th Circuit looks at it as a factor, but it also looks at the purpose behind the rule of shifting the costs as well as the litigation history of that case and whether it was brought in good faith. So it's not the only factor looked at by the 6th Circuit. And the 7th Circuit has found there are 2 cases where the costs will not be shifted. And one, it's where the prevailing party has engaged in misconduct. And the other is when the losing party is indigent, and there the court must make a finding that that pro se plaintiff cannot pay the cost. So if that court makes that finding, then the cost will not be shifted to the prevailing party. However, the 4th and the 5th Circuit, although they do find it is the discretion of the courts, they are not as favorable to indigent plaintiffs. They look at it more as pro se litigants are a burden on the system. And so they want the pro se litigants to really evaluate their case before they bring a case, especially against the government. So they are not as willing to not follow that presumption. The 5th Circuit has said they use the presumption to defray the judicial and social burdens of pro se litigation. And the 4th Circuit, they have classified it as they make the pro se litigant decide if their case is worth it before they'll bring it. So they are on one side of the spectrum, but the 2nd Circuit is pretty far on the other side of the spectrum, along with the 3rd Circuit. And both those circuits have found that it is an automatic factor when the case is against the United States. So if it is an indigent plaintiff and it is a case against the United States, that is automatic in the 3rd and the 2nd Circuit. And then the 10th and the 9th Circuit have looked more as a public interest, a more global approach to deciding whether or not they're going to shift the court costs. And all of them use a variety of factors, including the substantial importance of the case, the chilling effect this might have on future litigation, the closeness and difficulty of the issues, was there any misconduct, the financial resources, and things like that. So those 2 districts will take a more global approach and look at a variety of factors and really do a public interest assessment of the case. And then the 1st Circuit is the only circuit that has not addressed it for pro se litigants against the government, but they do on a global scale say that court cost shifting is a matter of judicial discretion. So although they haven't applied it to this situation, it is something that they say globally the courts have judicial discretion on whether or not to shift those costs.
In light of the established case law, our conclusion in the article was that state law officers should never present a direct and unqualified threat of thousands of dollars in court costs against a civil rights plaintiff, especially one that is not represented by counsel. Professional conduct rules demand honesty by lawyers and restrict communications with an unrepresented party. Under the model rules, lawyers also have a duty of fundamental honesty. For a government legal official to declare to a civil rights plaintiff that he or she will suffer the financial detriment of court costs upon losing the case is at best misleading and at worst an outright falsehood. Pressing upon an unrepresented party a narrative of financial disaster in the wake of a judgment of costs crosses the ethical line into offering improper legal advice. Moreover, the federal courts hold attorneys representing the public to higher standards of candor and civility. Government attorneys are ethically obliged to inform civil rights litigants that awards of court costs are a matter of discretion and may be reduced or excused for public policy reasons. Anything less is a breach of ethical and public responsibility for any legal officer who is entrusted to speak as a lawyer on behalf of the public.
And our article really highlights this with a story of Ron Pettit, who was an inmate at the Arizona Department of Corrections. And during his case that he brought for excessive force violations in the federal district court, he repeatedly offered to settle his case, but was denied those offers. And the Assistant Attorney General sent letters to him and classified the potential for court costs as an economic catastrophe for Mr. Ron Pettit. So he is just one of many individuals who have experienced this threat by government attorneys, and that threat is just a falsehood unless it's qualified with the fact that there's really a lot of judicial discretion that goes into the potential risk of court costs.
Thank you. And next, we go from recent graduates to a current student. Megan Massey is going to be our next presenter. Many of you are familiar with her because she played such an important role in putting all of this together. And we all owe her a debt for the fine job that she did with that. Her presentation is going to be on prison labor and the 13th Amendment.
Good afternoon, everyone. Good to see you again. As Professor Osler noted, my topic is about prison labor and how the 13th Amendment has had a significant impact on it. And the motivation behind this article really came from I believe it was a piece in The Atlantic a few years ago that I read. And it was a really striking image of two pictures side by side. The first was back in the early 1800s during slavery, and it was a slave owner on his horse overseeing his plantation, and then the slaves working in the field. Compared to a picture of in like 2013, 2014, nearly the same image, but the person on a horse was a Department of Corrections employee, and the people working in the field were the inmates at a federal prison. And the whole point of the article was about how the 13th Amendment really was the basis for allowing this kind of imagery to happen. And I thought that can't be right. The 13th Amendment ended slavery. There's no way that it would be a foundation for this kind of labor exploitation in the 21st century. And I quickly found out that I was wrong. And I think the best way to start is with the language of the 13th Amendment itself. So it reads, neither slavery nor involuntary servitude, comma, except as punishment for crime whereof the party shall have been duly convicted, comma, shall exist within the United States. And really the big problem is that middle clause. It's kind of known by legal scholars as the punishment clause. And essentially what it means is that if you've been convicted of a crime, the 13th Amendment doesn't really apply to you in the context that the state can force you to participate in forced labor against your will. And the way that this idea came about really was upheld by the courts, as we've heard a lot today, pretty immediately in the late 1800s. The first case was 1871, where the court very, and I would say poor language, said that under the 13th Amendment, inmates are, quote, slaves of the state. That they, because they've been convicted of a crime, can be forced to work out in fields, work on, at that time, working on railroads was really popular. So that was the case in Ruffin, and it wasn't a Supreme Court case, but the Supreme Court shortly thereafter in the slaughterhouse cases, which wasn't directly dealing with prison labor, really cut back on the broad application of the 13th Amendment and said, no. All the 13th Amendment really was saying is that we were going to end African slavery as it existed before the Civil War. And we've achieved that. So the 13th Amendment's application has to be really narrowly applied in situations, in different situations. So I think a more recent case, Alley v. Johnson in 2001, really sums up what the situation is like for inmates when it comes to the 13th Amendment and working conditions. Inmates sentenced to incarceration cannot state a viable 13th Amendment claim if the prison requires them to work. And that means they don't have, they can be forced to work, They can be punished if they refuse to work, which includes loss of privileges to solitary confinement. They have no basis for a minimum wage or maximum work hours. They have no claim for certain working conditions under the 13th Amendment. So pretty much they really are at a loss in the courts for getting certain protections when it comes to working while in prison. And who is this really affecting is another question we need to be asking. And I think a few panelists have already touched on it, but the racial disparities in our criminal justice system are huge. And that started, again, in Reconstruction almost immediately after the Civil War, with these court decisions that came down, and then systems of oppressions recognizing, oh, the courts aren't going to stop us if we can relabel a Black or brown person from a slave to a convict. If we can give them that label of convict, then we can assert control over them and have them work for us as they were previously as slaves. And so that was pretty much a big basis for Jim Crow, the laws down south where pretty much things like quote unquote mischief were criminalized. And it was a way to systematically sweep newly freed Black and brown people off the streets, convict them of crimes, and then send them out in a system known as convict leasing. And that spread from down south primarily to essentially the entire country during the Great Migration of the early 1920s. Because as we know, racism was not and is not a concept only known down south. It's a thing that the North was dealing with in the West as well. So when these populations were moving, what happened was they saw what they were doing down south and they just adopted those policies up north and out west. And that's pretty much what really created the first basis for the mass prison system and incarceration system that we have today, which was then rejuvenated and revitalized and expanded exponentially in reaction to the civil rights movement with the era of mass incarceration, the war on drugs, and primarily all of these policies and procedures that have been put in place over the past 4 decades that created mass incarceration are disproportionately affecting people of color. So we are locking people up, saying that if you have the convict label, that you can be forced to work under the state and have no repercussions in the courts. And primarily the people that it's affecting are Black and brown people. So how did this happen and how did we get here and how can we fix it? And I think if you look back to the ratifiers and the creators of the 13th Amendment, this was not what they envisioned. If you look at the conversations they were having during the writing up of the 13th, 14th, and 15th Amendments, they were really concerned with how can we eradicate slavery and make sure nothing like this ever happens again. And unbeknownst to them, they didn't realize that this punishment clause that they included would later be exploited and used to recreate a lot of the same systems that were back in place that they were trying to prevent from ever happening again. So how can we fix it? I've come up with 3 possible solutions. And I think that the answer is really going to be not in the courts, as I've noted, but in the legislature, which may not be very comforting because the legislature can be very slow to move on things as well. But I think the first and foremost, the best way to do this is to amend the 13th Amendment. Remove the punishment clause language, because that's really the hook that courts have used to say, there's nothing we can do about it. The 13th Amendment doesn't grant them protections. And if the prison says they need to work, then they need to work. So removing that language really takes the teeth out of any court decisions that have come down about prison labor. And then there are 2 other federal laws that I think could help prison inmates and workers in prison. And I think the first is going to be the TVPA, the Trafficking Victims Protection Act. There's a labor trafficking provision that has really strong language on forced labor and how forced labor is not allowed in the United States and the punishments associated with that. I think you could easily amend that language to include a provision that says the TVPA labor trafficking provision also applies to prisoners. And that would grant wide protection to prisoners both at the federal and the state level. And then finally, the which my co-panelist might know more about because she's actually written an entire article about the Fair Labor and Standards Act and relate to prison labor. But essentially what the Fair Labor Standard Act is that's what sets the minimum wage, maximum work hours for workers generally in the United States. And courts have decided that prisoners are excluded from the Fair Labor Standards Act. And I think, again, we can add provisions in there that say prisoners are included in this and prisons need to be subjected to the same conditions that employers that we all work for have to follow as well. Thank you. And I think that would be really important in conjunction with the protection of the TVPA, because I think prison programs and work programs can be a really positive thing for prisoners. I know a lot of prisoners like to work and they want to work. It helps build skills. It's a way to pass time in prison. It's a way to feel fulfilled while you're in prison. But when we go to work every day, we expect a certain amount of dignity and respect. And I think that prisoners deserve that same dignity and respect when they go to work as well. Thank you.
And our last panelist for today is Professor Gregory Sisk, who, of course, is the person who created this largely, and who we have to thank for having this symposium at all. It's one of the reasons that I came to this law school is I came here and I gave a faculty colloquium talk. And the discussion afterwards was remarkable. And there's some people that I remember, and I still have. I had a student at Baylor prepare a notebook listing who the faculty would be that would be there, and I made notes. And I still have that with the margin notes. and I was so impressed by Professor Sisk, even back then. He graduated first in his class at the University of Washington Law School. He's currently serves as the Laghi Distinguished Chair in Law here at St. Thomas. He's a nationally recognized expert in civil procedure and litigation with the federal government. And even with all of this going on, and having developed that national reputation and the role that he had at that time, 10 years ago, he decided to help prisoners and to do it with his students. I had started a clemency clinic shortly before that. And I remember Professor Sisk coming to talk to me about his idea. And part of that discussion was, I said, you know, you're going to lose your cases. And he said, well, you know, because he's very optimistic. And I guess that meant, oh, we'll win. And they have. They did win. And then they won again. And then they won again. And it's really remarkable. And one of the things that's such a gift, not just to the students who work with him, but to all of our students who hear about this, is that it's this real life experience by people you know, showing that sometimes when you push against something that's wrong, it moves. And today, he's going to talk about how qualified immunity condones rogue behavior in government officers. Professor Sisk.
Thanks a lot. Thanks a lot, Mark. Very kind. I'm so glad that all of you are here and that today has come together. I'm going to talk about something that you've heard mentioned from time to time, qualified immunity. And it's not just a prison law issue, but it is a prison law issue. And what it means is that just when you think you've got everything lined up to win, it all gets taken away through qualified immunity. So a year ago, a diverse, politically diverse, racially diverse coalition proposed abolishing qualified immunity in Minnesota. Unfortunately, that diversity was not extended to the state legislature, and it did not pass. And I testified before the state legislature in favor of this. But what I want to begin with So where's the clicker? To move forward? Okay, here we go. So what I want to begin with is part of the committee hearing before the Minnesota Public Safety Committee of the Minnesota House of Representatives. The first voice you're going to hear, and Xander, make sure the sound's up good and loud, is all done by Zoom, of course, is a county sheriff who was the law enforcement representative opposing the abolishment of qualified immunity. And the second is from a state legislator who is also opposed to the bill to abolish qualified immunity.
There's a misnomer that law enforcement feels like qualified immunity is some get out of jail free card. The attorneys I talk to say there's nothing further from the truth. The realities are qualified immunity does not protect law enforcement who knowingly violate the law. The view is that law enforcement is protected by qualified immunity, we feel is overstated.
As long as the officer is not breaking a law or violating the law or policy for that matter, he's protected. But if he violates policy, violates the law, qualified immunity does not fall in play. He is liable for what he does.
Alas, the county sheriff and the state legislator are quite wrong. All right. So the federal courts do in fact provide qualified immunity, the benefit of qualified immunity, even when an officer has plainly violated the criminal law, disregarded state statutes, ignored agency regulations, or transgressed official policies. Unless the source of the wrongdoing is both constitutional in nature and clearly established in law through an appellate precedent with nearly identical facts, the officer engaging in rogue behavior may indeed avoid liability through qualified immunity. So, plainly and painfully stated, the application of qualified immunity means that the victim of constitutional wrong by a government officer acting in official capacity is left without any remedy for the harm that resulted. Now, the first prong of qualified immunity forthrightly asks whether there has been a constitutional violation. But in sharp contrast, the second prong of qualified immunity introduces a peculiar analysis. The second prong asks not whether there was a violation, but rather whether the asserted constitutional right was, quote, clearly established at the time of the conduct. And this clearly established standard has evolved into a demanding exercise in parsing the specific details of prior appellate precedents. Too often, courts appear to latch upon the slightest of factual distinctions to excuse a defendant government officer from being held to respond to a civil charge of constitutional wrongdoing. And importantly, for my present purposes, the federal courts have regularly extended qualified immunity to a government officer whose state law wrongdoing is manifest. 3 illustrative cases from just the past 3 years will show this. First, in Jessup versus City of Fresno, city police officers executed a search warrant as part of an investigation into illegal gambling machines. While the officers later produced an inventory stating that approximately $50,000 had been seized pursuant to the warrant, the plaintiffs claimed that the officers had taken $151,000 in cash and $125,000 in rare coins. In other words, the officers had stolen tens of thousands of dollars in currency. At least one of these officers was later convicted of a crime. The United States Court of Appeals for the Ninth Circuit acknowledged that the officers, quote, ought to have recognized that the alleged theft of appellant's money and rare coins was morally wrong. But the court concluded they did not have clear notice that the theft violated the Fourth Amendment, which is a different question. In Evans versus Skolnick, a prisoner discovered that correctional officers were eavesdropping on confidential telephone calls to his attorneys. Prison officials had circumvented the prison secure telephone system. A loudspeaker was directly wired into a tapped line, allowing correctional officers to listen to an entire conversation by a prisoner with his lawyers. Correctional officers admitted that they listened to the substance of those conversations to evaluate its legal conduct, based on what one correctional officer explained, legal terminology that you might hear on television. The dissent stated that these calls included, quote, civil rights violations by prison officials, including the same officials that monitored the legal calls. As this dissenting judge recognized, correctional officer monitoring of the content of a prisoner's call to his attorney stood in direct contradiction of Nevada state law. The Nevada state legislature had declared prisoner communications to a lawyer to be confidential. And when this state statute was enacted, the director of the State Department of Corrections assured the state legislature that calls would be placed by a prison employee to verify that it was an attorney, and thus, quote, there would be no need to monitor that telephone conversation because it would be confidential. The chair of the Senate Judiciary Committee then assured everyone the warden, quote, doesn't listen until he determines that the call is within the privilege and the call is not monitored at all. Nonetheless, the Ninth Circuit majority granted qualified immunity, stating that the prison's monitoring of legal telephone calls did not, quote, violate a Fourth Amendment right that was clearly established at the time. The third case I want to discuss is Frazier versus Evans. The plaintiff happened to be in a parking lot near where police officers were arresting a suspect in a drug deal. He began video recording the incident on his tablet computer, showing an officer repeatedly punching the suspect in the face. He was surrounded by the officers who allegedly demanded he turn over the video. The computer was grabbed out of his hands and searched without his consent. Now, the district court denied qualified immunity on the plaintiff's First Amendment claim of retaliation after finding that the municipality had in place at the time of the events giving rise to the lawsuit an official policy which clearly affirmed citizens' First Amendment rights to record the police in the public discharge of their official duties. Indeed, the police department had trained its officers to follow that policy. Notwithstanding the city policy, the United States Court of Appeals for the 10th Circuit reversed and granted qualified immunity to the officers because, you guessed it, the First Amendment right to record the police was not clearly established. So the animating purpose behind qualified immunity is to protect an officer from ruinous personal liability, which doesn't happen anyway, when he or she reasonably but mistakenly engaged in official conduct believed to be legitimate. But an officer who has crossed a clear line set by a state statute, agency regulation, or department policy is hardly someone who has acted reasonably or slipped into an innocent mistake. By granting special solicitude to lawless government officers, the courts encourage further rogue behavior. Officials may learn the lesson that they can flout state law with impunity, knowing that they will be awarded qualified immunity without so much as an admonition for their lawless behavior. In sum, when the government officer is a lawbreaker rather than a law enforcer, the very reason for qualified immunity evaporates. So the modest solution I propose here is to remove qualified immunity when a miscreant government officer has failed to follow specific prescriptions of official conduct set forth in state law. Now, to prevail on a constitutional civil rights claim, the plaintiff still will have to establish that a constitutional right was violated. But the plaintiff should not have to face the higher obstacle of pointing to a past precedent in a nearly identical context to do so. By violating a clear state law legal directive, the government officer should be regarded as having forfeited the qualified immunity defense. Thank you.
Okay, so we have until 3 o'clock, I believe. So we have time for questions. Do we have a mic for questions out there? Okay, great. And we have a question. I'll run through.
That was great. Thank you, everybody. Really informative. A couple of quick things. One is I wonder if the presenters who talked about your papers, if we could get the citations to those papers, if they're published, it'd be great to see them. And I have a lot to say about all of them, but I have a specific question for you, Greg, about what you just said about qualified immunity. What I'm curious about is, one of the challenges with qualified immunity is the question of sequencing and whether the courts will answer the question of whether the right was violated before they decide whether it was clearly established. And it occurs to me, so, ordinarily, the problem is the law doesn't become developed because the conduct that you might think, that I might think was clearly violative, the court says we don't have to reach the question of whether it violated a right because it was clearly established, therefore qualified immunity. And that problem, then of course, in future cases, they could point to the case and say it wasn't clearly established. I didn't know either. But it occurs to me that with the specific cases that you're talking about, where they're violating they're violating a state law that exists, there's not really a debate at that first moment, right? So it does suggest, as outrageous as these cases are, it does suggest that that in future cases, it wouldn't be like in constitutional violations where future defendants could rest on the continued confusion about what the law is, because the court will have validated in each of these cases, like you're not supposed to monitor phone calls. People have a right to record. And so I'm curious to know if if you've seen any examples of cases where that positive effect might occur, even though in that initial case, it seems like injustice was done.
Let me answer the first part of your question, then let everyone else have an opportunity to do the same as the location of these works, and then I'll answer the second part after that. My paper is already, if you saw the title of it, qualified immunity, rogue officers, you just type that into Google and the paper will show up on SSRN. It'll be published, of course, in the law journal later on, but my current draft is available there already. Others?
Mine will also be in this upcoming publication. Yes.
That wasn't clear to me when you were talking about these are papers that are, okay, great. Sorry, I didn't understand that.
Well, all of these papers are going to be published in the law journal, and some of them, the court costs piece that I worked on with Alex and Nikki is also already available on SSRN. So the second part of the question is, boy, that would be nice if that were true, but it's not. So let me take, in full disclosure, I was the attorney for John Withrow in the Ninth Circuit case involving the monitoring of legal phone calls. That case involved, as we pointed out, the state legislature had clearly said they were not to do this. The prison had a technology system set up in which you submitted the attorney's name and phone call. It was plugged into the system. So when that number was dialed, it would stop any recording or monitoring. But of course, these officers bypassed all of that by splicing a loudspeaker into the line and listened to it directly. It was clearly unlawful. But the Ninth Circuit said, not only does qualified immunity apply, but we're going to exercise our discretion to bypass the initial question as to whether there was a Fourth Amendment violation here and resolve it on prong 2, which is that the law was not clearly established. We're not going to comment on whether it actually is a violation of the Fourth Amendment. Now, when I said there was a dissent, that's true. I mean, it's a dissent in part, sadly, concurred in whether that was clearly established, which I think was a mistake. But the primary point of the dissent was to say, at least we should give the answer. We should answer the prong 1 question so that that's precedent into the future. It was very clear the majority did not want to do that. They did not want to answer that question. And if I were to guess as to why, it's because, I think we've done a pretty darn good job of showing it's a clear violation of the Fourth Amendment. And they didn't want to say that, because if they addressed the first prong, they were going to have to say that. The dissent said, I'm willing to address it. And yes, it is a violation of the Fourth Amendment, which of course, then we would have walked away and said, I think our client would have agreed. That was a win. I mean, it would mean because of qualified immunity, he got no damages. He wouldn't have won any damages. So it would be a loss in a sense. But John Withrow wasn't in it for the few dollars that you'd win. He was in it because he cared about prisoner rights and had a long history of being involved with prisoner rights organizations. So that would have been a big win. So it's in the longer paper that I didn't present today. But that is a big problem with this, is that courts increasingly go immediately to the second prong, and then they don't even answer the questions for the future. So the next time this comes up in the Ninth Circuit, it's still, I guess we now have a persuasive argument from a concurring dissenting judge, but the Ninth Circuit has no precedent saying that it's a violation of the Fourth Amendment. The only thing I can grab a hold of is that the majority did acknowledge there've been a couple of cases since then in the Ninth Circuit, the Nordstrom cases, which I was also involved with, which involved legal mail, that maybe made it a stronger argument that this was a violation, but those were post the events that occurred here, and so wasn't clearly established. Does that answer? Other questions?
So this is a question for court costs, and I teased you guys earlier, but I actually have a question about, I guess, government. It just seems generally odd to me that in the case of government attorneys, attorneys general, they are a branch of the government that is specifically designed to go to court. And then their ability to then inflict, as it is part of the judicial system, to collect court costs or even attorney's fees in some cases, seems like if the government hired a street sweeper and then like that was paid for by our taxes, and then in addition to the payment by the government, they also went around and collected fees from all the houses of the street they swept that day. And I guess, has there been any discussion on any level of, should the government even be in the business of collecting court costs in these cases, because that is what this office is designed to do?
I don't know if there's been any discussion about that. I guess I'd refer to Alex or Professor Sisk, but I think the court cost is a more general, it doesn't just apply to cases with the government. It applies to any litigation, and the federal courts talk about it on the broad spectrum. And the cases we cite to is litigation with the federal government and oftentimes pro se and prisoner plaintiffs. But that the prevailing court cost shifts is just, I think, more general, and it happens on a wide span of cases. But I don't know if there's been any discussion about not allowing the government to have that presumption as a whole.
Well, I will say to your street sweeper example, from like my time clerking at the city of St. Paul during law school, the government does actually charge you for street sweeping and snow removal.
Yes, I know there is a fee, but that's like in general to the city, and it's not like, it's a bad analogy, but it seems like I'm working on a better analogy.
So my question is about the 13th Amendment. Colorado amended their constitution and removed the punishment clause. I think they did that in 2018. In 2020, 3 inmates did sue the state for being paid 10 cents an hour for their labor. I don't know where the case is at now. I have no idea. I think it's still ongoing. I have sort of 2 questions. One, do you know of any efforts with the Minnesota Constitution around removing the punishment clause? And then 2, I guess, if you think that could be a successful approach, that each state just take that action to remove the punishment clause, or do you think courts would then just fall back on the cases that you cited initially?
Yeah, so I think attacking it at every angle is the best answer. So I think that Colorado did that is awesome. I would be curious to see, don't know much about that case, but I'd be curious to see how they approach it, because they are technically being paid 10 cents an hour, which is a lot more than a lot of states that have 0 cents an hour that they pay their prison workers. And as a lot of cases have said, the Fair Labor Standards Act doesn't apply to prisoners because they aren't qualified or defined as workers in the sense that they don't get any protections. So they don't get a minimum wage. So I'm kind of curious to see how the court's going to deal with that, since they are technically getting some kind of wage, and that there's no minimum wage protections. Like, that is okay for the Colorado DOC to just say that 10 cents is an appropriate minimum wage. I would be very interested to see how that case plays out.
I know the plaintiffs are arguing for some of those standards. So not just, I think, arguing that 10 cents is not sufficient and that they should be getting paid minimum wage. So, but anyways.
Yeah, I think Minnesota should do the same thing. I mostly looked at the federal level because I feel like it would be more wide sweeping. But I don't think there are any efforts in Minnesota to do that kind of same thing, but there should be.
If I could just add something to make that more concrete, and Professor Osler and I have talked about this. We get multiple letters from prisoners, envelopes covered with stamps, and you know that that prisoner paid for those stamps, at 10 cents or 15 cents an hour, and they've spent, how many hours they had to work just to send me the letter, which unfortunately I'm probably going to write back and say, I can't help you. And so, I'm kind of reminded, we're both reminded of that regularly when, it's a prisoner letter when you go to your mailbox and the entire envelope is covered with stamps. So it really has a concrete.
Yeah, because they want to make sure it gets to you. And when I first started doing this, the stamps that people sent from prison, almost ironically, all said liberty at the top. Other questions?
I have a question about the 13th Amendment, and I guess also maybe about qualified immunity as well. So I know the Fair Labor Standards Act you mentioned does not cover prison labor. Do any other federal or state statutes or regulatory agency guidelines like OSHA or other, prison condition statutes apply? Otherwise, has there ever been Eighth Amendment claims about working conditions while in prison, such as deliberate indifference to safety risk while doing certain work? And even so, would that then be, how would you bring that claim, and would it be covered by qualified immunity to immunize any government official from any of those claims? It's kind of a compound question.
Yeah, I'll start. So most of my research for this specific paper was about 13th Amendment claims that people brought and how conditions and things like that, that they don't have a pretty much any kind of basis to bring the claim. I didn't look into the Eighth Amendment, but I'm guessing that that's a route that prisoners then take because you could make that deliberate indifference prison conditions. I'm just thinking of the case we worked last week. For example, overcrowding is an appropriate claim to bring under the Eighth Amendment deliberate indifference. So I'm guessing you could make that basis for it. I don't know how successful it would be, especially considering how difficult it is to bring a deliberate indifference claim. But that would be the route they'd have to go because you mentioned OSHA. Again, because prisoners have been consistently labeled by the courts as they don't have a working employer relationship like we normally would have, say, with the school or your firm, they've said that prisoners can't be defined as employees of the prison that they are working for. So none of those regulations apply because they aren't even qualified as quote unquote workers.
I think the qualified immunity argument would be pretty powerful there. I mean, what the prison officials would say is it can't be a violation of the Eighth Amendment when the 13th Amendment specifically permits it. But let me take the question and kind of turn it around a little bit. Part of the reason that we're upset about this and we're hearing about this is because we've gotten information about how prisons are handling that. And so I want to follow up on this carceral secrecy point. We all believe, or at least we say we believe, in transparency of government. I mean, that should be something across his political lines, that we want to know what our government is up to and hold the government accountable. Have you found any success in crossing those political lines by pointing out, the correctional department is a huge part of the budget, as Commissioner Schnell was telling us.
Yeah. So a couple of points. One, I'm also going to talk about prison labor because so I published a piece recently in the Ohio Law Journal that basically is called Beyond the 13th. And it examines a lot of the questions that you just raised around OSHA and around why they do and do not apply. And actually what I saw in that litigation was that the 13th Amendment isn't relied on at all. And so one of the arguments that I've made in the past is that the 13th Amendment discussion is important, and to the extent that there's going to be amendments state or federally, it's not to disturb those efforts, but there's actually a lot of things that can be changed very easily just by regular statute, right? Of creating rights and thinking about the ways that courts address things. So for example, in OSHA, one of the issues is whether or not the state has its own OSHA or whether they are relying on the federal OSHA. And OSHA has not taken a position on whether an incarcerated worker is considered to be an employee formally, although their guidance basically says that, because they rely on this economic reality test, which has been applied slightly differently across circuits in the Fair Labor Standards Act context, right? But that is a simple statutory fix, right? All you need is one legislative law that says, yes, if you are an incarcerated worker, you too are an employee. And that has nothing to do with the status or amendment of the punishment clause in the 13th Amendment at all. And so there's a variety of things around pay, around work job choice, around the connection to personal development, as well as the last category, which I think is one of the most egregious, is around working conditions. And their Eighth Amendment litigation has not been successful. And so I recount in that piece a series of cases where the courts have been like, well, you know, that they're not deliberately indifferent. Did they know that they had a knee problem? Yeah. Did they know it was raining outside? Yeah. Did they still put the person with a knee problem up on a slippery roof to fix the electricity with no safety gloves? And did the person get electrocuted and fall off the roof? Yeah, but that's not deliberately indifferent, right? So it's a series of those cases if you're interested in that. But I think turning to the other question around secrecy, you know, I think there is a bill currently in Louisiana legislature. I might have looked at it, right? And you know, talked about the value of data transparency. And it is HB 812, if you want to go look it up, it's on the Louisiana legislature website, and it collects a range of data: admissions, bookings, number of people in solitary, types of treatment, counts in terms of serious mental illness, all like data points, right? And it's rich. And the opposition, which has been, from my understanding, pretty united from the local sheriffs, is not that they shouldn't have to provide it. It's just that it's really expensive and time consuming and that they can't, right? And so it is interesting the way in which, when we talk about the value of data, the sheriffs and departments of corrections will often agree. They're like, oh yeah, data is important, right? It helps us understand X, Y, and Z. And so we're not giving it to you maybe because of it implicates security, right? But then the other is it just costs too much and we don't have enough money or enough staff, and you know, we're already strapped as it is. So that's why you don't get the data.
You know, it's always been interesting to me that we do have a very rich data set on a certain kind of worker, and that is financial advisors. That if someone is going to handle your investments, you can look up all of the complaints against them and how they were resolved. So we can do that for people that handle our money, but for the people who handle our people, not so much. Christina, I'm going to give you the last question.
So this question is for Ms. Armstrong. I'm also interested in transparency, especially concerning rogue employees and abuse of discretion. Have you found anything in your research of a way to solve this problem? Because what I'm finding is perhaps maybe the best method to make sure our prison employees are not abusing their discretion is having an external complaints department or an oversight committee outside of the Bureau of Prisons, outside of the DOJ, maybe in like the Human Services Department. So what are your thoughts on that? And have you thought of other ways to solve this problem with transparency and making sure employees are accountable in the prison system?
Yeah, so are you thinking about transparency or really around transparency around people who abuse their positions? So primarily the second?
Yes, the second.
Yeah, so that is harder than the first, right? Which is why I asked. The first one, right? So my law students and I every year file about anywhere 150 public records requests on every single place in the state of Louisiana. And so each student is like getting calls from sheriffs, like, and the students are educating the sheriffs about this is what the public records law requires, right? And this is why you have to give it to me. And yes, I will drive up to your sheriff, to your parish and pick it up, right? So that is different. When it comes to officials who may have abused their position, there is an additional barrier, right? Which is usually personnel files. And those are generally exempted from all types of records requests and often sealed in discovery requests. So the ways that you want to think about that is, yes, independent oversight. And again, like, Professor Dolovich, I'll send you to Michelle Deitch's work around that. Thinking about independent oversight, but also independent oversight that has the power of a subpoena, right? And she's discussed a lot around the types of power that you can get from that. I also, I think that lawyers should make friends with journalists. I think that's generally a tried and true method because they develop sources, right? They also have this kind of often an institutional knowledge of different people who sometimes have been able to go from jurisdiction to jurisdiction, which we often see in these people who have abused their positions. And so thinking about what does a regional approach look like, one that is not just rooted at one particular office, but thinking about statewide initiatives as well, I think is really important when we think about creating institutions of accountability that can pierce some of these veils, particularly once you get into personnel issues, which are especially difficult to pierce.
So Professor says we have time for one more question. See if you can just hand that behind you there. Thank you.
Thank you so much for the really rich discussion. I have a two-part question. Feel free to answer whatever time permits. The first question is sort of maybe an observation. I'm just wondering if you share it, but particularly when you look at prison systems in places like Louisiana, Mississippi, I'm thinking of all of the panelists' research on the 13th Amendment. I'm wondering how much of the secrecy, the dehumanization that happens in prisons is really made possible by an express understanding of who is behind bars and who isn't. And so that's just one question. And then the second is, are you all as troubled by the effect of Pearson v. Callahan on the development of qualified immunity jurisprudence and specifically its ossification, insofar as there's no longer kind of a requirement that courts reach the merits of constitutional statutory claims, but instead can sort of just continuously kick out cases so long as the law is not clearly established, thereby not establishing the law any further.
To that first piece, I think that's the big problem. And I was really struck during your presentation about how that middle piece, that's where we don't have reform. And that's kind of exactly what mine was dealing about, was when people are in prison, okay, how are they being treated? And I think you're exactly right that the people who are in prison have been pretty much since the founding of this country been systematically dehumanized. And I think it was Professor Dolovich earlier said that the best way to fight, I think, all of our battles around prison rights, prison conditions is to humanize people. And once we do that and we see them, they're people, yes, they're incarcerated, but they're human beings, and they deserve, in my instance, proper working conditions, to be paid adequately for it, to have good working hours and not be subject to 18+ hour work days, which has happened in some state systems. And the effort behind that is so abstract and difficult, but it is the most important thing that we need to do, because once we start seeing those people as people, then it's easier to make that connection of, yeah, they deserve to be treated like I do when I go into work every day.
I'll just share. So I wrote a piece around the 13th Amendment and the punishment clause in 2012, right? And I was workshopping the paper with some other Southern law professors. And I was struggling with this idea of what is the harm, right? When we think about this exclusion and the diminishing of status, and like, how do we describe that? How do we capture it? Is it just a dignitary harm? Is it like this social exclusion? What is it? And one of the Southern law professors, she was really outraged, and she's like, it's got to be even worse when it is a white inmate, is what she said, because they were never supposed to be a slave. And I was just like, okay, right? So I say that to say that I often feel like this is a chicken and egg issue, right? That the way in which these institutions continue to operate and morph and respond, they are not rigid, right? They are nimble in ways of remaining relevant and poised to capture additional revenue, right? The secrecy is essential to that element. At the same time, secrecy was also justified based on our value of the people who were going into the system historically, which Megan really expertly laid out. So I'm not sure it is either or. I actually think it's both.
I'll briefly answer the second part of it. Yes. Others have written a lot more about that particular aspect than I have, but it's certainly something that you encountered. The clarity of the law, the job of the courts to tell us what the law is greatly impaired by the ability to leap to the second prong and bypass the first prong. And courts do it very regularly. There is, I think, some reason for optimism on that. There are members of the court, including those who you might not ordinarily suspect would be sympathetic on these issues, who have some real doubts about qualified immunity as a doctrine, the way in which it's defined, the way in which the ordering of those rulings. There's a possibility that we may be seeing change. For a while there, I thought there might be legislative change. I'm less optimistic of that going forward, at least at the national level. But there is ferment within the courts, and I mentioned earlier that political diversity, a lot of libertarian and original intent scholars, like William Baudet at Chicago, have pointed out it has no historical basis. Qualified immunity is an invention of the Supreme Court in the 70s. So maybe we'll see something even with this court that will be positive.
Right. And we're on break until 3:15. I'd really urge everybody to come back. Our last panel is going to be people who have been directly impacted by everything that's been talked about previously. So let's thank our panelists, including remotely Professor Struve.
Let's go ahead and start our final panel of the day. So when academics and lawyers get together and have conferences like this, we talk a lot about all the things we do for our clients. And we often forget to actually include our clients in that discussion. This would have been especially a wrong step to take today. Since our purpose today is to give voice to those who are often forgotten, and to talk about the experiences that they have had, it's essential to hear from those who have actually walked the walk. I'm just so delighted with the three we have here today. I'm going to introduce them each, and after I introduce them, I'll start with Ore, who is with us on the screen. I will give him an introduction, a chance to say hello. And then I'll introduce our other two and give each of them a chance to say hello. And then I have a series of questions. And for those of you who are experienced in prison rights litigation, you'll recognize some of these questions are pretty simple and basic. But there are those here in the room who are still learning about this. And I think it's important to ask some of those basic questions. And then we'll make sure to save some time at the end for you to ask questions at all. So the first person I want to introduce to you is a former client of mine, Ore Pfeiffer, who is in Spokane, Washington, appearing to us by Zoom. And he successfully sued the United States government under the Federal Tort Claims Act for excessive use of force by correctional officers. This was something that he did a fantastic job handling this pro se before the district court, established a wonderful record, unfortunately lost before the district court. And then we took on his case with the appellate clinic and managed to win the appeal. But of course, as I'll say more at the dinner tonight, and as Corinne has pointed out, winning doesn't mean the case is over. So the next step then was to go back for trial, a bench trial before the same judge that had granted summary judgment against us. And we found an attorney to handle that in Arizona, and Ore testified, and the district judge found that in his favor, found that liability had been established and awarded damages. One more thing before we hear a little bit from Ore. I hope I don't embarrass him by saying this. He is one of the most positive people that I have ever known. And I think I've told Ore this before, but if not, he's hearing it today. There were times, I'd be having a down day for reasons that are pretty minor, and I'd get an email or have a telephone conversation with Ore, and by the time I was done, my spirits were lifted. So Ore, welcome, and say hello to everyone.
Hello, everyone. First, I'd like to thank the Professor Sis for having me here today in the University of St. Thomas. Point out that we successfully sued the government and won. So all credit to Professor Sis and Catherine, both Catherines who helped on the case. I think there was 3 Catherines, wasn't there? In the district court, it was Catherine.
There was a Caitlin and a Catherine. We've lost your sound. Well, we'll do the best we can. So glad to have you here.
Trying to learn and correct my behavior and coming in, trying to.
Well, unfortunately, with Zoom, we sometimes have technical difficulties. So you're freezing up a bit for us.
Okay, can you hear me now?
Yes, you're better. Yes.
Okay. I just try to come in assist and come in and learn and go out better than I did before. And I believe I've had some hiccups in but the whole thing about having hiccups, when you fall off, you get back on the horse again and try to not make the same mistakes twice. So again, I thank the professor and the University of St. Thomas for having me here today to speak before everyone here today, and that's me, Ore Pfeiffer.
There you are, Ore Pfeiffer. All right. So the next person I want to introduce, and let me turn to this, and I hope you look at the bio in the program as well. Rudy Martinez, he said to me, please describe me as former federal commuted prisoner. So Rudy spent 25 years in prison on a mandatory life sentence for non-violent drug offenses. He was granted clemency by President Barack Obama in 2016. And I'm proud to say that clemency petition was supported by our own Professor Mark Osler, who established the first in the nation clemency federal commutations clinic. And he remembers so well and is so honored that he was able to make the phone call to Rudy that the clemency petition had been granted. So Rudy, say hello to everyone if you would, and hello. A few words if you'd like.
Well, first of all, again, it's always a pleasure to be asked to speak. I believe this is my 3rd time here in St. Thomas, and what I owe this school is impossible to pay back. But I guess the only way to do that is to continue living and hopefully setting that example for those who are still incarcerated and have those life sentences, because I'm still in contact with many that are incarcerated throughout the United States. And they're actually counting on me. Like, don't mess up out there, because, and it is true. It's a lot of pressure. But again, I owe gratitude to St. Thomas, of course, Professor Osler, and
and Bruce Rubenstein, who was also an author here in the Minneapolis magazine, wrote a story in Minneapolis magazine that really catapulted my case to the eyes of Mark Oster here and you guys. So thank you, and thank you all for attending today. I know it's been late, but that extra credit will come in handy.
You attorneys have to be here to get your CLE credits, so you can't claim all the hours unless you stay to the end. Paul Wright is really a legend in this field. Anyone who has spent any time working on prisoner rights cases, and I learned this very early on, know the importance of prison legal news. And have followed the travails of prison legal news and being able to get access to the readership in prisons. Prisons not wishing other prisoners to be aware of all of those pieces of news. He was in prison for 17 years in the state of Washington. Until his release in 2003, and he continues to work as with the Human Rights Defense Center, especially on issues about censorship for prisoners. So welcome, Paul. Say hello and give us some thoughts.
Hi, thanks for having me. For those of you that aren't familiar with prison legal news, I brought some copies. They're up on the thing there. So like crack, the first one's free. So, which actually I've never heard of anyone actually giving away crack, but it sounds good. So, and we had some talk earlier today about the Prison Litigation Reform Act. And one of the things that the Human Rights Defense Center does is we publish a number of books aimed at both pro se prisoner litigants litigating their own cases, and also for practitioners that are also doing their own, also representing prisoners. And so, as you can see, this is a big book, so I was only able to schlep one with me. If anyone's actually litigating cases involving prisoners and you're going to encounter the PLRA, this is like the book. And the good thing is there's nothing else on the market that covers the PLRA. So it's good to have exclusivity and a good product. So and these books are available on prisonlegalnews.org as well. So I've been doing this, as Greg mentioned, I've been doing this pretty much since I started Prison Legal News in 1990. I started the magazine while I was in prison because I thought that it was important for prisoners and their families to have a voice in what passes for criminal justice debate in this country, which isn't much. And since then, we've grown as what there was of the prison press or the penal press in this country. When we started in 1990, we had around 1 million people locked up, and there was around 50 or 60 independent prisoner rights publication. Today, the prison population has more than doubled to over 2 million, and it's pretty much us. So, and the interest in prison publications hasn't gone down because of a lack of interest among prisoners and people interested in progressive criminal justice reform. It's literally been stomped out because of state repression. And one of my jokes is I hope to someday live in a country that, you know, respects the role of a free press and an independent media, but hey, I'm not moving to Iceland anytime soon. So, so we're doing the best we can here.
So I'm going to ask a series of questions. I think I'll start with Paul and move in opposite order. So the first question is really, the question itself is wrong, because I think you'll tell me immediately that there is no typical day in prison. But tell me, build on that. What was a typical day like for you during those many years of incarceration?
There's a journalist named Ted Conover. He wrote a book called New Jack, and he likened. He went to work. He wanted us to see what things were like in New York prisons. They wouldn't give him access to a prison as a journalist. So he decided to go work in one. So he went through the whole process, got a job as a guard, and he worked at, I think it was Sing Sing for around a year. And I think he summed it up when he said that, prison is kind of like a fireworks factory where everything is quiet and monotonous until it blows up. And I think that's probably a pretty good analogy. Prisons, I think in general, are pretty boring until they're not. And, the stuff that makes it into, I think, literature, drama, the movies, of course, the dramatizations are, of course, the more exciting days. But, like everything else, I think that one of the bad analogies about trying to analogize, typical days in prison is also they vary by the experience. I think that, one of the other analogies is like, if you ask soldiers, what was it like being in the Army? Well, it depends, where we're at. I was in the Army, but I served in Germany in the 1980s, where all we did was sit around, drink a lot of beer, and play soldier. So, that's a very different experience. Whereas even during the Vietnam War, some guy may be in an infantry unit humping through the jungle, another guy's at an army base making sure no one runs out of blankets. Overall, I'd say, prisons are generally somewhat boring, but it also depends where you're at. I did time mostly, pretty much exclusively in maximum security prisons in Washington. Even among the maximum security prisons, they varied wildly. The Washington State Reformatory at the time, that was the place to be in Washington. You're close to Seattle. You had programs, you had activities. There was educational programs, and the guards were a little more civilized. You go to Clallam Bay, which is on the Olympic Peninsula. You have an all-white guard force. They're pretty reactionary, pretty open about their membership in the KKK, which, being from Florida, I didn't even know they had KKK chapters in Washington. I thought it was very much a Southern thing, but what did I know? And not a lot going on. There's, maximum security prison, and there's maybe 50 jobs for 900 prisoners. The Washington State Penitentiary is kind of in a category all its own. So again, I think it varies, and literally every day is different, and a lot of it comes down to what are you doing? I published prison legal news for most of the time I was incarcerated. I went into prison in 1987. I started prison legal news in 1990. So a lot of my stuff was writing. I maintained whatever prison job I needed so the administration could say I was dutifully employed. When I was at the penitentiary, they said I couldn't work anywhere because I was a security risk. So I thought, hey, this is great. I can work out and write all day. So other places, it's like, oh, you've got to work, and okay, I'll be a janitor and I'll clean the gym for a couple hours, for 15 minutes, and then work out for 2 hours and then write. So I think it varies very much depending on, where you're at. Then there's stints in solitary confinement. My joke was that regardless of where I was or wasn't doing, prison administrators wanted to make sure I could, go to solitary at least once a year just to check on the conditions there and see how things were going in seg. Again, it kind of, it very much depends.
Rudy, same question?
Mine was a little bit different.
Okay.
State prisoner, Walla Walla, is that correct?
All of them.
Yeah, Walla Walla. And Walla Walla is one of the most well-known. I mean, you could be in the East Coast and you heard of Walla Walla. So, it was as we say, referred as a tough joint. But I was a federal prisoner. And in the feds, it was a little bit more, as guys in the state would say, oh, well, the feds are soft, it's easy time. But that wasn't the case. Unfortunately for me, when I first got to Leavenworth, which wasn't my first stop, actually Terre Haute, Indiana was, but I only lasted a month there until they transferred me to Leavenworth. And when I arrived in Leavenworth in 1992, they had just brought all the Aryan brothers and the Mexican mafia guys from California because they couldn't control them in the state. So the feds, bright idea, say, well, we'll control them. Biggest mistake they ever made. So during that time, these guys decided to make what they call a commission, get organized. And this is at Leavenworth. So tensions were high. And, as Paul said, the institution can go up anytime, which, riots and what have you. And sure enough, 1992, we had the riot July 5th inside the auditorium of Leavenworth. And I'm stuck right there in the middle of it, 2 months into my time, and 3 people get killed. And it was just a big mess. And that really woke me up, because from that day on, my whole attitude had changed. Now, mind you, I was a first-time nonviolent offender going into my very first prison, never been incarcerated. And I actually came out to the yard with a smile on my face. And I remember this Mexican guy walking by me with another guy in Spanish telling me, what the hell is this guy smiling about? But, I spent so much time in the hole at MCC. I was just happy to be out, in the sun. And just to show you that's how naive I was. But yeah, after that day, July 5th, 1992, after that riot, I realized that this is a whole different world. I actually knew that when I walked into the chow hall of Leavenworth, And I was fortunate enough to grow up in Uptown, the north side of Chicago, which was the melting pot of the city as far as I was concerned. You walked into that Chow Hall Leavenworth, 500 inmates there, and it was segregated, whites, blacks, Spanish, Native Americans, and that's just the way it was. So where do I fit in? You know, and I'm walking around like an idiot with the tray, where am I gonna sit at? You know, I feel like I could sit anywhere. I made the mistake by sitting at the AB's table. Unbeknownst to me, I was like one of the first people to get there. And next thing I see, here comes a bunch of white guys and they're looking at me. They're like, "Hey, Holmes, what are you doing here?" I'm like, "I'm having lunch." They said, "No, your people sit over there." I'm like, "My people?" And then I realized, well, there's some Native Americans there. My father's Native American, my mother's Mexican. And so I went over there to the Native American table, you know, and then, "Where are you from?" "I'm from Chicago." "Well, they're from the South. They're Hopi Indians." You know, and that's just the way it went. Until finally I established my own table with my own friends and what have you. And it was the only mixed table in the whole joint. And that right there placed me as a bad guy, because the last thing the SIA, the special investigating agents there in the prison, they don't want unity. You know, they want you divided. That's how they control you. So they see a table with Native Americans, African Americans, Mexicans, Puerto Ricans, Cubans. There's a problem here, man. Who are you? You know, how'd you make this happen? We can't allow this in the institution. And that's pretty much how my journey kind of started, because they called me into the office. "Hey, what are you doing? Who are those guys?" Blah, blah, blah. You know, and that's just a sad fact of you know, being in federal prison, the penitentiaries. And you know, that discrimination holds true today. And how'd my day start after that? Every institution that I would go to, you had to make your knife. You had to have a knife, you know? And it wasn't a thing in 25 years that I didn't use it. And I thank God that I didn't have to use it. But I'll tell you what, it always felt comfortable having it. As I told Mr. Osler, I was worried when they were first doing my commutation papers, the motion, because I was like, "Listen, I got a few incident reports here of me carrying knives." But I never hurt anybody, but nonetheless. And, you know, I was the guy who didn't mind going to segregation because I spent so much time in segregation. To me, hey, that was, you know, the stress reliever right there, going to segregation. And I remember they found a knife on me in the yard, and the lieutenant asked, "Why is it that every time we take you to the hole, you got a big smile on your face? And what are you doing carrying this knife?" I said, "Listen, you know, the old adage, I'd rather be caught with it than without it." And that was my attitude for 25 years. Yeah, that was my day.
So Ore, I know you've been in more than one, you were in federal custody as well, and in Arizona and Alabama. Give us your sense of what a typical day was like for you.
Well, I've been in 5 federal prisons. I was also in the state, Walla Walla, Column Bay, Monroe, McNeil. And the difference between state and federal is night and day. So my typical day was, well, when I first prison I went to was in Colorado, and you know, I didn't know anything about federal prison. I just thought maybe it was the same as the state, but it's really not the same, because the feds are broken down. It's politics in the state, but you have different politics in the feds, because you're dealing with people all over the country, from state to state, even from other countries. So when I first hit Colorado, my friend, he'd been down, I think I hit the federal prison in 2001. And my roommate, he'd been down since I think 88. So he was breaking all the different rules down to me. And you know, when you first come in, you go to the receiving center, you have everybody will come up there and talk to you before you hit the actual compound. And the captain to tell you, SIS will be there and tell you, and sometime they'll tell you, you know, depending on what prison you go to and how violent it is, they'll ask you straight up, if you've told on somebody, let us know so we can remove you, not put you on the compound. Whoever your people is, get with them. And, you know, they have a unwritten saying, that unwritten rule that they tell you behind the scenes, is that if they're compound violent enough, they'll tell you, well, get with your people. you're probably gonna need a knife on this compound, because if someone start come at you, we're not gonna be able to save you. And a lot of time I've seen people get stabbed up and the police be right there, and they're really taught to just watch until you're done and drop the knife when you drop the knife, and then take you to the shoe. So like a week while I was in Colorado, I was on the phone, and the Sureños and the Paisas got into it over some wine. So this particular prison got a hallway, and the hallway is small, but the phones are there. So you have at least 30 guys on this side and 15 guys on the other side. And it's a small hallway. So these guys going at it, hitting each other with knives and throwing mop buckets. And I'm on the phone, and I'm like, what the heck is going on? So my roommate, who's been there, he had to fight through the crowd to grab me and pull me through the mesh of fighting and take me to my cell. And he said, look, man, you cannot be in nothing like that in the middle of that, because them guys are fighting and they're stabbing wildly, and you can get stabbed and get hurt. And that was like my first introduction to federal prison. So, and after that, there were several more incidents. So I just made up my mind to where no matter what the incident was or where I went, I was there to change my attitude and to change my life. So I particularly stayed in the law library, and they have places there called Unicor where inmates work, factory work. Usually, mostly Unicor do contracts with the military. So I stayed when I come back from Unicor, I go in the morning, go to work at Unicor, and I come back and I go down to the law library, work on my case and work on other people's case. And I try to occupy my time all day, whether it be that or play sports, and keep myself out of the way, because as stated before, you could wake up and walk outside your cell, and the tension is so bad that it could be cut like a knife, because somebody could have done something. And now, in particular, when I was in Phoenix, that incident with the riot with the blacks and Mexicans, that Professor Sis helped me on the case. It was the same thing. I walked out the cell, and there's people lined up upstairs, downstairs, and some incident done happened earlier that day I didn't know anything about. And then from there, the whole prison exploded. So it's a typical day is just me trying to stay out the way, but sometimes you just can't in that federal prison, because you're within that fence, and anything that happens could affect you. Even if you don't know it, it could affect you. So you just basically have to stay positive and just stay away from everybody, and just have tunnel vision as to what you want to do with yourself when it comes to bettering yourself, and just stand out the way. And that was my day there. I would go to work, I try to go to the law library, and then I would go work out, and then I come right back to the cell, and that was my day.
And as to follow up on that story, even when Ore is staying out of the way, minding his own business, trying to stay out of it, that's when he got shot in the face multiple times by a correctional officer with munitions that led to that case. So that doesn't always work, does it? So Ore, let me follow up with you and start with you on the next question. What was your worst day in prison, and why?
Well, my worst day was, I was in a prison called FCI Herlong, and I woke up that day to go to work to Unicor. Unbeknownst to me, there was same thing in Phoenix. There was some guys standing around, a few of them standing around, they talking. And when I particularly walked by, they stopped and just looked at me and just started whispering. So I kind of got a funny feeling, but I really didn't think anything of it. And I went to work. So at work, this guy out of Detroit came to me and said, "Hey man, did you hear about your friend from Seattle?" Because I'm from Seattle. He said, "Man, they ran in his cell and tried to jump him." So I was like, "Nah, I ain't heard nothing about it." So he was like, "Well, yeah, that's what happened, man. You need to go talk to him." So at lunchtime, I went and talked to him, and he said, "Yeah, they ran in his cell, and they were supposed to go out to the yard at 12 o'clock with the other guy to talk about the incident and try and squash it." So I went back to Unicor, and I told him after I get out of Unicor at 3 o'clock, I'll come back and talk to him and see what happened. So I guess all that day while I was in Unicor, he was at rec, and they kept coming down there trying to beat him up. And this is what they do in federal prison. Once you have one incident with a person, and if the captain don't take you off the yard, they'll keep coming at you and keep coming at you until they get off the yard or you get off the yard, right? So when I came out of Unicor at 3 o'clock, I went and talked to him, and he said, "Well, we supposed to all meet out at the yard at 3 o'clock. Now, mind you, this particular prison had a unwritten rule between the SIS, the captain, and probably the warden too. They had a rule that if I have a problem with you now, federal prisons go by cars. So depending on the car you're in, you might have a race car like the ABs, that's a car. You might have gang members, the Bloods, that's a car. Or you might have, if you're not part of any of them groups, the state where you from could be considered a car. I'm from the state of Washington. So all them guys from the state of Washington might hang out with each other. So my particular car that I was in, that I was associated with, everyone associated with, is because I'm from the state of Washington. So it don't matter if I don't say that I'm associated with that car from Washington. I might say I'm on my own, I'm not with that. They're still going to associate me with that because I'm not a gang member. I'm not part of a racist group or a religious group. So I'm an individual by myself. So they're going to associate me with the state of Washington. So when anytime somebody from the state of Washington get in a fight, they're going to also come after you too, because you from the state of Washington. So we went out to the yard, and what I was saying earlier, the captain and the warden on this particular compound, and SIS had a rule. If I had a problem with your car, we had a problem, they're going to give you, go out to the yard and try to resolve the issue. If you can't resolve the issue, they're going to give you 10 to 15 minutes. The loser get off the yard. And as you can imagine, this particular yard was wild because everybody that had a problem would go out to that yard and they could never squash the incident. You can't come to a peaceful conversation and try and work it out, because those dudes, once you go out to the yard, there ain't no talking. We just gonna lose or get off the yard. And I went to the yard to try and talk with my friend and those people that got into it with him for running in his cell and trying to stab him and beat him up. So we basically thought that we had a deal, that the incident was squashed and we was gonna move forward, but evidently not. So when we went to the other part of the yard and I was talking to them, just all of a sudden out of nowhere, just like 30 dudes just rushed us. And man, we tried to handle our own with that, but it was just too many of them. And he got knocked out, and my other friend got stabbed up, and I got my nose broke and damn near messed up and had to go to the SHU. And basically we was the losers. So we end up having to get off that yard, and I got shipped to Phoenix. And as you said earlier, I wasn't even there 6 months and got in another ride and got shot 6 times in the face. So that was like one of my worst incidents. Well, actually, the 6 times in the face was my worst incident, but that incident right there led to that incident. And when I was in Victorville, I got to Hurlong because I got stabbed there. So it was just that it was just all bad on those West Coast prisons. And my friend told me when I was in Colorado, he said, do not go to those West Coast prisons. And when I was laying there after getting shot that 6 times in the face, and all I could hear his voice in my head was, don't go over there. Don't do it. Don't do it. And
Go to the West Coast. Well, let me turn this over to Rudy, the same question.
The worst day of my life.
The worst day in prison.
Oh, the worst day in prison, same thing. I have to be honest with you. It was the day that we had waited 2 weeks. They were deliberating my case for 2 weeks. It was a CCE case, which was a large case. And I had a court order to dress out every day and to take showers every morning. I was coming from segregation before I went to court. And this particular morning, they refused to give me my clothes or give me a shower because they were running late. The lieutenant was running late. And I told him I'm not going to get on the bus until I shower. He got upset. One thing led to another. I refused to cuff up. The bus left. And now the court's upset because I'm not there. And judge finally finds out, realizes, okay, they haven't given him a shower that I gave a court order to, nor his clothes, and called. Now they were forced to do that. That day, the verdict comes in. I'm found guilty. I come back to the SHU, to my cell, and realize that they had stripped everything. Everything was gone. Mattress, my clothes, my personal belongings, everything. And they had spray painted the window. There was a little window, probably about 3 inches wide, and about 6 inches, or it's about 6 feet long. And that window, you could look outside downtown, Van Buren, MCC, in Chicago. It used to be a Chinese restaurant with a neon light and a pawn shop. And while I was there, I would always look downstairs and watch the people walk and what have you. But anyways, when I come back from being found guilty, they had put a white coating on there. And I go inside the cell and I'm just looking, I'm like, wow, look what they did. Nothing's there. I'm not gonna go off. I'm too tired. So they take off the cuffs and I sit down, put my back against that window, and you can still see the neon light flashing on and off. And I noticed that there was a paperclip on the floor, and I picked up the paperclip and I opened it up. And I got to thinking, and I'll tell you what, if you ever been to an AA meeting and they tell you to take inventory of your life, if you haven't done that, any of you, I really strongly suggest that you do. And I try to go back as far as possible to try to think, how did I get in this predicament? I know what I'm facing, a mandatory life sentence, but the back of my mind, I was thinking I would never get that sentence. I would probably get 20 years. And as I'm going through my whole life, I left home at 15, stayed out there in the streets, selling drugs at an early age. And I find myself here now. And I always remember, because it was me, my brother, my sister, and my mother. Back in the 70s, the government would come by with their government trucks and they would pass out food, government cheese, big blocks of cheese, right? Which we love because my sister made the best grilled cheese sandwiches out of that cheese. Right? So my mother would give me, my brother, and my sister, every Friday we would go to Sheridan and Foster and we would each get a box of this food and we would bring it back home. And so there was always peanut butter in these boxes, always the big piece of peanut butter. And so no matter if my mother was alcoholic, whatever the story is, I don't blame her. I did what I did. I know what I was doing. But even if there wasn't food, there was always peanut butter and tortillas. And to me, that was a meal. So here I am. I don't realize how much time has elapsed until I put my hand on the floor and it's wet. And I'm like, what the hell? Why is it wet? And I realized that I had been crying. And snot's running out my nose, whatever. So I must have been there for a couple of hours at least, while I'm taking inventory of my life. And that snapped me out of it. I was like, what the hell? And so I'm like, damn, and I realized how just exhausted I was. And something caught my eye underneath the toilet and the sink, the silver toilet and sink that's against the wall. And I saw something shining underneath there. And I crawled over there and I reached my hand underneath there to pull out that object. And that object was a peanut butter jar from my commissary. So when they took out all my stuff, and, had the bag of my commissary, the peanut butter must have rolled out and rolled underneath the sink, right? So the jar, the top came off, so all you see is the aluminum foil. That's what caught my eye. So I reached under there and I grabbed this thing and I started laughing to myself. I'm like, peanut butter is still here, And honest to God, I was just happy because I'm like, this is hope, I got that paper clip, and even though at that time I was probably at my lowest point in life, there was a mirror that's made out of metal, so you really can't see yourself in there. But I remember that sheet inside there, never give up. So, when I hear these stories, the other lawyer that was here, the gentleman from Nigeria, telling that story, how, you think you're going to win, but you don't. Honest to God, I wish that for you students or those that are fighting this cause, if there was a statue to give you guys, what is the guy who pushes up that rock?
Oh,
I would get a statue of that, and I would give you guys that, because it's very important that we don't give up. And that was the worst day of my life. Yeah.
Well,
or day of prison, anyways.
I say pretty much the worst days I had while I was locked up was getting convicted and getting sentenced. But, I can say that I did 17 years in prison. Dakota, our beloved former President Trump, in real shitholes, and that's one of the things too, is not to get into the misery Olympics about, hey, what are the good prisons or whatever. It's like, they're all bad. They're bad in different ways though. One of the things I think that, I've always been pretty positive about keeping things on a positive outlook. And I've looked at it that I'm 56 years old and I spent 20 years in the military and 3 years in the military and 17 in prison. So I spent pretty much from the time I was 18 until 38 in violent paramilitary male dominated institutions. And I can say that, looking at the positive, I've never been beaten. I've never been raped. I've never been pepper sprayed. I've never been tasered. I've been shot at, but fortunately my opponents were shitty shots. So no hits. So that's good. I've never been stabbed, like Warray here. So, and I got jacked around in prison. I mean, from not too long into my sentence, I decided that I really didn't like my conditions of confinement. I didn't like the way I was being treated. And I was going to try and do something about it. And I'd say that, probably for me, more than an organizer, a jailhouse litigator, or a jailhouse lawyer, I've always viewed myself more as an activist. And the writing is just a tool. Litigation is just a tool. This is just one way to accomplish a goal. And, along the way, I've organized work strikes. I've organized food boycotts. A lot of different, I've lobbied the legislatures, everything else while I was in prison. So, and yes, I've been retaliated against. I went to the hole a lot and everything else, but I kind of look at that, that's just kind of like goes with the territory. And, if you're signing up for it, if you're signing up for the life of an activist, you can't be a critic of the American police state and not expect to be repressed. Like that's exactly the point that you're criticizing, is that it is a repressive fascist police state that doesn't respect basic human rights, including the right to free speech. So, it's not really a surprise when they act like fascists. So that's why I say in terms of, negative, the bad days in prison, on the one hand, they were all kind of bad. On the other hand, there's a lot of good times, and I think that's kind of a flip side of it. I think that.
Well, that's my next question. When was your best day in prison? So you can go ahead and follow up with that if you'd like.
Yeah, I'll segue into that. Is the fact that I think that a lot of things is, not to get overly philosophical or too zen about things, but I think a lot of it is just it depends on you can have a good time with good people regardless of where you're at. I mean, some of the best memories of my life were times I spent in prison with friends of mine. Like, it's like one of the things being in prison. I don't use drugs, so a lot of the people in prison do. So, like a considerable portion of their time and energy is spent getting drugs. But if you spend your time and energy on other things, I like to eat. So scoring a smoked turkey breast in a maximum security prison or getting a rack of barbecued St. Louis ribs into prison, that's pretty impressive. And I can say I pulled that off. And then then I got my buddies, hey, we're gonna have some ribs for Christmas. And it's like, and I tell one of my good friends, I say, Jimmy, you work for the captain, you're his janitor. Ask him if you can use the microwave to warm up the ribs. And he's gonna ask me where I got the ribs, Paul. And I'm like, well, you ain't gonna ask too much, you're his janitor. So I think that's one of the things that I think that that you can say is that regardless of where you're at, you still have valuable experiences. And I say that it's not all negative. And a lot of the guys I did time with, I guess I'm getting old here. But guys I met like 30 years ago and the late 80s and the early 90s, we're still friends. And it's in a lot of respects, I think, that's just it, whether you're in college, whether you're in the military, whether you're in prison, you can and do make, valuable relationships. And I think it doesn't really matter where you're at, in terms of that. The other thing I'll say too, is that, I certainly value the support that I got from my family. And, and my parents lived in Florida, but at least once a year, they schlepped out to Washington to visit me at one point or another. Most members of my family made it out to Washington at least once or twice in 17 years to see me. Even, it was a lot of sacrifice for them. So I think that that's also the flip side of it too. I'm on really good terms with all the folks that took the time in my family that took the time to come see me. I don't talk to the ones who didn't, because I'm kind of like, hey, you didn't have time for me when I was locked up. What makes you think I want to have time for you now that I'm not? So, but so I think in a lot of respects, it just kind of, human experiences, I think, replicate themselves wherever you're at.
So Rudy, I'm going to ask you that question, but I'm going to make it a little harder. It can't be the day you found out that you got clemency. You got to choose a different day.
Wow. Other than the day they were telling me I was going home, huh?
No, that's too easy.
Well, to give credit to Paul, the guys who worked in the library, the legal cats, they were, you didn't mess with them. They had a ton of respect, and I didn't read a book until I was incarcerated. And shortly thereafter, something happened to me where I was transferred to Cook County Jail, put in handcuffs and shackles for 112 days, consistently every day from 7 o'clock in the morning to 10 o'clock at night. And Amnesty International had interfered with that. They came in and stopped all that. And they had no choice but to transfer me back to another division in Cook County Jail, which was the basement of Division 1. And I remember telling my story to a guy, and he's like, man, they violated your rights, bro, and he's telling me all these things they did to me, but what am I going to do? And I say everything happens for a reason. There's the book card, and I'm going through books, and now I started reading constantly. And there's this book called the Prison Litigation Manual, and it had a bunch of pages missing, but it had the amendments, and I'm reading the 8th Amendment. I'm like, oh, wow, this is so cool. This is being cruel, unusual punishment, whatever. And I'm reading the rest of it. I'm like, okay, well, what do I have to do in order to file? And back to the 2 young ladies who were doing the stuff on the courts regarding fees and what have you. Back then, it was like $50. It was nothing. I think now it's like 300 or whatever it is.
4
yeah.
or 5, I think.
So, I go get this book that I always thought it had something to do with dinosaurs, but it's called the Thesaurus. and I get the dictionary, and I got to write the statement of facts. That's the first thing I got to do, So I said, well, I'm going to try to sound intelligent, use some of these words here. So it took like 2 weeks to write like 3 pages statement of facts, but I got it in, and I got representation from Jenner and Block. And I didn't stop from there, because I won my case that they had brought me over to Cook County Jail for. I went back to Leavenworth, and I was placed in segregation again. And, they used to leave the lights on 24 hours in there. And I used to put newspaper on top of the lights, and they would give me incident reports for covering up the lights. But, for months, I would probably be in segregation. And so I filed on that. That was my first filing to the courts in Kansas City. And they had to put switches on the outside, so they were really pissed. And slowly but surely, this is how I end up moving from institution to institution. You know, I didn't believe in working in Unicor. I didn't believe that, you know, we should make 18 cents an hour, but yet the cost, they're not making the adjustment for the cost of living. I remember when I come into the feds, you know, a bag of Doritos was, you know, $1.25, you know, and when I left, it's like $5.50, but yet you're still going to pay 18 cents an hour. And I would encourage guys, don't go to work, man, don't go to work. Next thing you know, in the middle of the night, I'm getting cuffed up, I'm put on the plane or the bus and I'm with the next joint, you know. So this is how I end up in 11 institutions because it wasn't because any disciplinary, you know, it was a simple fact of you can't let these guys push you around. You just can't. And just a really quick story, I ended up in Marion, right? The so-called toughest prison in the United States. And I end up in Marion under a fictitious incident report. And who am I there with? John Gotti and Jeff Fort. And I'm sitting here eating breakfast, and here's John Gotti, and Jeff Fort introduced me to John Gotti because Jeff Fort was from Chicago. I don't know if you guys know who Jeff Fort is. He was actually the leader of the Al Rookins back in the late 80s. They were arrested for domestic terrorism. And this guy was very well known in Chicago. And here he is in front of me, you know, welcoming me, you know, hey, homie, you're from Chicago. Okay. And he introduced me to John Gotti, and I'm sitting there, and in the back of my mind is, what the hell am I doing here? How did I get here? In Marion with these guys. I don't belong here. And they sent me there on what they call a classification 332, closer supervision. But I didn't do anything, you know. And this is what happens when the feds or the state have a paintbrush in their hand and they can paint you any way they want, you know, and they can make you dangerous and sound dangerous. And that's what happens often. But I think going back to what you asked as far as my best day was my first filing in Cook County against Cook County Jail and getting representation from that case. Yeah, for sure.
So same question for you, Ora, your best day.
My best day was like when I seen a friend, while I fought a few cases, but this one particular case that I won, I had a friend who had 13 life sentences. And when the First Step Act came down, I helped him file on that First Step Act. And his case was a little complicated. And, you know, when you're doing time in some of these prisons, you have a lot of guys with a lot of time, life sentences. I had a cell who had 90 years, had a friend who had 232 years as a result of 924Cs ran consecutive. So some of these dudes, when you look at them, they don't have no hope because the amount of time they got, and they've basically accepted the fact that they're probably going to die in prison. So when I filed that for him and I argued it and we mailed it, and he ended up getting an attorney, and the attorney stated that the brief was so good that all he was going to do was modify a couple of things. Well, that guy ended up one day getting a letter from his attorney and an order saying that his life, all his life sentence been dropped down to 360 months. He's already been incarcerated for 26 years, so he was immediate release. So he just couldn't believe it. But to see his face change from no hope to where he's just like, you know, just stunned. That was one of the joys that I got from that, and was one of the happiest days that I had in prison, because in my head, and he wasn't the only one that I helped get out of life sentences, fight their cases, and win their freedom back. It was a few of them, but his particular case was unique because he had 13 life sentences, and he just thought he would never get out. And in the back of my head, I guess with the 25 years I got, I always thought everything in life happens for a reason. And somebody sent me to that prison, that federal system, for a reason, to learn the law and to help some of those guys out that didn't have hope, that thought they would never get out. And they end up winning their cases and from some of my help and from some of the other attorneys' help after they got the initial petition, and some of them guys got out, and you know, some of them cases I won with them guys with life sentences, those were probably the happiest times that I've had there beside me getting my college degree.
Well, and you can see why, as I said earlier, I would hear these stories from Ore and I would always feel uplifted by the end of the day. Just really so thankful for you and those stories. So one last question, then I'll turn it over to the audience. I'll start with Rudy this time. What do you think people don't know about prison that they should know?
Again, I can only speak for the Federal Bureau of Prisons. And I think I don't know if many of you realize this, but it's very difficult to get into the federal prisons, penitentiaries. You can do interviews in the FCIs or the camps, but you'll never be able to get inside behind those walls. And there's a reason for that. They don't tell you about the statistics of the people who've been injured in there, because it goes against whatever wherever that prison may be in some rural area. The funny thing is, when census comes around every year, we have to fill out that census card. So they're benefiting off us as prisoners, and you know that rural community is making money off of us. But yet they won't tell you how many people got killed that month or whatever, because you know the assaults and all this stuff has to go on record. And they hide that. And that's always bothered me. You know, I don't know how here we are 2022 that is still allowed to happen. And, you know, even going into the penitentiaries to see your clients, you know, is difficult. You were talking about the phone calls and what have you. And I think that's something that a lot of people don't realize. Ask yourself, when have you ever saw an interview from the Federal Bureau of Prisons in a penitentiary with any inmate? And if you know one, please let me know, because I haven't seen it. And, you know, I wish I spoke to the commissioner earlier before he left. And I'm sorry for interrupting you while you were speaking, because that's what held me up, and my apologies. But yeah, you know, if we could have more guys like him, you know, and that mentality trickled down to the wardens. For instance, here's the bad thing about the Federal Bureau of Prisons. A warden comes in, he only stays for 1.5 to 2 years. So he comes in, he wants to implement these new rules. Okay, we're going to change this, we're going to change that. Maybe a good guy, maybe some good rules to change. Then the next person comes in and says, no, you guys got it too good. You know, we're going to change that. So nothing ever stays the same in there. You know, as I was telling Paul, in 1992, when the Pell Grant was taken away from the Bureau of Prisons, that is pretty much the day, or I'm sorry, 95, between 90, I think it was 93, 95, the Zimmerman bill came in. And that's pretty much where I want to say, you know, the schooling and rehabilitation went out the window for the feds. And sadly enough, you know, you have inmates now, for instance, I may be a white collar criminal and I'm coming in, I know about brokers and what have you, stocks. And I can ask the warden, hey, can I teach us a class in this? And you'll say, yeah. And that's where you're going to get your certification from another inmate, because nobody's coming from the streets to do that, except I think in California is the only place where the BOP benefits because of the state, what they offer. But other than that, there is no rehabilitation in the Bureau of Prisons, Federal Bureau of Prisons. I can tell you that right now. And I've taken many of classes, you know, but those were just pretty much self-taught classes that were taught by other inmates and what have you, and, you know, to keep myself busy. But yeah.
Paul, what do you think people need to know?
I'd say the big thing is the, you know, pretty much the lack of accountability is the part that that's always gotten me. I mean, that's been one of my things for 30 plus years. You know, like there's one of the things when, you know, I was hearing you did the earlier presentation about the probation officer sexually assaulting the probationers. I mean, part of me as a taxpayer, just as anyone who like actually pays taxes or who has a job, the idea like, okay, so someone's showing up at their job and they're viewing it as sexually assaulting the people they're supposed to be supervising while being paid on our nickel, views this as a normal part of the job. I mean, but the thing is, this is super common, and it's not just in the sexual assault context. I mean, you know, as someone who's been covering this stuff for years, it's been like, you know, it seems like a huge percentage of staff at like women's prisons seem to think that, raping the women prisoners, that's just a job perk, that goes up there with getting your uniforms ironed in the prison dry cleaner shop for free, or getting free haircuts from the prison barber. But it permeates just everything, from the lack of medical care, in Washington as it is in most states. So that's one of the things. The one gentleman talking about, the prison medical care and doing the suicide cases. And generally doctors have to be licensed. There's an exception to that. You don't have to be licensed if you're working for the government. So the Bureau of Prisons and the Veterans Administration and the military are huge dumping grounds for unlicensed physicians. So are state prisons. And in Washington, it's very common for doctors who sexually assault their patients to have their license suspended. But then they'll suspend the suspension as long as they only treat male patients. So the only way you can have an all male patient clientele, if you're a doctor, is basically be the prison doctor in a men's prison. So I could say for several years, I had my own gynecologist. He was the prison doctor. But the thing is, like, these guys aren't like, it's not like they're good doctors with some boundary issues. They're sex predators and they're really crappy doctors. And yeah, this is why the mortality rate is so high. But it's just like this whole level of lack of accountability, where the notion is the fact that, people die, people are getting raped, people are getting killed, they're dying horrific deaths, and no one loses their job. I mean, that's part of the thing that that for 30 years or 30 plus years, from the day I went to prison, that I realized this is what's going on, and you really better not get sick in prison. That's the type of thing that's just really that's just been that's one of my pet peeves. But I think that's the thing, is that very few people outside of prison, I think, until you're having like some type of regular either personal contact, because either you're in prison or you have a loved one or someone in your immediate circle of friends or family that's doing this, or you're doing it professionally, either because you're an attorney, whether it's criminal defense, civil rights, or I'd like to think the prosecutors and the defense lawyers defending the state of affairs are also well aware of it. But this whole lack of accountability, I think that people, I don't know, I'm still outraged about it, and I've been dealing with it for 30 plus years. But you'd think that whether it's as a taxpayer, just as a human being, or you just have the innate, the sense that, people need to be held responsible and they need to be held accountable for their jobs. Very few people have jobs where if you screw things up so badly that someone dies, you're still keeping your job. And yet in prisons and jails, this is the norm. And that's one of the things that I think that if people knew about, I'd like to think if they knew, they'd be outraged. And that's why, 32 years later, I'm still doing this. So, that hasn't changed.
So same question for you, Ori. What do you think that now that you've been out for a while and talking with people again, what do you find that people don't know about what was going on with you in prison?
Well, one thing is that you really do have people in prison that are innocent, that don't get help, that may have been set up by officers on the street, and they end up getting a lot of time, and no one's helping them on their case, and their case so far gone past its appeals process. Now they can't get back in court. When Bill Clinton signed in that bill, and I think it was in '95, I think it was the anti-terrorism, the AEDPA, the Anti-Terrorism Death Penalty Act, it killed a lot of people's chances of getting out of prison, whether they're innocent or guilty. And when that bill was signed for your 2255, basically your habeas corpus, it's basically killed your habeas corpus. And you got a lot of guys in there that, more than a lot of than people think, that are innocent, actually innocent, that are still sitting in prison today that can't get no help. And they might write some law schools and ask them to look at their case, but some of those law schools might have so many petitions that they can only pick out certain ones. But I wish there was something that maybe some type of challenge to that AEDPA that would get rid of it, to allow some of these guys' cases to be reheard and seen again. And one of the things I think back to, I don't know if anyone remembers this. I think back in I think it was in the early 2000s, they stopped the death penalty in Texas and Illinois because DNA was starting to prove a lot of people innocent. And I just think about, okay, those people who DNA proved them innocent and end up getting out or getting off the death penalty. What about those people who said they was innocent and truly was innocent and was actually executed? Who's going to be held responsible for those people? You know, and those people probably cases were so messed up that people may not want to took on the case, or maybe they really just thought they was guilty. And that's the one thing that holds on to my memory, is that you actually have innocent people in prison that can't get help.
So I want to let everyone else have a chance to ask some questions. I know it's late on a Friday afternoon, but we'll go. I think we can go an extra 5 minutes or so, can't we? So let's take 15 minutes or so to take questions from the audience. Does that work for everyone?
Well, Ori's got to go, but Rudy and I think we're here the rest of the night. So
all right. Well, do you need to leave us at 4:30, Ori?
No.
Okay. All right. Well, then we're good. So let's take 15 minutes. Megan, you're there with the microphone. Please just go ahead and ask a question if you'd like.
Hi, thank you for sharing your stories and continuing to speak about them. First off, I'm actually a social worker here. I'm not an attorney, but I'm just wondering kind of what your experience with reentry was and how you guys kind of integrated, and what was one or two like biggest things needing to know about reentry.
Well, I talked to a lot of guys that have gotten out, and probably at least hundreds in the past 19 years since I've been out. I've talked to a lot of guys, and my own experience. I'd say the critical thing is, if you got a job and you got a roof over your head, you're golden, and after that, everything else just kind of flows from there. And I'd say but I think that, generally when people talk about reentry, part of the thing, one of the things that was kind of annoying was I get out of prison after 17 years and I need to get ID, and I go to the DMV and they're like, well, we need, and I had my birth certificate. My parents sent me my birth certificate. So I got that, and I got my prison ID card. Well, we don't really know that you're really Paul Wright. And it's like, call up the prison. They just let me out 5 hours ago. The ink is still wet on the ID card. They'll tell you I'm Paul Wright. And it's like, no, you need to have 6 forms of identification. And it's like, I just got out of prison for 17 years. I got a birth certificate. I got a prison ID. The warden will vouch for me. How the DOC secretary knows who I am. Call them up. And but I would say that generally the bulk of what I think a lot of people call, quote, reentry, I think after the first week or so, I think that literally those are just the problems of being poor in America. The big thing, like I say, if you have a job and you got a place to stay or a roof over your head, I think that pretty much solves your most immediate problems, and everything else that flows after that is yeah, you need to get ID, but once you get that, that kind of takes care of itself. And then after that, it's just a matter of, how are you going to put food on the table and how are you going to keep a roof over your head? But that's the same problem everyone else in America has.
Ori, you want to weigh in on that? You're the most recent reentry in this group. Tell us about your experience. You're muted. We can't hear you.
You're on mute, Ori.
Do you have a mute button on your end, Ori?
Difference between the people that's out here and the inmates. I was so used to, in prison, you have a high level of respect. So, when you maybe bump into somebody, you turn around, oh, excuse me, I apologize. Or, You know what I'm saying? Stuff like that. So out here is just like, you know, a lot of people don't really have much respect for each other. And then it was basically in there, I never had to pay bills, pay my credit cards or keep track of that, or my light bill, my rent and all that. So I had to get used to that. And basically the main thing was the technology, learning how to work the phone or computer again and all that stuff. And I think I've been out 1.5 years, and I'm starting to integrate myself into society a lot better. But those were the things that really I had to get used to, especially paying the bills part, because I didn't have to pay bills in there, you know. Maybe the store man when I borrowed something from him. But yeah, that was about it right there.
Ready?
I'm going to try to share 2 quick stories with you. I've always said I could write a book on the faux pas since I've been home. Mind you, 25.7 years I've been away. I know nothing about computers at all. And when both of my sons come to pick me up, I asked them about a friend of ours because they had to drop me off at the halfway house in Chicago. And we were going to go past Belmont and Central, which was a very close friend of mine. I wanted to surprise him. He has a pizza place. And I asked my son, do you have Pete's phone number? He says, no, Pops, I don't. I said, well, let me get your phone, and I'll get through information. I don't tell him to just give me the phone. And so I dial 411. So the operator comes on, and I said, yeah, Pete's Pizzeria on Central. And my son looks back, goes, Pops, what are you doing? I said, I'm calling 411 information. He goes, Google it. I said, Google? He says, yeah, watch. He says, look. I knew nothing about Google. And that's the God's honest truth. And he punched up the map, and the map came up, and there's the beat. Look at this. But another story. So I get to the halfway house, and then they give you a debit card for whatever money I had in the institution. When I left, they put it on a debit card. And the following day, the halfway house said, okay, you can go get a phone, but you can't have a camera on it. It has to be a flip phone. So I have no cash on me. And the halfway house is on Chicago and Holman or whatever division, Chicago and Kedzie, very rough area, you know. And I know the area well, and there's a bunch of brothers and sisters there. And so I go to it's a plaza, and the card says the ATM, it's ATM. And the door is locked, but it says it's supposed to be open from 7 to 10 or whatever, but it's not opening. And I'm like, oh, why is it not opening? There's 2 ATM machines in there. Here comes this woman. She's looking at me. So I back away, and then she slides her ATM card and the door opens. I was like, oh. So it closes. Now I get the ATM card and it opens. Now she's looking at me, and she's doing this with her ATM. So I come up next to her, and now I'm trying to watch her. I'm not watching her for her PIN number. I'm just like, what am I supposed to do here? So I put the card in everything she does, and I'm like, oh, it's right, the PIN number. And I put the PIN number in, and then it comes up, withdraw. And okay, so I want to withdraw $75, right? So I press $75, and it's saying, no, it can't be $75. It has to be whatever, increments of 10. But I don't realize that, and I keep doing it. She says, do you need some help? And I'm like, yeah, I'm trying to get $75. She goes, no, you can only get, 20, 40, 60, 80. I said, but I want $75. It's my money. And now here's a line outside the door, and these people want to come in, and here, me and her were having this conversation. But why can I get $75? I want a $5 bill. And she's like, no, baby, you can't do that. It's either got to be 80 or 100. I'm like, I'm so frustrated. Now, mind you, I suffer from anxiety even now. And I was going to talk to you about that. I saw the case that you put up there. So I said, I'm so frustrated. I said, just $80 then, I'll get the 80, I get my cash. And she's the first one out. And everybody's there, they're all bitchy though. Hey, what's taking you so long? And I tell her, I said, listen, I'm so sorry. I said, I'm just coming home. I've been away for 25 years. I tell her this inside there. So then when she comes out, she goes, why don't you all shut up? This man been away for 25 years. And they're like, oh, my man, welcome home. And that's what I love about the west side of Chicago, because, they can relate. They can relate. But yeah, that's been my experience.
Anyone else?
Thank the three of you for sharing and Professor Sisk for hosting this symposium. So I do criminal defense work, and I think both at the trial court level and at the appellate level, it's you face a lot of defeat. It's difficult work, and it can be frustrating at times. And from hearing other stories from the panelists, you know, prisoners' rights work is it sounds like very similar experiences. Hearing about not only the conditions in the prisons, but seeing some of the, you know, the graphic videos and the images that we've seen today, hearing your stories about violence you face in the yard, sexual assault from prison staff, even from probation officers. I'd like to hear from each of you, and particularly from you, Rudy, facing a life sentence. What is it, even being in those conditions, what is it that kept you going and, you know, gave you this positive attitude to not just, I guess, succumb to being stuck there and resorting to, you know, violence or drug use, whatever it is, but what kept that positive outlook and kept you going?
My sons, my two boys. So they were 4 and 5 years old when I left, on the cusp of their birthdays. So excuse me, but yeah. So I mean, I've been placed in different, you know, predicaments where I would have to hurt somebody, and I knew if I did this, you know, that I would never see them ever. And that's what made me a good politician in the joint. You know, let's talk about it, let's straighten it out. You know, and a lot of guys that respected me and follow me, sometimes they would think, man, you know, this ain't the route to go. You know, this is what we got to do. No, we don't. There's other avenues. You know, if we're wrong, we're wrong. If we're, you know, we have to accept the fact that we're wrong. You know, and if they're right, you know, it is what it is. But yeah, for me, it's been my son, my two boys. Those are the ones that, you know, kept me focused, for sure. Yeah.
I say one of the things that I'm a big proponent of determinate sentencing. And I think, you know, one of the biggest outrages that we have are parole systems or discretionary parole, which it's largely a thing of the past now, which I think is probably a good thing. But I knew that when I was sentenced to 304 months, I knew that pretty much within a couple of days, I knew when I was getting out. And I had like 8 years of good time to play with there. And, you know, I didn't lose any that I didn't get back. So, you know, on the one hand, that's good. So, you know, I think that knowing that there's an end, there's an end in sight. You know, it's a long way out, but, you know, I was 21 years old when I was sentenced to 25 years and 4 months in prison. And at that point, it's just such a long amount of time that, you know, it's kind of, I think, especially when you're 21 years old. Just before I left, just before I left my office on Wednesday to get ready to come here, one of my employees, he took yesterday and today off and to celebrate his birthday. And I asked him, you know, how old are you going to be? He said 23. And I said, oh, you're doing pretty good. And he says, yeah, you know, I think, you know, everything's good. I said, well, look at it this way. When I was your age, I was 18 months into a life sentence. So, you know, working at the Human Rights Defense Center isn't the worst thing that could happen in your life. So, you know, but I think that's for me, is one of the things is, you know, knowing that there's an end. And I think that one of the things was also the biggest thing was, I think, you know, starting out in prison, I think that, you know, you worry about getting killed or, you know, or getting stabbed or whatever. And then after a couple of years, I realized that if anything was going to kill me, it was going to be bad medical care. So then it's like, whatever you do, don't get sick in here. And it's like, you know, basketball, after I saw the first guy, you know, break his ankle and then go out for medical treatment and they killed him. It's like, okay, we're not playing basketball anymore. And, you know, that's just a risk mitigation thing. And so I think that's, you know, one of the things I'll have to say is, I can't and won't speak for anyone else, but it sounds crazy, but at least for me, like the 17-year sentence actually went by fast, but then I feel like life goes by fast. Like, and that's one of those things I think, maybe if, you have stuff going on and you're doing things, like I always felt in prison and out, I feel like I don't have enough time to do all the things I want to do. And I've also come to the conclusion time is our most valuable asset. It's the one thing that we have. And once it's gone, you're never getting it back. And so, that's why my thing is, try to use your time wisely because you only have so much of it.
So Ore, you're going to get the last word on this. What gave you hope? What kept you going? What gives you hope and keeps you going today?
Well, when I first went to and got in the federal system, I had to look at myself in the mirror and I had to make a decision as to am I going to continue down this path that led me here, or was I going to actually change? So I made a decision that I was going to do everything I can to change, and I wasn't going to let anything around me affect my mission to change myself. And I wrote down everything that I wanted to do, that I wanted to achieve from the time I was incarcerated all the way till my release date. And for the most part, I achieved all that. But as I explained in some of the stories that happened to me while I was in there, a person could lose hope quick, but I stayed positive because I had tunnel vision. And that tunnel vision was that I needed to change. And as one thing that really helped me was that when I talk to other inmates and I try to influence them to do the right thing and to change their life, that's what gave me hope and made me happy. Now, some of those guys, it went through one ear and out the other, but some of those guys took my word serious and changed some of their life. And when I started learning the law and became good at it and started fighting some of those guys' cases and watching those guys walk out the door, that further gave me hope that I can do something good besides going out there and committing crimes and doing stuff like that. I could do something on a positive level. And like I said, for the most part, I achieved my objective. And even while I'm out here today, I talk to some of those guys who are still incarcerated, and I still try to encourage them that, like I used to tell my cellie all the time, because he had 3 life sentences, and I used to tell him that one of these days that the door is going to open. You just got to recognize when that time comes and reach out and grab it, because just because they gave you 3 life sentences don't mean that you're going to be in here forever. You just got to stay positive. And when you see other people stay positive, keep you positive, even around negative situations. So that's basically how I was. I just try to stay positive and try to uplift everybody else around me. When you uplift people around you, you stay uplifted. So that's how I try to live my life out here too. So
but before we leave you, Ore, I think do you have someone there with you that you would like to introduce to us as well?
Oh, this is my fiance, Anna Lynn. Here she comes. She likes to be seen, so she's trying to get in the camera a little bit. She got to fix her hair.
Well, that's fair.
Hello.
Well, congratulations.
Thank you.
And she keeps me uplifted too. So she's a real good, positive person, good person. So, I'm happy that she decided that she want to marry a person like me. So
she's very fortunate. She picked a great guy.
I appreciate it.
That brings us to the end of our symposium for today. So thank you all so much for being here. Please don't let this be the end of your exposure to these issues. The Law Journal will be publishing remarks or articles from all of those who presented today. It takes a while for that process to take place, so it may be late 2022, early 2023 before that's all available, but I ask you to look for that. And once again, thank you so much to all of you who participated. For those of you who are academics, we go to symposia a lot. And if you're like me, usually by the second speaker, my mind is already starting to wander as I think about what am I going to do in class tomorrow, where am I going to go for dinner tonight. Not today. Today, my attention was riveted the entire time, and I know yours was too. So a round of applause, please, if you would, for all of our participants. And that does bring us to an end. For those of you who were participants and spoke, if you would like to join the University of St. Thomas Law faculty upstairs in the faculty lounge, there's a reception. Do not feel obliged to do that. I'm going to go for a while and then I'm going to go take a nap. And so if you would like to do the same, feel free to do that. And again, thank you all.